Yes. What do you think? What is it? We accordingly affirm the said conclusion, albeit on different grounds as discussed above than those attributed by the learned single judge. Accordingly, APOT 415 of 24 along with the GA are dismissed on contest, thereby affirming the impugned judgment and order dated November 13, 2024, no orders to cost.
For the appellant's ballot. There are notes of argument.
So filing notes of argument.
Oh, yes.
Lord, before my lord, I filed my written notes of submission.
Yes.
My lord, lordship, I is seeking a lordship's pardon, my lord. Lord, I have added one paragraph, my lord, in my written notes of submission, my lord, which I had not argued, my lord. I'll just indicate why, my lord. Lordship will recollect, my lord, when Mr. Mitra, my lord, learned senior counsel, my lord, while he was concluding his submission in response, my lord, to the judgment, my lord, trying to distinguish Sukanya holding judgment, my lord, submitting that, my lord, that was in the pre-amendment era, and my lord, Sukanya holding is no longer a good law, my lord. Lord, very recently, my lord, Honorable Supreme Court, if Lordship can.
No, new judgment. I can.
Recent judgment, only one paragraph.
Then we have to give them a hearing.
Yes, I'm giving just one paragraph.
You should have informed them previously. Why today now in court? Mr. Jain, you should have informed them previously.
That's my mistake. No, that's why my lord, I was seeking.
We'll keep it on the next Wednesday then for hearing on that. If you want to add a judgment, yes. You are for the?
I am for the respondent number 1, my lord.
Learned counsel for the respondent number 1, comma, at the time of filing written notes of arguments.
My lord will permit, my lord, I'll just omit that part, my lord. If lordship.
No, let it be there. It's a judgment. Comma, seeks to rely on a recent judgment of the Supreme Court. Pushed up, since the said judgment was not cited at the time of oral arguments, comma, in order to afford the other parties to give an opportunity to respond to the same, comma, let the matter stand adjourned till March 5, 2025, when it will be listed under the same heading. Pushed up, the written notes of arguments filed by all the parties today be kept on record. File those written notes of arguments. Only on the response, we are keeping it till next.
But let the
Lord, I'll just head over.
Yes, please just give at least the citation.
Yes.
For the appellate.
Lord, may I hand over the citation as well? For
Yes. Have you written on your written notes of arguments for whom it is being filed? Sometimes it's missed out.
In my lord, I have indicated, my lord.
দেখে নিতে সবকটা আছে কিনা কার written notes of argument. অনেক সময় থাকে না, আমরা বুঝতে পারি না, খুব অসুবিধা।
Fact sheet আছে আমারটা। Respondent number 1, Yamini Ma'am.
উপরে লেখা নেই? যাদেরটা লেখা নেই তাদের ফেরত দিয়ে দিন, ওটা লিখে দিতে বলুন।
We have written.
We have also written.
কে লেখেনি দেখে নিন। হ্যাঁ, সেটা লিখে দিন। রাজীব জন। আর বাকিগুলো সব লেখা আছে তো রিটেন নোটসে, কি কার কে ফাইল করছে? রেসপন্ডেন্ট 1 ওটা রেসপন্ড। Very, thank you.
Great one. I'm sorry, my lord.
No, sir. Wait. লিস্ট দিন, লিস্ট ওটা দিন, ততক্ষণ সইটা করি। করতে করতে লিস্টটা দিন, যেটা সই করতে দিচ্ছিলেন সেটা দিয়ে তো দেবে। ওই ক্যালেন্ডারটা ঘুরিয়ে দিন তো অনিন্দিতা। থ্যাংক ইউ। Anyway. Yes, Mr. Application? Yes.
Application. My lord, this is an application, recalling application of the order.
Hand over.
My lord, this is most urgent, my lord.
We
Friday is the date for bailiff report.
Maybe. Whenever the file comes, it will be given. Yes.
The ghost is led by me, my lord.
Yes.
Pursuant to your lordship's direction, on 9th of January, have given the requisites and it has been duly submitted.
It will
And
appear as to be mentioned there.
Yes, it is or to be mentioned or let the direction of filing paper books may be passed. My lord.
That can be done only if it appears in the list.
Yes.
It will appear as to be mentioned. Just give the caption to be mentioned.
Good.
Yes,
Hospital has been wrongly filed. The automatic is to be mentioned.
to be mentioned. To be mentioned. To be mentioned. We give. Yes.
My lord, Friday is the day for bailiff.
You don't understand. Whenever the file comes, we give it in the list.
My lord,
Whenever the file comes, we cannot give it before the file comes.
position will take a-
Thank you very much. Yes, call on the
I'm
list.
grateful to your lord.
My lord,
মোটা মাথা কিছু ঢোকে না?
my lord, may I just mention one matter?
Yes.
This is a first appeal, my lord. It's ready
First
for
step hearing we are not taking.
ready for hearing.
No, sorry.
There is an injunction application in affirmative.
Yes.
Lordship, may I be permitted to answer a matter?
Application.
Lordship, the matter
Yes.
is completely ready for hearing, Lordship.
No. Call on next. Yes.
Lordship, I'm for the petitioner. I'm for the petitioner, Lordship.
Oh, the deficit court fee has to be accepted. We find from the report of the office dated February 19, 2025 that the deficit court fees have been paid but beyond time. Full stop. Such deficit court fees be accepted and the defect in that regard be deemed to stand cured. দেরি করে deficit.
Item number 2, I'll press for not to take additional.
যদি পরের ফাইলটা রেডি রাখুন. Yes, yes. Item 2. Item 3 দেখাচ্ছে না কেন বোর্ডে? এটা কত নম্বর আইটেম? এটা 2. 2, why is it appearing as Lojima? What were you to do? You have not put in the requisites. Why? Yes, come or not come is immaterial. We'll put it as final orders if you don't deposit. Let us office report টা বার করে দিন তো। কিসের বেসিসে লজিমা এসেছে? Thank you. এটা আমাদের কাছে প্লেস করছে কেন? সার্ভিস রিপোর্ট এখন আসেনি।
Service report has it.
এক মাসের উপর হয়ে গেছে বলে হয়তো নতুন তার ফেস ডিউ। Please inform him, we'll direct him, the appellant to deposit fresh requisites within a fortnight. We'll give you a fortnight. It appears from the office report that all the notices of appeal were issued on January 13, 2025, no service report has yet been received. Full stop. Accordingly, the appellant is directed to put in fresh requisites for service of notice of appeal on the respondent numbers 1 to 4 within a fortnight from date. Full stop. The office shall furnish a further report as and when any further development occurs in that regard. Within a fortnight, please put in fresh requisites. Put ready করে রাখুন. Yes, Mr. Das, what is the matter? Yes.
My lord, it is an application for.
Mr. Das, this is appearing for the first time or you have served?
My lord, I appear.
Yeah.
Yeah. Oh, yes.
As per your lordship direction, I have served.
Yes, Mr. Das, what is the matter?
Well, the matter is that by the restoration application.
Section 5?
Section 5, there is a delay of 4 or 5 years.
Section 5 in filing the restoration? 4 or 5?
Yes.
What is the explanation?
Explanation I have given, my lord. Kindly come to my application first.
No, there is
Petitioner
there's a substitution application also.
Yes, that is previously.
That was allowed.
That is allowed. Everything was completed. The name of the appellant number 2 was also deleted. Well,
So-
be that as
No, no, what is the, let us find the application first. What is the application number, the original?
Application 5 and 6. 5 is for
Five.
restoration, and 6 is for condonation of delay. My lord, what happens, my lord, before the corona period, my lord, on 3rd December 2019, the matter appeared in the list. My lord, I missed the list. And it really escaped from the notice and the matter was dismissed. My lord, your lordship knows, my lord, after that, my lord, corona period started from March 2020.
When was it dismissed for default?
3rd March to 2009, 3rd December.
3rd December?
2019.
3rd December 2019, yes.
Well, the
Corona period started 3 months thereafter.
yes, well, we do not know. I do not. I
Acha.
missed
Then-
the list. Therefore,
what
my
happened?
lord,
How did you
there-
come to know ultimately?
ultimately the son of the petitioner came to the Honorable High Court to take know the fate of the case, and from that I came to know.
Therefore, Mr. Das, for all over these years, the son could
Petition-
have come.
No, petitioner number 1 that I have explained in the
Mr.
petitioner
Das,
1 is looking at the case all after. Well,
then why did his son come? What was the occasion for his son to come?
Well, because he got rumors from the locality, my lord, that
Where have you stated that?
I have stated. The wife of the petitioner number 1 died. Well, before,
Wife died, yes.
yes, my lord, he was at a mental loss and he
Mental
was,
loss for how many years?
my lord,
Wife died on 28th of April 2020.
20.
We lived the entire corona period, pandemic period.
Yes,
At the end of 2021, he must have gotten over that shock
he was not in a condition, my lord, kindly see,
for over 1 year.
my lord. He was totally bedridden under doctor prescription.
For how long?
Well, for last February till now.
If till now he is not in a position to come, then why didn't his son come at that relevant point of
Well,
time?
because he got the rumors from the
Where that?
that the deponent.
Nothing stated here.
Para 5.
When you got the rumors from the locality?
That the deponent hearing got rumors.
How did the people in the locality know about the dismissal of the appeal when you did not know?
No, because it is the respondent, my lord, who disclosed in the village.
They live in the
area,
same
my lord.
premises.
My lord. And my lord, not only that, my lord, there were talk of settlement. Even after that, even after the dismissal, talk of settlement between the petitioner.
Yes, what do you say?
My lord, the delay of the explanation of the delay has not been properly explained. And number of days, how long it has been, my lord, the delay, it has not been mentioned anywhere in this application.
Not mentioning the number of days is not fatal, but they have stated that they got to know the wife died
Wife
and
also that there is paragraph 6, they have been taking the point that talk of settlement
Yes,
continues.
that
There
is.
is
what
a-
about that?
Talk out my regarding the property, there is a talk of settlement. This is, my lord, the suit property is
If there was a talk of settlement, then they would not anticipate that it has been dismissed.
Entirely my fault, my lord, I missed the list. Because now, my lord, there are all
Initially
the,
your fault, but thereafter your client had to take note.
my lord, nowadays, my lord, in the mobile phone, I got the list. But at that time, my lord, it was not started, my lord. And you lost it
The
back-
suit arises out of what?
My lord, arises out of, my lord, I got the degree with the trial court. Thereafter, he filed a suit against challenging the
Mr. Das, you have to pay costs to him.
fraud and practice before.
Cost to him. You choose between 30,000 and 50,000.
my lord, kindly,
20,000 at least.
kindly, my lord.
No. There
Well,
should be some data. No.
My lord, kindly have some
The-
mercy, my lord.
Can 6 of 2024 has been filed for condonation of delay in filing Can 5 of 2024, comma, the latter being a restoration application. Who's sub next para? Learned counsel for the appellant submits that the matter got dismissed for default on December 3, 2019. Full stop. It is submitted that the learned advocate appearing for the appellants had missed out the matter in the list. Full stop. Thereafter, on April 28, 2020, the wife of the appellant number 1, comma, who had been all along looking after the case, comma, died, comma, upon which the appellant number 1 suffered from serious mental depression for which he is still bedridden. Full stop. Next para. Later on, comma, the appellants came to know from rumors in the locality, comma, where the respondents also live, comma, that the appeal had been dismissed, and thereafter the son of the appellant number 1, comma, the present deponent, comma, came to the court and learnt about the dismissal. Full stop. It is further submitted that a talk of settlement continued for several months even after the dismissal for default, and there was an assurance on the part of the respondents that the matter would likely to be settled, which was another reason why the appellants had not taken information in the meantime about the appeal. Who's up next para? Learned counsel appearing for the respondents submits that proper explanation of the delay has not been furnished. Full stop. Moreover, the period of delay has not been mentioned. Full stop. Next para. Although learned counsel for the respondents, in his usual fairness, submits on instruction that talks of settlement were going on between the parties, however, it is submitted that the prolonged delay of several years in filing the present application ought not to be condoned. Full stop. Upon a careful perusal of the averments made in the application, we find that there is some justification in the appellant not taking information of the matter in the meantime in view of talks of settlement going on between the parties. Furthermore, the period during the pandemic restrictions ought also to be uh, uh, deducted as per the several orders of the Supreme Court in that regard. Full stop. Next para. On an overall consideration of the averments made in the application, we find that sufficient cause has been made out for condonation of the delay in filing the restoration application, as well as for restoring the appeal to its original file and number. Full stop. However, due to the suffering of the respondents for the condonation of delay and the restoration of the appeal after so many years, the respondents ought to be compensated by costs. Full stop. Accordingly, Can 6 of 2024 is allowed, thereby condoning the delay in filing Can 5 of 2024. Full stop. Can 5 of 2024 is also allowed on contest, thereby recalling the order dated December 3, 2019, whereby SA number 85 of 2018 had been dismissed for default and restoring the said second appeal to its original file and number, subject to costs of rupees 20,000 being paid by the
I'm
appellant
not bargaining, my lord.
to the respondents within a fortnight from date. Full stop. Next para. It is made clear that in default of such payment, the above order shall stand automatically recalled.
My lord, I'm not bargaining, my lord. Finally have some.
No, no.
Finally,
No, sir.
finally have some.
No.
Then, my lord, these are 2 weeks, my lord.
2 weeks, 2 weeks. Next. Yes. Five to read.
An application for restoration
Restoration.
dismissed in Lojima. Solovana cost was not put in time, my lord. Service, my lord.
Mr. Mahato, when was it dismissed?
It was dismissed of 8th of March 2022. At page 7, my lord, the order is here.
What was the defect? Only Talavana? Rupees 5.
I have stated in page 4, paragraph 5.
So when did you file the application? In time? What is the delay?
I have not prayed for any delay.
Restoration application,
Only restoration application, my lord.
even restoration, then 30 days applies. You have to explain the delay. When did you file the application? After 5 years?
My lord,
2024,
2020.
5 years. In the absence of any explanation for the delay, we cannot.
Not this week.
You can file a supplementary affidavit. We will take that on look. The appeal had been, the appeal and the connected, the appeal had been dismissed for non-compliance of the court's order by an order dated March 8, 2022. Full stop. However, we find that Can 4 of 2024 does not plead any reason for the prolonged delay in filing the same. Full stop. Next para. On the prayer of learned counsel for the appellant stroke petitioner, the appellant stroke petitioner is granted leave to file a supplementary affidavit to explain the delay in preferring the application. Full stop. Accordingly, let the matter stand adjourned till March 10, 2025, when the application shall be listed under the same heading. Full stop. In the meantime, the learned advocate, the appellant stroke petitioner shall serve a copy of the restoration application along with an advance copy of the supplementary affidavit proposed to be used by the appellant to the respondents, indicating the next returnable date, and file an affidavit of charges to that effect on the next date.
For restoration application, I have served.
আচ্ছা তাহলে ওটা যেটা বললাম if not already served.
Only the supplementary affidavit is
We have
required.
put in if not already served. If you have served that, then only this. Yes.
This is an application for amendment of the cost title. Now the appellant before is the LLP is designated partner who was representing the LLP has since expired. We have annexed the copy of a death certificate, and the amendment is to the effect that his son, who is now designated partner, be incorporated in his place instead.
The agreement contemplates such a substitution.
So yes, there are two LLPs.
So this is basically under Order 20 Rule 10 in a sense. Because interest has,
Why I say
he does not claim as an heir, he is a partner of the LLP.
the LLP has an independent existence. So the plaint as it was filed contained this averment, represented by such and such. Even if it hadn't been there, it wouldn't have been made much of a difference. This is a
Yes,
legal entity.
exactly. He does not come in as an heir. He comes in as a new partner.
Yes, LLP.
So
there is no
then
problem.
also it's Order 20 Rule 10.
But the appellant is the LLP. Now it has got an independent existence. So whether
So not even Order 22. Who has died and who has come in?
Rajendra Prasad, who is the LLP, the
Partner.
partner, the designated partner of
He comes in now.
No, he was the initially. Now Aditya comes in. Prayer is at page 7.
Yes, we are allowing them in. The present application is an application, is one for amendment of the cause title of the Memorandum of Appeal
As well as the application.
as well as the connected pending application. Push up next para. It is submitted by learned counsel for the appellant that during pendency of the appeal, one Mr. Rajendra Prasad, one of the designated partners of the appellant LLP expired, and as per the LLP agreement, his son, Mr. Aditya Prasad is required to be incorporated in place of the said Rajendra Prasad as the designated partner. Push up next para. Accordingly, can heard learned counsel for the parties, in view of a sufficiently justified cause being made out for such amendment, can 2 of 2025 is allowed, thereby directing the name of Mr. Rajendra Prasad to be deleted from the cause title of the Memorandum of Appeal and the other pending application in connection therewith, and be substituted by the name of Mr. Aditya Prasad, son of late Rajendra Prasad. Such amendment shall be carried out to the cause titles of the memorandum and the application by the learned advocate on record for the appellant during the course of the day.
But the interim order is till 20th of February.
What was the interim order?
On the
Page 10.
page 10.
The matter is appearing as in the hearing
Hearing
list,
list.
my lord.
We'll extend it till disposal then if it's a.
Kindly
Appeal is-
explain, kindly
One of the
please-
appeal will be disposed on a very short point of
Yes, sir, the
because
short,
there's an arbitration clause and a person already filed the section 5 and 8. So this could be disposed of on a short point of law.
Who filed Section 5 and 8?
One of the defendants. It was my
What have
suit.
you challenged?
My lord, it was a suit, my lord.
Your suit?
My suit.
They are 5-8?
Yes, they are 5 and 5.
That has been allowed.
Yes, no, that has not been allowed. That is pending adjudication. 7-10 allowed.
whether it is a
Commercial
commercial
suit
suit
or
or
not.
that is the main dispute.
That's the main
The
dispute.
my
But in any
case
event,
is that it is a commercial suit, it has to be
and
sent
accordingly,
to
the learned judge in the court below found favor. Her argument found
Your
favor.
contention is that if 5-8 is allowed, that has to be taken up first.
No, my contention
You
was
agree to 5-8, to 8.
they have already filed 5-8. So there's a
They have filed. You concede to that.
we'll have to concede because there's arbitration clause.
but
We'll
that
record that
was
dispose of the appeal right now. We'll allow that and
fixed a date because I am led by Mr. Shoptangshu Basu.
Fixed a
That
date.
that point has not been argued by them. They
see,
are all,
there is a Section 8 you have filed.
yes, my
We'll
lord.
allow that application from here.
Then my lord, kindly fix it tomorrow, my lord, Mr.
Not
Basu
then my lord
will
Tuesday, my
take
lord.
this matter.
The interim order granted earlier is extended till disposal of the appeal. Full stop. Next para. Learned counsel for the appellant submits that the appeal arises from an order whereby the plaint has been returned under Order 7, Rule 10 of the Code of Civil Procedure to be filed before an appropriate court. Full stop. However, comma, there is already a subsisting application at the
Transferred to the commercial.
Commercial court. It was not returned.
আচ্ছা plaint was returned কেটে দাও it is submitted থেকে আবার শুরু করো it is submitted by learned counsel for the appellant that the suit was transferred to the concerned commercial court since it was observed by the impugned order that the civil court does not, that the ordinary civil court does not have jurisdiction in view of the dispute being commercial. Full stop. Next para. Learned counsel for the appellant further submits that there is already a subsisting application under sections 5 and 8 of the Arbitration and Conciliation Act 1996 at the behest of the defendant stroke respondents, to which the appellant is agreeable to concede, comma, since there is an existing arbitration clause in the agreement between the parties. Full stop. In such view of the matter, comma, learned counsel for the appellant submits that the appeal and the application may be disposed of together by directing by passing appropriate orders allowing the application under section 8 and referring the matter to arbitration. Full stop. Next para. Learned counsel for the respondent seeks a day's accommodation to take instructions on the same. Full stop. Accordingly, let the matter be listed under the heading to be mentioned tomorrow.
Not tomorrow, day after, some difficulty.
Under the heading to be
Tuesday,
mentioned on
Tuesday, Monday is the month list.
to be mentioned on March 4th, 2025. Full stop. It is understood that the appeal and the application shall be disposed of on the short point on the said returnable date.
I'm so grateful. And interim order is sent, not?
In the order we have already
I'm so
granted till disposal. না যদি arbitrator কাছে রেফার হয়ে যায় সব চলে যাবে
It's already on record.
wherever it goes it will go to arbitration.
I'm grateful.
That the agreement is already challenged. For such reason, it is not.
They concede, we have recorded.
The agreement containing the arbitration clause is has already been challenged before the forum. For such.
You are challenging.
Yes, man, the
You are relying on section 8 also.
Yes.
For such
Yes.
reason, the previously the matter was before that it was held that whether the arbitration is over or not. But for such reason, there already
You
the
have filed a section 8 which is still pending.
It's there, my lord. The record shows. My lord. Page
But my
432A.
instruction is that the agreement we have challenged the agreement
Should have
itself.
told this before. Anyway, you have extended it till disposal of the appeal. If you
Yeah,
find
on
that
day,
if we find that we cannot dispose it off on the short point, we'll relegate it to the appeal hearing district. Next.
I'm grateful.
In the matter, I am but the appellant petitioner, my lord.
What is the matter, Mr. Partition?
My lord, this
Suit
partition,
against appeal against partition suit preliminary degree.
no, my lord, partition suit, there is a order of injunction of status quo. My lord, I am the defendant in the suit. My lord,
This appeal has been admitted under order 41.
no, that is not
It has not been admitted.
My lord, that have not been admitted.
If it has not been admitted, why did you mention the application for inclusion in the list, Mr. Bhattacharya? Don't you know the law? Unless the appeal is admitted, how can we hear the application? And it is filed out of time. Have you filed a section 5?
Yes, my lord, section 5 is there.
Change brief mitigates that liability of yours to file a section 5. Why would you take a change before ascertaining?
Yes. Hey, application also. My lord,
What?
my lord, it's-
165 days, no less. But probably there's some further order that the appeal is preferred in time. Let us see. একটা অর্ডার বলেছি যে 16/10 রয়েছে অর্ডার শিটটা কোথায় রয়েছে অর্ডার শিট কোথায় কোনো অর্ডার হয়নি এর আগে নাকি একটা অর্ডার রেফার করেছে 16 দেখি দেখি 16/10 অর্ডারটা রয়েছে এখানে
16 order of trial court.
আচ্ছা what did it say
My lord, these were, my lord, my application on order 13 rule 4 and 151, my lord, that was, my lord, rejected.
No, this order, impugned order, is the order dated?
Order date was 16th of October 2000.
That is the impugned order, not the order dated 11th of April.
My lord, there was a partition suit. Thereafter, what has happened, my lord?
No, let them decide first which order they're challenging. You cannot challenge two orders in a single appeal. Which is the order you are challenging?
16th of October order, man. 16th of October. 16th of October 2023, man.
When did you file the appeal? Oh, you applied much after. Long delay.
You have taken an application, man.
The appeal is time barred. Full stop. Learned counsel for the appellant seeks to prefer an application for condonation of delay. Full stop. Accordingly, let the matter go out of the list with liberty to the appellant to mention the matter on notice to the respondents as and when such application for condonation is filed. Out of list. File the section 5, give a copy to them, give a notice to them, mention, we'll take up the section 5, decide it, and then take up the.
Respondent. May I file my affidavit in reply, my lord?
Yes.
This is an appeal.
Appeal has been admitted, Mr. Lahir.
Yes. Refusal of ad interim order of injunction.
No, this appeal has been admitted.
Yes. Lord has passed interim orders on my application.
All right.
And had, my lord, that it's affidavit, exchange of affidavits.
What is the impugned order in the appeal?
Impugned order in the appeal is refusal of injunction on the simple ground of delay.
Suit for?
The suit for declaration and injunction.
Declaration of title?
Right.
Your suit for declaration title, ad interim refuse or injunction?
Ad interim. This is on ad interim, my lord.
Yes, you have filed a written objection in the court, will you?
No.
File a written objection?
Yes, my lord.
We'll direct you to file within a fortnight. And then there you don't have a right of reply in the trial court. We won't give you that right. And the injunction application will be the main injunction application will be decided within because you are suffering for.
If any new facts are there, my lord, short reply.
Trial courts there is a provision for reply. There is a practice also.
Yeah.
No. 2 weeks, 1 week, we'll direct the injunction application to be decided within 6 weeks.
Fine.
And we'll continue this order because it's all you are already suffering this. And we'll say that this order will not be, the trial court will do it independently and this will not prejudice the trial.
Well, only what I am submitting, my lord.
Yes.
Matter relates to, my lord, with regard to the shares. I am claiming something, they have, but ultimately both parties are claiming that we are 50% shareholder. So let my 50% share, let there be not to pass any injunction order.
What was the injunction?
No injunction order has been passed, but
no, this court had passed injunction.
My lord has passed.
What injunction has passed? That is what we are asking.
Not to injunction from selling, transferring, alienating, dealing with the suit property in any manner.
Suit property, share in immovable property.
Immovable property. And I am not been allowed to enter into my. That he has not.
That you have to file an injunction.
That is to be so.
No, it's a joint property till now. 50%, which 50%?
It is purchased, my lord, by two separate deed of conveyance.
You cannot do that. From the same owner.
Same owner.
From
the same owner. It is
no,
being purchased
the exclusive
by our predecessors.
Listen.
My lord.
The sole owner sold the property by demarcating it to two persons.
No, there is no demarcation.
Not demarcated, but
undivided
sold as two part, my lord. He has purchased.
What is the two parts? Either demarcated or not demarcated.
He has purchased the undivided half share, and I have
undivided. Then you cannot transfer. You cannot. This order. We can dispose of the application and keep the appeal pending unnecessarily. We'll sustain this injunction order.
Will be disposed of, my lord. And the trial could be directed.
On consent of the parties, the appeal itself is taken up for hearing along with the application. Push up next para. In a suit for partition filed partitioned by meets and bounds, and as such, all the parties, being co-sharers, have equal right, title, and interest over every inch of the property. Accordingly, we are of the opinion that the learned trial judge acted illegally in refusing to grant ad interim injunction order to the plaintiff stroke appellant. Accordingly, FMAT 405 of 2024 is allowed on contest, thereby setting aside the impugned order and granting injunction, restraining the respondents from selling, transferring, alienating, encumbering, and or dealing with the suit property in any manner in favor of third parties till disposal of the temporary injunction application pending in the court below. Next para. The Can 1 of 2024 is also disposed of accordingly. Next para. The defendant stroke respondents shall file their written objection within bracket S to the temporary injunction application in the court below within a fortnight from date. Reply, if any, shall be filed within 1 week thereafter. The learned trial judge shall dispose of the temporary injunction application itself as expeditiously as possible, preferably within 6 weeks from the date of communication of this order to the said court, without being influenced in any manner by any of the observations made herein, independently and in accordance with law. No orders to cost. You have filed affidavit in opposition and reply today?
Yes, no, reply is filed today, opposition was filed.
প্রথম লাইনে একটা করে দিও, affidavit reply filed today be kept on record. আরো কাগজ আছে?
Bhutan ID.
Ninety ready করে রাখবেন আলাদা। Yes, appeal admitted.
Appeal admitted, my lord.
What is the
Application for stay in connection with the execution case. The specific performance of suit, degree to expertise.
You are enjoying an interim order?
No, it has, your lordship will find the last order passed by this honorable court where it was directed, the application will be heard. Last portion of the order, well, appeal will be heard after that, the direction for call for the records and other things.
Appeal along with the application?
No,
No,
after that,
Mr. Maiti appeared for
it is the act number.
the respondents. Mr. Wrights recorded that your learned junior appeared for the respondents in paragraph 3.
Kindly take it up tomorrow.
We dispense with formal issuance of appeal notice.
Myself and my junior both miss the
Oh,
kindly take it up tomorrow.
We'll take it up tomorrow. Mr. Rai, please come prepared because it's against an injunction order.
No, order 9 rule 13 rejected.
Come prepared, we can take up the appeal also if necessary. Agree to the appeal being taken up along with the application, we'll dispose of either way.
Then my lord, kindly keep it.
We'll keep it next week. Next week.
Then I'll pass an order so that
We'll pass an order to that appeal. In view of the short ambit of the appeal, and since the respondents are already represented through counsel and service of notice has been dispensed with, we also dispense with calling for the trial court records and preparation of formal paper books. The appeal along with the application shall be decided on the basis of the papers already before us. For such purpose, let the matter be listed under the same heading on March 5, 2025, after a week. It will appear under the heading application, but understanding is will take.
careful till lordship.
Lord, I am a appellant, my lord.
What is the appeal against?
Appeal against eviction, my lord. A decree of eviction, my lord.
Eviction on what? I mean, under the Premises Tenancy Act?
No, my lord. Under TPA.
TPA. 106 notice.
106, my lord.
This is appearing for the first time.
First time, my lord.
What is your prima facie case? 106 notice, there is no defense practically.
My lord, my humble submission is that there was a lease agreement. And that lease agreement was for 11 months. And lease agreement already written that only for 11 months. And there is a clause of extending that period. Another 11 months. But what they had done, not extended, but it is renewed on the same documents, my lord. That is my before your lordship challenge. There is several, your lordship knows, my lord, there is several judgments, my lord, renewal and extension, my lord.
What is the difference if a 106 notice is given?
106 notice is given only for the defaulting ground and reasonable requirement. And
106 does not require any ground. 15 days notice, you are out.
notice has been given.
106 notice does not require
Yes,
any ground.
But my
106 notice, if that notice has been, service has been proved, that is sufficient.
lordship.
Then you have no ground. Why prima facie case? Why should you grant stay unnecessarily?
My humble service. The only kindly look at the agreement, my lord, lease agreement.
Whatever may be the, please look, transfer property act. Have you got a transfer property act?
Yes,
Any copy? Please come to section 106.
No, we have.
We have for yourself.
Yes.
Take our copy. Eta din to. Please look at 106 subsection 1. This is a month-to-month notice admittedly.
Lordship.
See the last part of it. Terminable by a 15 days notice. They have given you a notice, you have received, you are gone.
Yes. Notice has been given, my lord.
Then no defense. 106 notice, no defense. Agreement or not agreement, even admitting that they admit that there was a tenancy. Even a subsisting tenancy without citing any ground of breach can be terminated under 106 with a 15 days notice. You have no defense in this suit. Why should you, if it was a second appeal, we would be dismissing. But here we have the stay application, we are rejecting stay. You don't have a prima facie case. Stay is not a matter of course. Those days are over.
Lordship. But agreement,
So those have created so many pendencies.
Lordship.
Not unnecessarily. If you have a slightest point, we'll definitely grant you stay. What is the point here? Here you don't have any slightest point.
106 notice has been given.
Yes.
On the basis of lease agreement.
Yes. You read out loudly 106 subsection 1, please.
In the absence of a contract or local law or usage in the contrary, a lease of immovable property for agricultural or manufacturing purpose shall be deemed to be a lease from year to year, terminable on the part of either lessor or lessee by 6 months notice.
Read after that.
And a lease of immovable property for any other purpose shall be deemed to be a lease for month to month, terminable on the part of either lessor or lessee by 15 days notice.
That has been given, you have received, gone. What remains?
Give me a chance.
We are giving you the chance. This is the chance you have.
Agreement, kindly look at it. Agreement.
Yes. Let us see the agreement. Please give back that book to us.
Yes.
Yes. Agreement, yes. As per the agreement, it's a monthly tenure. The rent is payable monthly.
Monthly.
Tenure is 11 months, monthly payments. So it's a monthly tenancy. You have given a reply to the notice.
Yes.
The service of notice is admitted. In that notice reply, you have admitted landlord-tenant relationship. Nothing remains. Sorry.
But kindly look at my lord.
Yes.
Agreement itself.
Page.
Page. 82, my lord. 82.
82. Yes.
Your lordship kindly come to page 84, my lord.
84, clause 14.
14, my lord. After expiry of the 11th months of the said tenancy period shall be extended another period of 11 months, and in that case the rent shall be enhanced at the rate of 10% may be negotiable and shall process continued for another 11 month period.
This previous 11 months had expired.
expired.
They have renewed the tenancy.
They have renewed the license for another 11 months after.
Don't say license, tenancy.
Lordship.
If you say license, you are in any event gone.
Not
Not license, tenancy was renewed for another 11 months.
11 months.
We proceed on the premise that it's a subsisting tenancy. It was renewed.
My lord, it was renewed after 12 months, my lord. Date was.
Whichever way you look at it, whether there was a renewal of this tenancy or the tenancy was subsisting. A subsisting tenancy can be terminated by a 15 days notice.
Lordship.
That has been done here. You have admitted, you have given a reply to that notice. There you have admitted the landlord-tenant relationship. Nothing remains in your appeal. We will dismiss the appeal itself. Why not?
My lord, kindly. They renewed the license after 12 months. My lord. After
So
12
what? Not licensed tenancy.
But when registration is required, my lord, that was not registered agreement.
Exactly. If it was not a registered agreement, then monthly tenancy is deemed to be a monthly tenancy under the Transfer Property Act. If it's not a registered document, it's deemed to be a monthly tenancy. Tenancy is created all the same. We are speaking in your favor. That tenancy was created.
Lordship.
Proceeding on that premise, the suit was filed that there is a subsisting tenancy and they have given a notice. Finding of the court is very clear. There is nothing in there.
Lordship.
Sorry. The present appeal has been preferred against a judgment and decree of eviction on the ground of notice under section 106 of the Transfer Property Act 1882. Push sub next para. The application, the learned counsel for the appellant submits that although there was a clause for renewal of the written tenancy agreement after 11 months, comma, the renewal was granted after 12 months. Full sub next para. However, comma, even proceeding on the premise that there was a subsisting tenancy of the appellant under the respondent, comma, we find from the impugned judgment and decree of the court below that it was observed that on perusal of rent agreement, which was marked as Exhibit 5, it appeared that there was an agreement between the plaintiff and defendant on August 29, 2018, by which the defendant was inducted as tenant by the plaintiff. Pushed up from Exhibit 8, comma, it was observed, comma, which was a reply given by the defendant to the plaintiff in respect of notice served under Section 106 of the Transfer Property Act upon him, comma, the defendant admitted the landlord-tenant relationship in between him and the plaintiff. Push up, even today, comma, it is argued before us on behalf of the defendant appellant that there was a subsisting tenancy agreement between the two. Push up, the language of section 106 within bracket 1 is clear. Full stop, if a notice is given, if a 15 days notice is given, comma, the tenancy is terminable even without citing any other ground for forfeiture of lease. Push up next para. In the present case, comma, Exhibit 8 was considered by the trial court, from which it is evident that the defendant appellant gave a reply to the notice under section 106 of the Transfer Property Act, which presupposes that the said notice was properly served on the defendant stroke appellant, and in the said notice, comma, landlord-tenant relationship was admitted between the parties. Pushed up, in such view of the matter, comma, we do not find any illegality whatsoever in the impugned judgment and decree. Pushed up, therefore, comma, no prima facie case for grant of stay has been made out. Stop. Accordingly, can 1 of 2025 is dismissed without any order as to cost, comma, thereby refusing stay of the operation of the impugned decree. Pushed up, it will be open to the respondent stroke decree holder to proceed with the execution of the impugned decree. Pushed up, do you want to press the appeal? Then we'll direct you to put in requisites for service of notice. The appeal will be kept.
Yes, ma'am.
But you have refused stay.
Proceed the appeal, my lord.
Well, the appellant shall deposit postal requisites, for service of notice of appeal on the respondent within a week from date. Pushed up, the trial court records be called by special messenger at the cost of the appellant, comma, upon retaining a skeletal record for the purpose of execution, comma, such costs, which costs shall be deposited by the appellant also within a week from date. Pushed up, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Get to
Yes, Mr. Gupta, what is the matter?
Well, this is my application for extension of the model now.
By application, it expired in the meantime. How long back did it expire?
It was filed prior to the expiry of the.
It was filed prior to.
It expired on 15th of
Why section 5? Section 5 has been allowed.
This is another for acceptance.
This has
of
been
the
allowed, section 5.
paper book model.
Can to, while your lordship's 9th January 2025, when your lordship's taken up the can 2 application stay,
Achha.
this short points involve order 12 rules is that's why your lordship directed that informal paper will be filed
Yes.
and the main matter shall be heard along with this.
Paper books you have filed?
No,
Yes, ma'am.
they have.
Yeah, it has been filed
Okay,
after
fine.
time.
Yes.
That is my can for acceptance.
Order
Paper book filed out of
I
time.
think that's some time required, my lord. Because this has been fixed for hearing before your lordship's on 27th January 2025.
No,
Some
can,
action-
can 4 is for
Acceptance
That's-
of paper book
well,
filed
can
out of time.
upon hearing learned counsel for the parties, can 4 of 2025 is allowed, thereby accepting the paper books which have been filed late by the appellant. Full stop, next para. As per previous, what is the extension application? Can?
It's the retrieve order of the stay mark.
Which can?
Can 3.
Can 3 of 2025 is an application for extension of the interim order granted earlier, full stop. Upon hearing learned counsel for the parties, we extend the interim order till May 31, till June 30, 2025 or until further order, whichever is earlier, full stop. The appeal, in view of the short point involved, the appeal along with the application shall be listed for hearing in the monthly list of March 2025. Next week. Thank you.
Is there any required to file short opposition to this stay application?
We won't look into new documents. If everything is annexed to the paper books, we'll decide on the paper. We'll decide the appeal itself.
Item number 11, my lord.
Yes, sir.
This is an application for visitation. The copy has not yet been served. So, first time this application appearing. Kindly keep it on the next week. Short possible because I could visit my daughter lastly on May 2024.
Can you serve the other side within that period? 1 week you won't be able to serve.
Kindly keep it on 10th, so that by this time.
You are very confident about the postal service. If you say we'll, but you will again pay for time on that day. We'll keep it on 10th. Let us try.
To the permanent address as also the address now she is residing because at the time of
You have given both here.
No, in the after
Presently decided. Again
present-
another third address.
Third address.
So you serve at all 3.
All
I will give you leave to incorporate that new address also now.
my lord.
And Mr. Rai, what is the impugned order against which this-
The divorce has been rejected, not granted. Ex parte. Although the wife filed an application that under order 12 rule 6 that the divorce may be
No,
granted
answer.
and custody may be order may be passed on the custody application. In spite of that,
12.6 is not applicable in matrimony. Ex parte
ex parte
dismissal of suit. The appeal arises out of an ex parte dismissal of a divorce suit filed by the appellant husband, full stop. The present application is one for visitation of the minor child of the parties by the appellant stroke father of the child. Full stop, next para. The petitioner shall serve a copy of Can 1 of 2025 on the opposite party at all her addresses as given in the cause title and file an affidavit of service to that effect on the next returnable date, full stop. On the prayer of learned counsel for the appellant, leave is granted to the learned advocate on record for the appellant to carry out the necessary correction to the cause title of the memorandum of appeal as well as the application by incorporating the current address of the respondent wife. Full stop, it is made clear that service shall be effected, as indicated above, at all the addresses, including the newly incorporated address. Full stop, next para. The application shall be listed next on March 10, 2025 for hearing.
ম্যাডাম সাইডটা দিয়ে দেবেন এখনই কারেকশন করে দিচ্ছি। হ্যাঁ
But I appear, my lord, for the defendant, my lord,
Appellant.
tenant, appellant.
What is the impugned judgment?
Impugned judgment is a decree for eviction passed in a summary suit, which starts at page 173 of the paper books. Paper books have been filed, my lord, pursuant to your lordship's
The
order,
summary suit means under which provision?
order 12, rule 6. My lord, naturally, my lord, lower court will not have, my lord, chapter 13, which is much
Yes.
broader.
Right.
Here, my lord, one has to proceed on, my lord, admission. The learned
Suit was filed for under which provision? I mean, premises
filed
tenancy.
under Premises Tenancy Act, there is a lease. My lord, there was the original lease of 1984, which expired by efflux of time. There's a further lease, which, my lord, is dated, my lord, 15th of, my lord, 11th August 1987. 11th August 1987, the lease, my lord,
11th August 1987 lease was
of the lease, the
lease.
second lease.
This
I
is an admitted position.
admitted.
Very
But I cannot, my lord, run away with it.
Right.
The, my lord, rent in question, which ultimately become initially, my lord, was, my lord, 300 rupees, is, my lord, 456.26 paisa. So this is the component of
456.26
paisa. By, my lord, escalation, my lord, it becomes, my lord, under the lease deed. That's, my lord, how, my lord, exact figures.
So you are a defaulter regarding that 26
No,
paisa?
no, no, no. I am not a defaulter at all, my lord. My lord, there was initially 2 defaults, my lord, that I have, my lord, overcome, my lord. That's
Yes.
neither here nor there.
7-2.
That I have done. Now, my lord, suit was filed in the city civil court, my lord.
What is your admission?
My lord, the admission is acceptance of the jural relationship. That is the accept. There are other points, lordship. I just frame the points and show the judgment.
No, then-
Acceptance of jural relationship.
If you accept the jural relationship, how can it automatically?
That's the how. And, my lord, there is a judgment of Prakashvati Chopra, my lord, by the division bench, which says, my lord, even if there is a prior lease, my lord, the lease is for the prior period, because lordship knows West Bengal Premises Tenancy Act, my lord, section 3 had before or after. Now, my lord, it has been amended in 2001, saying, my lord, only in respect of the lease by consent after and it's registered, my lord. That's the, my lord, 2001 amendment with retrospective effect from 2001. So, my lord, if that is so, my lord, I get a protection, my lord, under the act, because the lordship has to take the twin test in section 3. My lord, it should be, my lord, after and
Can
my
you
lord,
look
the
at the
valuation-
provision once? Yes, I have a copy. We have a copy.
I have a
Premises tenancy act একটা ওনাকে দিয়ে দিন। ওটা ওনার দিকে রেখে দিন। ও ওখানে
Your
আরেকটা
lordship, my lord, takes the
current copy
section
আছে। ওটা দিন। আরে ওনার থেকে
বলে
দিচ্ছেন
দিচ্ছি,
কেন?
বলে দিচ্ছি, দাঁড়াও, বলতে দাও আস্তে আস্তে। If your lordship, my lord, takes
Today's date fixed for application for stay hearing.
absolutely, my lord.
Yes, we are
Paper
looking at
books
the
are
prior
also,
facie case.
yes, also, my lord. Kindly have a look at. I have no dispute on. I'm not disputing. Section 3. If
Yes.
your lordship takes C, a tenancy where the lease with due consent of the tenant has been registered under the Registration Act 1908 after the commencement of the act. So after the act came into force, and the fact of such consent has been recorded in the instrument so registered.
What is missing in your case?
My lord, it's, my lord, my lord,
It's a
registration.
registered document after coming into force.
It's, my lord, prior.
Oh yes, it's
It's
prior.
prior. So, my lord, this, my lord, lordship
Does
is
not
what
apply.
was originally there. Originally, my lord, there was an exception carved, my lord. It says, my lord, I read out, lordship books must be having it, my lord.
Yes.
Any tenancy where the lease has been registered under the Registration Act, under the registration 1908, before or after the commencement. So it's a wisdom of the legislature, my lord, they have done so.
When was the suit filed?
Suit was filed in 2008. This will have a retrospective effect from 2001. The suit is 2000.
Yes.
So we go by this one, the first one. So my lease is prior, and lordship has to read, my lord, E along with that. Twin conditions have to. If, my lord, now it's very easy, my lord. If it is above 5,000 or 10,000, straight away transfer property. And, my lord, any premises let out for residential, it's a residential premises, my lord, not being a premises within the purview of clause C, which carries more than 6,500 rupees as a monthly
The rent is much less.
Rent is much. So, my lord, I'm covered under the West Bengal.
So how was it? So how was it dismissed? I mean,
My lord, if it was allowed, I say, my lord, there's a judgment of Prakashvati Chopra, my lord, which says, my lord, if the lease is continuing, even then, my lord, reading the old provision of Section 3 of the 1956 Act, it's a division bench, my lord, that, my lord, he will not get the benefit of 2G, that he will not be a tenant under the Act. But it doesn't take into consideration, my lord, or it takes, my lord, in whatever way, the effect of the amendment, my lord, which is, my lord, there.
that was in the context of 2G.
That was in context of 2G. I prefer the Order 7 Rule 11, my lord, saying that. Now, in the revisional court, now Order 7 Rule 11 is a finding on the basis of the plaint. I can always raise it.
Not only that, even if 2G is said to be applicable or not applicable, whatever.
Yes.
I mean, that does not mean that's not a precedent on this proposition.
This is not.
That it goes out of this
And
act.
my lord, why, my lord? Even if it is so, there are stray lines on that. I'll be very candid, my lord.
That would be obiter.
No, that
May not
doesn't
be obiter.
consider, because, my lord, lordship says in this, my lord, lordship knows, my lord, that in this type of suit, my lord,
yes,
if, my lord, someone's entry is not, my lord, illegal, his entry is legal, but subsequently by efflux of time, my lord, the lease expires. His entry doesn't become illegal. He's there.
It's
As, my
not a
lord,
question of the entry being illegal in either case.
No, entry, my lord,
That concept is not.
No, that concept is necessary because then, my lord, a suit as a trespasser, you cannot file against him. You have to file it as a 106 notice, my lord, if the rent is above, less, my lord, now there. Then, my lord, valuation of the suit will be 12 months.
No, they have filed the suit under which provision?
Under the transfer of property. It will be 12 months rent. That's all, my lord. That's, my lord, settled under the West Bengal Section 7(1), my lord. That section is there. Now, the division bench says, in the case filed in the original side, you cannot club the mean profit and make it a suit as a trespasser and, my lord, take the court into jurisdiction. That's
No,
a
if you
division
admit
bench.
the jurial relationship and if you say that it's a but you say it comes within 97.
Comes within, and, my lord, most importantly, if lordship takes the fourth schedule, since it is below 60,000 rupees, my lord, it will be before the small causes. Fourth schedule of the act in question.
Then we cannot decide the appeal immediately. That was the. So let us hear this. Yes, occupation charges. You have filed your opposition.
So this is, my lord, the suit will otherwise a decree will be a, my lord, a non-est, because under the provision of the act, I get a protection under this act. Suit should have been filed in the small causes court. It has been filed here on clubbing of 5,000 rupees damages, so it becomes 10,000, comes to city civil court. Now, my lord, but the act specifies, my lord, if I get a protection, I have to be sued before the small causes court. My lord, that's, my lord, a lack of subject matter jurisdiction. Then, my lord, I get the protection of, my lord, the fair rent, my lord, as per.
That will hear in the appeal. You have made out a prima facie case, but what about the opposition? You have filed already.
Yes, yes. They
Opposition
have filed an opposition. We have given a reply.
Dekhi opposition to reply your opposition about it.
And, my lord, paper books have also been filed. My lord. As per your lordship's direction, I have come.
That we can direct to the appeal.
Yes, I have already filed.
So,
that was the direction in the order.
কোন ক্যানেটটা দিচ্ছেন সেটা দেখবেন ক্যান 1 is the stay মিস্টার
yes
রিপ্লাইটা দিন ওটা তো রিপ্লাই নাকি reply your file.
Yes, I've done. So far, I am complete.
You have not filed. Why are you saying filed?
I'm sorry.
I'm asking you repeatedly. Our officers are unnecessarily harassed for this.
I mean, কেন করিস নি?
One টা তো can one টা কোথায় সেটা তো লাগবে।
সব করেছো তো না তো? They have filed a unregistered lease.
ওনার opposition এর এটা কল করো।
And there is a registered lease deed at page.
Give us half a minute. Can one টা এটা?
Same.
ওটাতে কি হবে? আপনার কপিগুলো আলাদা করে দিন। অপোজিশনের
That's your best.
এই সুতো বেঁধে বেঁধে বুঝি না একসঙ্গে তো বড় সুতো বাঁধাই থাকে।
Like 600 square feet is the area of the premises. The residential in question. There's no dispute on that. My learned friend is annexed documents in relation to commercial spaces. One
Park
is
Street.
yes,
Park Street. It's Park Street.
115 they're asking in respect of a commercial space on the front of the building. That is their document. Milord.
No, what is the area of your property? The suit property?
552 plus 108. So I said so Milord, it says 660. 552 is the Milord flat and servant's quarter is Milord 108. Backside of the building. So
660.
660. Lordship takes is 660.
Which floor?
Florida.
Third floor.
Third floor. Third.
On the Park Street, yes.
Yes, Milord, it's Park Street, and this is what he has annexed, Milord.
You are using it for residential purpose.
I have purely from 1984. There was a enhancement. There was a rent, Milord. I am occupying the premises from 1984. It's the second lease.
Last rent is 456.26 per month.
Yes, that was the last rent.
And they have annexed what?
They have annexed
Deal with that also so that he can give up.
Page 18 of the affidavit in opposition.
Yes.
No. Page 18 is unregistered. This is, Milord, in respect of Milord, commercial property, Milord. Where, Milord, Lordship will kindly take, Milord, page 22. They are asking for, Milord, 1 lakh rupees rent. Page 22. It's a
But
restaurant.
Mr. Ghosh, the test is how much they can, how much the property can fetch. They can, if they got it from you, they would have, the principle is that it could have fetched 1 lakh. They could have commercially exploited it.
Milord,
is this also on the third floor?
This is, Milord, ground floor, front of the building, Milord.
Ground floor.
One
So
is
that's
the first floor. This is first floor.
That
This is
makes
first
a difference,
floor.
yes.
This is first floor. No, I don't say it. It's front, but first floor. And this 42, page 42 is the document which is on the ground.
This is first floor, 90.
First floor. And Milord, surprisingly, Milord, the page 42 document, if your Lordship takes at page 42.
Yes.
Milord, there, Milord, page 42.
And this is 1350 square feet also.
This is 1350 square feet. That's there.
And page 42, yes.
This, Milord, is, Milord, for, Milord, 9 Milord. No. Period. Milord, 9 years. Page 21. 9 years. And this is a document of August 2020.
9 years, why is it that relevant? I mean,
no, Lordship, ask me the period.
No. Page 42, we said, what is the
page 42, if your Lordship takes, page 42. Register
document should have
page. Kindly, Milord, takes page 56, Milord. That is, Milord, 1.50 lakhs.
No, regarding the area?
Area is 1200.
12?
And this is 3 years. This is 1200 square.
1200 square.
This is with documents on record. Watch. And it's an ice cream parlor. On the ground floor.
1.5 lakh.
Yes. On the ground floor. On the road.
Yes. So if first floor can fetch 1 lakh, why shouldn't you pay 1 lakh, Mr. Ghosh?
Well, that's a lesser, larger area in question.
Larger, very well. 1350 and yours is 660, about half. So then 50,000.
Actually makes it little less, Milord, so
Why?
that I can contest it. It's Milord, a residential third floor in question.
In Park Street.
Milord, third floor, if someone is residing, Milord, Lordship will make it. And Milord, on the back side, that is also a consideration. Straight away, it can't be, Milord. Lordship has to draw a line. Yes, I know, Milord. Sometimes I come from the landlord and I start shouting. But Milord, yes.
No, not that. That's not a consideration that you shout sometimes for the
landlord.
No, backside is the servant quarter.
No. My floor.
Backside means it's south facing.
That I, Milord.
We'll make it 1 lakh.
No, it's a backside.
South facing, Park Street.
Milord, it's a backside.
What backside? Backside of what? Looking at from which side? Backside means nothing.
I'll take the instruction. I cannot.
Backside, what is backside?
Milord, on the backside of the building in question.
The building may be facing north and the backside is south then.
The building is, well, natural ice creams. Milord, he says, Milord,
natural ice cream.
Natural ice cream. I have no knowledge.
He might have direct knowledge.
Milord, backside is, well, I'll take the, Milord, I have to, Milord, the
backside of Park Street. That is what you mean.
Backside, Milord.
That does not make a difference.
Milord, it's third floor, backside, not on the ground floor, Milord. It's almost half.
Achha, the first deed is also for commercial. That is also.
That is everything is for commercial.
Both
That-
both of both
are
both the
commercial.
documents.
Both are commercial. Both are commercial documents. So some consideration for residential and the backside.
No,
and-
residential is no consideration because it is the test is what they could use it for.
The
So if
third
first
floor
floor-
document, if they have given a residential one, commercial one is, Lord, I am bound by what fell from, it's falling from your lordship. And Lord, in the test of the case, of course, merits can't be looked into. Lordship looks at, Lord. Judgment on admission when there is no admission.
Yes, what do you say? What should be a proper occupation there?
Just kind of to see. The basic question is that 77 by 1B Park Street, front side, back side. If your losses for the sake of argument say High Court's building, is there any difference between code number 19 and 13?
No, there is no difference because both are judges.
Yes.
But here you cannot
I say the
you
location.
may not run a good business from the backside.
Or
if-
I will show your losses that in another matter, the losses kind of to see.
No, this matter. Let us focus on this matter first.
No.
Whatever annexures we have.
Yes, this is one in respect of registered lease and another is respect of unregistered lease. Your losses can to see that 165 per square feet in the registered documents and 111 in unregistered documents.
Yes, if a 1200 square feet ground floor, we cannot compare this third floor with ground floor.
Now,
So yes, first floor may be comparable, although third floor is much up. But even then, 1350 square feet on the first floor and 660 square feet on the third floor is half of that, around half, just around half. So if you can get 1 lakh for 1350 on first floor, it cannot be more than 50.
1 lakh 15.
1 lakh 15, then we take it as 1 lakh because this is on the rear side and also on the third floor, 2 floors up.
The appearance of a degree, my lord. If they say that this is the
One
residence.
can still go to the first floor to buy things, I mean,
So same
commercially.
staircase,
have a-
one entrance.
I
Same
have-
one entrance.
I have a valuation report. I'll
But
I'll
they
not.
value same.
Not a
entrance.
part of the record.
Yes, I have prepared it. It's below.
You cannot.
It's below 30,000. I have prepared it. I could have below done, but that is the actual
Well,
valuation.
if your losses
They
can
have
to
no
see
valuation report of
Their
this.
affidavit in reply.
50,000, ঠিক আছে না?
Their affidavit
1
in
lakh 15 ওটা বলছে, যাচ্ছে তো।
We have not annexed.
They are getting 1 lakh 15. So a little more than 50,000 would be. So we'll make it 50,000.
Thought you makes it 30,000.
No,
It is in the
not
third
no
floor.
question of 30,000. You also use it as a cafe lounge and a restaurant and a hookah bar. Hookah bar would operate better from the rear.
Well, I don't know. Am a
Yes, you don't know anything. You're so naive and such an innocent person. We also don't know.
no. Hookah bar, I don't know. Hookah bar, I don't.
You have never heard of hookah bar?
Yes, in Salt Lake.
You may not have direct knowledge, may not be a user.
I haven't.
You
been to
need not
hookah
be a
bar.
cricketer to be a cricket critic.
No. Hookah bar, I haven't been myself.
Maybe, but you have heard of hookah bar.
Yes, absolutely. And we'll the raids and whatever happens there. I have
So if you have heard that, then it operates better on the rear side. So pay 50,000.
Or what I am submitting my lord before losses, since the rented premises is 50%, 660 square.
660.
That's why your losses of the entire per square feet.
No, also because it's on the third floor.
Same entrance, same staircase.
Same staircase
lift.
does not mean anything. Same staircase. Maybe.
Well, Lordship, I'm not.
We are making it half because the area is half for that reason. Area is half. That is the reason.
Millard,
We are ignoring the rear portion thing.
Lordship, I'm not pressing for stay. He can't pay Millard. Let them get the property. I'm not in a position to pay Millard.
Oh, you are in such a position.
I'm the instructed, so Millard, I can't pay Millard.
So then we have to record your submission that you are not pressing the stay.
Yes, we're on instruction, I'm saying. So.
Right.
Come to stage.
During hearing, learned counsel for the appellant submits on instruction that the appellant is not willing to press the stay application. Full stop. Accordingly, can 1 of 2024 is dismissed as not pressed. Full stop. Let the appeal, the paper books have been prepared in the appeal.
Yes.
Let the appeal be listed in the monthly list of March 2025 for hearing.
And the stay,
I'm not pressing.
execution case stayed your losses.
No,
I'm
refuse,
not-
dismiss stay application.
Application and the order was till 21st. That's gone. That's gone.
It is made actor line at close. It is made clear that the interim order granted earlier has already expired, and there would be no impediment in the respondents proceeding with the execution case.
And the appeal fixed value. Appeal.
What limits of the appeal?
Appeal, they may win and get a restitution under 144.
Defect.
That will consider.
Mean profit. Mean profit, they will have a claim in mean profit, even if I leave today. That Miller I have to press. Because they are claim mean profits. Because they are from 2008, they have a
If you win the appeal, everything goes. If they, in the meantime, if they get an execution, then
that's why the appeal has to be given.
then the argument will be on section 144.
Yes, and Miller were the maintainability of the suit. If this suit has to go,
No, no, everything else comes in. Everything else comes in.
Great.
13 million for the
13 year for
appellant,
the appellate.
appellant,
Right.
defendant, my lord.
Yes, Mr. Ghoshal.
My lord, the appellant.
What is the substantial question of law? Memo koi? Ache? Look here.
My lord, kindly look into the impugned order first, my lord.
Very well, we'll do that.
Impugned order of
As per your pleasure.
6/6 to 2023.
What is the defect? Let us first check. Defect removed. Very well.
Yes.
6/6.
Well, the appeal, my lord, there is a title suit filed by the plaintiff, my lord. They are decreed against the defendant.
What is the suit for?
Suit for declaration of title and by injunction. The petitioner, the appellant prefer an appeal against that order, my lord. That
Yes.
so there is a section 5. The section 5 was rejected.
Oh.
Against that, my lord, the petitioner.
What was the delay?
My lord, not that delay. That the entire time is covered by the judgment of the Supreme Court.
Oh.
Yes, ma'am. 6/6. That was, my lord, going to the.
You argued that?
That was not argued by anyone, but the lower court below also not seen that. Also, I have win by stay application. I have annexed the judgment. The entire period is covered by the judgment of the Supreme Court. 6 order number 10, my lord, 6/6.
No, no, you have argued. You have argued. You have not even looked into the impugned order. That is your first argument.
Argument, my lord, there is a COVID. The judgment is not cited there. Judgment by the
Judgment did not be cited. You argued it.
Yes, ma'am.
We asked you whether you argued, whether this point was taken.
Yes, yes, ma'am.
This was different. Mr. Ghoshal, you do this. We will. How many respondents are there?
My lord, respondent number.
Two respondents.
Two, my lord.
We'll take up the along with the order 14, hear out the main appeal. You serve notice on these both. They have there is no scope of execution immediately, and we cannot stay at permanent injunction. So do this. We'll make it clear in our order that we'll admit the appeal right now. No, then we won't have the determination to dispose it of. We'll admit it and dispose it of together. Give a notice. Serve copies of the memo as well as the application. The present second appeal has been filed on the sole question as to whether the learned first appellate court was justified in law in refusing to condone the delay in preferring the title appeal, comma, dismissed the section 5 dismissed the application under section 5 of the Limitation Act, and consequentially the title appeal itself, comma, despite the entire limitation period for preferring the appeal falling within the pandemic restriction period, comma, which was deducted from the during which the limitation period for filing all proceedings were extended by several successive orders of the Supreme Court. Push up next para. In view of the extremely short conspectus of the appeal, comma, we intend to dispose of the appeal along with the admission hearing. At the admission hearing stage. Full stop. Next para. Accordingly, the appellants shall serve copies of the memorandum of appeal along with the application on the respondents directly as well as through their learned advocate in the court below, indicating that the appeal and the application shall appear under the same heading on March 10, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Do that, come back. 10th March. Serve on the respondents as well as their advocate in the court. Section 5, second appeal. বছরের পর বছর ঝুলে থাকবে।
The appellants, but it again shows for a defective, Miller. I don't know why.
Out of time, that is the defect shown.
Yes, no, we have filed section 5.
Then that takes care of it.
Directors us to file the
Yes,
fee
yes.
and section everything, Miller. We have
Section 5 has been served.
Yes, Miller. Affidavit
Proper service effected.
Yes, Miller.
বাবু
Stay,
একটু ওদিকে দেখ।
stay, application and memo has been served. Your Lordship's direction was the 15th February. We served on 24th February.
What is the delay?
115 days delay, Miller.
Explanation?
Explanation, Miller, we filed after we filed the 21st September 2023 was the order of the lower court below. We get a certificate copy on 22nd September. Thereafter, we preferred a civil revision. That was pending, and there was Durga Puja, Miller. Thereafter, the order has been rejected, stating that this is an appealable order, 22nd December 2023. So we preferred an appeal.
Despite service, none appears for the respondent. Full stop. Affidavit of service filed to be kept on record. Full stop. In the application for condonation of delay in preferring the appeal, comma, the appellants have pleaded that initially they had preferred a civil divisional application on a bona fide misconception of law, which was ultimately dismissed, and thereafter the present appeal has been preferred against the impugned order. Full stop. Next para. Upon a perusal of the grounds taken in the memorandum, taken in the application for condonation of delay, comma, we are satisfied of the sufficiency of the cause for the delay. Accordingly, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FMAT number 27 of 2024. Push up. Let the appeal be listed tomorrow under the heading Order 41 Rule 11.
After tomorrow, Miller.
Then it has to be next week.
Next week.
Let the appeal be listed under the heading Order 41 Rule 11 along with the connected stay application on March 4, 2025.
Great.
The application is one for stay.
Yes,
The
Miller.
other applications?
Yes, Miller.
Stay or injunction?
Stay. Great.
Well, the pseudo was for eviction, recovery.
Delay has been condoned?
Yes, Mala, yesterday.
Previously condoned? Yes. Right. Yes. You are appealing for the other side?
And for the respondent.
Well, yes.
Pseudo was for eviction, recovery position, and mean profit.
Eviction on what ground?
Eviction of that, they're saying that reasonable requirement.
Only reasonable requirement? Both courts granted the decree?
No. They have preferred the suit, title suit, it was rejected. And thereafter, they have preferred an appeal, it was affirmed.
Affirmed?
That means pass the order
Reverse,
against,
reverse.
against me. Reverse.
So what is your ground? Substantial question of law?
Yes. Kindly come to my memorandum of appeal. Ground number 6. Ground number 6. Ground number 13.
What is the ground? Show us from the judgment that that ground is correct.
There are so many grounds that I have taken out that, but
So many grounds in a second appeal means it's a bad second appeal.
yes. But my question of
That is
law,
a sure shot indicator that if there are many grounds in a second appeal,
question of
it's
law,
a bad
kindly
second
come-
appeal.
Kindly come to my ground number 6.
You tell us, you argue, yes. Whatever is there in your ground, what is the, verbally say, what is that ground?
Firstly, my lord, they have preferred the suit, title suit.
Ejectment
This
suit.
ejectment suit, that is right. In the said suit, they have stated in the plain that they require 6 rooms. The premises is G+3. Ground floor, there are 10 sub-rooms.
Their requirement is 6 rooms.
6 rooms.
6 rooms, yes.
As in the stated in the plain.
For what purpose?
For residential purpose.
Acha. Ground floor has 10 rooms according to you.
10 shops.
10 shops.
First floor, 3 rooms. Second floor, 3 rooms. Third floor, 3 rooms. 3 rooms means 2 rooms and 1 Thakur ghar.
Third floor.
Third floor. Each floor, my lord, they are containing a kitchen, washrooms.
Now, first floor and second floor, 3 clear rooms, not Thakur ghars.
These are all same.
All 2 plus Thakur ghar.
With kitchen and washroom. Now, my lord, my client is staying at third floor.
In those 2 rooms.
Those 2 rooms.
And they are residing in the rest of the 2, first and second floor.
No, they are staying at first floor. Second floor, they have given another tenants.
That tenancy was given during pendency of the suit.
Yes.
No.
Before that.
Before that. So then those are tenanted, those cannot be taken into consideration. What was the wrong committed by the first appellate court? Then they have 2 rooms only in their occupation.
They have another premises also. And these premises also within the same municipal corporation.
What is the composition of their family?
That is the observation made
Sir
by...
Devnath, what is the composition of their family?
My lord, I am showing the plate.
Let us come to the appeal court judgment.
Wife, his 2 sons, her 2 sons.
So husband, wife?
Husband deceased.
As a wife?
Wife,
2 sons, 2 major sons.
2 major sons. 1 granddaughter.
Granddaughter age?
12.
You're asking him?
Graduate.
But in the
Graduate, so separate room.
separate room. And 1 maid servant.
You better come this side so that you can assist him easier. Yes, Mr. Devnath, let him come beside you so that he can assist you. Acha, 1 granddaughter. So 2 sons, 1 granddaughter.
And 1 landlady.
So therefore, 2 plus at least 4 rooms for bedrooms.
Bedrooms.
And granddaughter must require a study room.
Yes.
5.
Yes.
Another room for drawing room. 6 is sufficient.
My lord, husband.
They have only 2 rooms.
My lord, kindly consider, but big son, elder son also purchased 1 flat. She's another accommodation.
What is the finding of the appeal court on that? Mr. Devnath will come back in 5 minutes. You go through your records. We'll come back in 5 minutes and continue with this. Yes, Mr. Devan, how was it dealt with by the appellate court regarding this?
Before coming out that, can you give me the permission? Because
Yes.
the observation made by the learned trial judge in issue number 6, kindly come, my lord, internal page 13 of the trial court order.
Yes, 13.
Why I am on, my lord, before coming out that? Because the observation made by the learned trial judge and
Yes.
the first appellate court is entirely different.
Let us see.
Issue number 6, my lord, whether the plaintiff reasonably requires set flat for the use and occupation of the plaintiff and her family members, whether any other reasonably suitable accommodation is available to the plaintiff. The plaintiff has filed this suit for eviction of the defendant tenant on the ground that she reasonably requires the premises for her own use and occupation, and for use and occupation of family members, as she does not have any other suitable accommodation elsewhere. It is a specific case of the plaintiff that family of the plaintiff consists of herself, eldest son, wife, daughter, youngest son, and full-time care gave her for the plaintiff, and she, along with family member, resided in rented accommodation at 6 Godanghata State Police Station, Borotola, Kolkata 6. And her son is carrying out business from 2 rented rooms situated in the ground floor.
They are living in a rented accommodation.
Yes. It is observation of the trial court.
Rented accommodation there by right, as a matter of right, they're entitled to their own house.
But it was deposed.
Whatever may be the occupation there.
Deposed by the plaintiff in the plain that is rented, but they cannot show any receipt of the rent.
What is the finding of the trial court on that?
I am placing a finding. That is the finding, issue number 6. Now, my lord, and his son is carrying this as husband. On the other hand, the defendant specifically averred that the plaintiff does not require the suit premises for her own use and accommodation, and stated that plaintiff is the owner of the entire suit building at 12 Godanghata Road, Borotola. And apart from that, she has another other suitable accommodation within 10 kilometers from the suit building. It is further case of the defendant that the suit building is a 3-story building and there are 36 rooms, which was under possession of the plaintiff, and plaintiff has let out these rooms to different tenants. Now, before plunging into adjudication, it is what we mention here that clause D subsection 166 of WPT Act entitles the landlord or any person for whose benefit the premise is held to determine the tenancy of the ground that he reasonably requires the premises for own occupation, and he has no reasonably suitable accommodation within the same municipal corporation area. The word reasonably requirement plays a very vital role in the adjudication suit for eviction on the ground of reasonable requirement. This court cannot resist itself from mentioning here that it is no more res integra that bona fide requirement means the requirement must be honest and not a mere desire of wish. There is end of number. There is number of judicial pronounced Supreme Court and High Court, Calcutta, in this regard. But this court resists itself from mentioning them in the judgment for the sake of gravity. It is settled proposition law that any suit for eviction on the ground of reasonable requirement, plaintiff landlord has to fulfill 2 basic conditions. Number 1, requirement must be reasonable and bona fide. Number 2, no other suitable accommodation available to the plaintiff landlord. In this suit, plaintiff has adduced evidence to substantiate her claim, and defendant also adduced evidence to controvert the same. Now, on careful perusal of pleading and evidence on record, it appears the plaintiff has not uttered anywhere in the plain that she is the owner of the building, property premises, 12 Godanghata Road. However, from the document of plaintiff itself, certificate copy of the deed of purchase, Exhibit 2, it is clear that plaintiff Usha Ranipal and her husband Nitai Pal, since this is purchased the entire suit building 12 Godanghata Road. And needless to know that after demise of Nitai Chandopal, the plaintiff also inherited a portion of the share, Nitai Pal, in the suit building, and her sons become the owners of the building. But as the stated of a plaintiff has failed to disclose that she is the owner of the suit building, there is no doubt that the suit for eviction under West Permission 1997, the plaintiff has obligation to prove his ownership of the property, but plaintiff landlord has the obligation to disclose his accommodation available in the suit property. From the pleadings of the plaintiff, it appears that plaintiff has failed to disclose how many rooms are there in the suit building and whether they are vacant or occupied. Whereas PW1 Tapos Kumar Pal, who is the son of plaintiff, has admitted during cross-examination that the suit building is a 4-story building, and except the defendant, there is no other tenant on the 3rd floor. There is no other tenant on the 3rd floor of the suit building. He has further disclosed that there are 10 sub-rooms on the ground floor of the suit building. Cross-examination dated 14 September 2019. From the statement of PW1, it is clear that plaintiff has accommodation available in suit building, but same has not been disclosed in the claim. From the argument's sake, it is considered plaintiff has no accommodation available in suit building, then she has obligation to plead the same in the plaint. But again, there is no pleading that she has no accommodation in the suit building, or that entire suit building is in occupation or possession of tenants. The court is not oblivious that plaintiff has paid for local inspection and tenanted accommodation of the plaintiff, and the suit flat has been inspected, but again, plaintiff has failed to show their present accommodation in the suit building, and local inspection of the tenanted premises of the plaintiff is not suffice to consider the reasonableness or the considered justification of the ground eviction. To get a degree of eviction on the ground reasonable requirement, the plaintiff landlord has to prove that his or her requirement is bona fide nature, and plaintiff has to disclose his or her present accommodation. This court cannot resist itself from mentioning here that it is more res integra. Bona fide means a requirement must be honest and not a mere desire wish. But the conduct of plaintiff does not vouch for honesty. Concealment on the part of the plaintiff to disclose the residential commercial accommodation available to plaintiff amount to concealment of material facts and laws does not help those who do not come with clean hands. Plaintiff has intentionally deviated from disclosing her accommodation available in suit building, which amounts to suppression of material facts. The court is borrowed wisdom from the judgment reported 2003-9 Supreme Court cases, Kishan Chand, where the suit of eviction was filed by the plaintiff against the defendant on the ground of disorderly requirement, but the plaintiff concealed some material facts before the court, and honorable court has held. As stated above, the plaintiff has tried to conceal her present accommodation, and though not specific document has been brought before the court, but the admission made by PW1 cannot be discarded as it comes from the witness of the plaintiff. The word reasonable plays a very vital role in adjudication, a suit for eviction of ground of disciplinary requirement, and the act of the plaintiff does not demand any mercy of the court. In this case, plaintiff has tried to conceal material facts, and for the reason plaintiff is not entitled to get in relief, and accordingly presents issues disposed and decided in favor of the plaintiff against the plaintiff. But this observation made by the trial judge is not at all figured, and the order of the.
Let us see we are looking at the appellate code now. We have read that.
Yes, ma'am.
Appellate code, page 14.
Appellate code, page 14.
Page 14.
Yes, ma'am. Learned Court is a well-discussed judgment mentioned elaborately above the aspect of suitable accommodation which is available to the appellant plaintiffs not under the head issue number 6. She decided the issue number 6 against the appellant plaintiff. Learned Court has mentioned the appellant plaintiff tried to conceal her present accommodation Karanhata Street. It suggests that she has accommodation elsewhere, so she does not require the suit premises back to her for her own use and for the use of family members. Appellant plaintiff has filed a suit for eviction of reasonable requirement. Tenant mentioned in para 7 of the plaint that she and family members are residing in a rented residential room on second floor premises number 6, Karanhata Road. And Sans appellant was carrying on the business from the 2 rented shop rooms on the ground floor of the premises, and there is another room on veranda in which they reside. She mentioned in category in the plaint that she is aged about 73 years old, and family members comprise her elder son, wife, daughter, youngest daughter, full-time maid servant for looking after appellant plaintiff. And she has mentioned his requirement for a decent living of 5 bedrooms, 2 kitchens, 1 storeroom, 1 thakur ghar, 1 guest room, 1 drawing room, sitting room, 1 dining room, and a storeroom. She made it clear in para number 3 that in all 6 requires 13 rooms, but presently she and family members residing only in 1 rented room at 6 Karanhata Road. She paid for eviction of the testimony so far he can get back accommodation from the suit premises for herself and family members. Taposh Kumar Pal, son of the appellant, came and deposed before this court as a witness. She stated before this court as PW1 that his mother was not kept well due to age-related ailments. He appeared before the court in order to depose. He stated that his father inducted the respondent, defendant, tenant over the suit premises, and after death of the father, his mother became the landlady of the respondent defendant. He admitted that other rooms in the building has also been let out to other tenants. He denied that his mother is owner of holding number 6 Goranhata Street. He intimated the court that Gopal Vishwanath Goswami is landlord of Goranhata. He also intimated that the court that presently is the daughter of the elder brother studying at B.Ed in Maharaja Sirish Chandra College. So family of 5 members having a grown-up daughter and one old lady require accommodation at their own place. It cannot be agitated and said that they cannot ask for dining room, drawing room, bedroom, thakurghar, kitchen, showrooms, etc. in order to live a decent life in their own home. They definitely require the suit premises reasonably, and there is a genuineness in their claim. They themselves are residing at number 3 Goranhata Street, where they run their shops. Basically, they are businessmen, and 2 brothers have 2 separate shop rooms at their Goranhata Street tenanted premises. Now, how and why defendant is saying that Goranhata premises is actually a purchased property of the appellant plaintiff, it is not known to them. Respondent defendant could not produce a single scrap of paper that the fact appellant is the owner of 6 agencies. On the other hand, respondent defendant could not say during his cross-examination that when he lastly paid the rent to the landlord lady with respect to the suit premises under this position. Respondent defendant admitted the plaintiff that the appellant plaintiff Usha Rani Pal has 2 sons and they have their own family. He further admitted appellant plaintiff Usha Rani Pal family stay in one mess. This witness admitted one strange thing during cross-examination that he visited suit flat lastly some 15 days before. Then he admitted that he sometimes visits said flat. She denied that he does not reside in the suit flat. During the cross-examination stated at a place that Nutan Singh is residing in the suit premises flat along with her flat. She told that court has the court that his 2 daughters, namely Nitu and Neha Singh, are married off. Commissioner report along with the field note has been placed before the court and marked Exhibit 9. When PW2 Advocate Commissioner deposed before the court, she visited both the suit premises at 12 Jodu Pandit Road, Kolkata 6, where respondent defendant is reside. He visited the place in presence of both the sides and learned advocate both sides. He found 3 bedrooms, 1 kitchen, 1 passage, toilet. She mentioned about the measurement, windows, doors, furniture, stated that flat situated on 3rd floor at premises number 12, Jodu Pandit Road, Kolkata 6. She mentioned that the accommodation of the respondent is well decorated. Nowhere she has mentioned that damage has been caused to the flat. After this, she inspected the resident accommodation of the appellant plaintiff on the 2nd floor at premises number 6, Goranhata Street, and she found 1 room, 1 covered space, veranda cum passage, which has been converted into kitchen. This room and covered space situated in the 2nd floor. She found 2 rooms at the ground floor, and both rooms are being used by the business purpose. She has clearly mentioned that she buy jewelry box, bags, 1 rolling machine, then matcha containing business material at ground floor, a sub room. So there is only 1 room covered veranda. Entire family reside together. On the contrary, respondent defendant living in a spacious flat of 3rd floor at 3rd floor, convenient 12 Jodu Pandit Road accommodation. Appellant plaintiff Hannah Sang resides on the 2nd floor, where 2 shops are situated at the ground floor of Goranhata. Had it been a personal house of the appellant plaintiff, then could have used the 1st floor as well. Why the entire family residing in 1 room at 2nd floor and having 2 rooms on the ground floor?
Half a minute. ওই রেন্ট রিসিপ্ট দেখিয়েছি তাতে অসুবিধা রেন্টেড হাউস ওখান থেকে নিজের বাড়িতে আসতে যেটা ওর পারচেজ ডিড থেকে পারচেজ ডিড রয়েছে অ্যাডমিটেড ছেলে 4 স্টোরি বিল্ডিং তাতে শুধু এই টেনেন্ট আছে সেটা একটা জায়গায় অ্যাকশন রয়েছে সেটা তো দেখায় না কিছু is independent of the Mr. Devnath, no inspection was sought by the landlord regarding the other rooms of this building, the suit
He
building.
can say so perhaps because the trial court I was not there.
Probably not.
No, my lord.
Only the suit premises was, as per the records, only
Inspected by the
the
landlord.
suit premises was inspected and Goranghata was, Goranghata is tenanted. Otherwise, the tenant is, the landlord is entitled to.
Now, my lord, kindly permission, my lord. Right now, I came to know, my lord, that entire property, they have got it.
No, that we can't accept your contention because they have produced rent receipts before the appellate court has discussed. We won't go by that. And if they are in a rented accommodation, they're definitely entitled to their own house. But their only difficulty which they will be facing is that they have not shown the extent and mode of user of their existing accommodation in the suit building. It's an admitted 4-storied building.
As well as, my lord, they have not stated how many rooms are there in the plaint.
They have not even disclosed the number of rooms in this in the suit building.
Kindly come to them on a plaint, copy of the plaint.
No evidence is also there. 12B Jodhu Pandit Road, it's admittedly a 4-storied building.
They says only, my lord, paragraph 8 of the plaint, the requirements of plaintiff as follows: one bedroom plaintiff elder son, one bedroom plaintiff younger son, one bedroom plaintiff going up granddaughter. But how many rooms are there? So, my lord, that plaint, the suit is not at all maintainable.
Difficulty is they are residing in a rented accommodation. They are having to pay rent.
But they have to show at least. Because, my lord, the observation made by the learned trial judge on after adducing all the evidences.
1 minute, Mr.
Observation of the
Mr. Devnath, 1 minute.
different.
Mr. Devnath, 1 minute. You don't have a right of hearing in order for Rule 11. We can admit the appeal. But because we find from the records, we are giving this proposition to you. It's your call. We will have to admit the appeal on at least one ground that you have not disclosed your alternative accommodation in 12B Jodhu Pandit Road.
My lord, in the
Admittedly, it's a
plaint itself
4-story.
In the plaint itself,
No,
there is.
in evidence, there is nothing. You have not had a local inspection on that. Nothing.
Title deed was there. Title deed was list of tenants already disclosed in the title deed, Exhibit 2.
Title deed is not a proof of the tenancy. You did not examine a single tenant.
There was.
Your son admitted that they are the only tenants.
Yes.
There are tenants.
PW1.
PW1 has admitted.
12B. Only third floor.
No.
The defendant was residing. There are no other tenants. Only every floor is consisting of 3 rooms only.
There are
One
no other
flat.
tenants in Jodhu Pandit Road than them. That has been admitted by your son.
Jodhu Pandit Road, only several tenants are there. And several suits are pending also.
Let us come
It is in
to
the exhibit evidence also. There are other 2 ejectment suits are pending against other tenants.
please come to page 15 of the trial court. The trial court, before the trial court, the evidence was there. PW1 Taposh Kumar Pal, your son, has admitted during cross-examination that the suit building is a 4-storied building and except the defendant, there is no other tenant on the 3rd floor.
On the 3rd floor. Third floor is only one flat is there only, nothing else. 3rd floor, one flat.
Have you got a copy of the evidence?
Yes.
Show us the evidence. Have you got a copy of the evidence?
No.
Should have had a copy of the evidence. We want to see whether they had established that the other rooms are tenanted. The appeal court comes to such a finding.
May I submit to Lord Srimalal? Only.
No, we want to see the evidence. Your submission won't do.
Oh, evidence. We have not got that one right now.
Because the appeal court holds contrary.
Yes.
Appeal court holds that PW1 said that the other rooms in the suit room building have also been let out to other tenants.
Contrary view.
Not a contrary view. Because your learned friend is right. The trial court records that on the 3rd floor there is no other tenant.
Except me.
Yes. Whereas appeal court records, these are mutually compatible. He says that the other rooms in the building are let out to tenants.
Yes, that is PW1. Son.
So if there is such evidence on record that other rooms are let out, why should you have an inspection of that? That is sufficient.
That only inspection was done at my tenanted premises.
Need not be. If the other premises are tenanted, then they need not be
Because
inspected.
they have not a place for any petition for inspection.
See, they don't require. If they say in evidence that those other rooms are tenanted, all the other rooms are tenanted, and they are living at present in a rented accommodation, then as a matter of right, they are entitled to the suit rooms.
But kindly see the appellate court order.
Appellate court says that he admitted, means PW1, that other rooms in the suit building have been let out to other tenants. That is PW1.
Then kindly come to my trial court.
Trial court we have read again and again. How many times will you read? We read out the relevant portion, page 15, which you also placed before us. PW1 says that suit building is a 4-storied building, and except the defendant, there is no other tenant on the 3rd floor. Only the 3rd floor, there is no other tenant here. That is the admission.
Then entire room vacant. Entire floor is vacant. They have the.
No, he says that the other rooms are tenanted.
No, he has said. But otherwise he said there is no other tenant. That entire reasonable requirement is not required.
You don't understand what you are saying. And you don't understand what we are saying. PW1 says all the other rooms are tenanted, apart from the 3rd floor where you are the only tenant. Otherwise, they're living in a rented accommodation, they're entitled to have their own house. And reappreciation of evidence cannot be done by the second appellate court.
Well, kindly come to page 15.
15 we have read thrice, Mr.
No,
Dev.
I have not.
We have a limit to our patience also. You read out.
Except me.
If you are wrong, then tell us. It's a clear admission on them, on their part, that only the 3rd floor, on the 3rd floor, there is no other tenant than me. Not regarding the rest of the building.
Well, when they said only, kindly consider, when they said only that I am the tenant, then whether it shall be taken in consideration that there are also tenants?
Ashu. Congress. The present second appeal has been preferred against a judgment of reversal arising out of an eviction suit filed by the plaintiff respondent on the ground of reasonable requirement. Push up next para. The learned trial judge dismissed the suit for eviction by holding that the plaintiff stroke respondent has failed to show her present accommodation in the suit building, although it has been established by a purchase deed that the plaintiff is the owner of the entire suit building. Full stop. Next para. The appellate court reversed the findings by taking note of the evidence of PW1, the son of the plaintiff stroke respondent, that the other rooms in the suit building have also been let out to other tenants. Push up next para. Learned counsel for the appellant argues that such finding of the appellate court is contrary to the observation of the learned trial judge, who specifically narrated the relevant portion of the evidence of PW1, the son of the plaintiff, who had admitted that apart from the defendant, there is no other tenant on the 3rd floor of the suit building. Push up thus, it is submitted by the appellant that in view of such admission, the trial court was justified in refusing to grant eviction on the ground of reasonable requirement on the failure of the plaintiff to show the extent and mode of user of the other rooms at the suit building, that is at 12B Jodu Pandit Road, Kolkata 7,06,000. Push up next para. However, on a careful perusal of the judgments of both the courts below, we find that there is no contradiction in the findings of the trial court and the first appellate court insofar as the evidence of PW1 is concerned. Full stop. Whereas the learned trial judge observed that PW1 had admitted in his cross-examination that there is no other tenant on the 3rd floor of the suit building apart from the defendant, by such very statement, it is evident that the admission of there being no other tenant was restricted to the third floor and the third floor alone of the suit building. Full stop. On the other hand, comma, the first appellate court also considered the evidence of PW1 and recorded that the said witness had stated that the other rooms in the suit building have been let out to other tenants. Full stop. Next para. That apart, comma, the appellate court took into consideration the fact that at present the plaintiff, comma, along with her family are residing at a rented accommodation, comma, which itself is a sufficient ground for the plaintiff to seek to be accommodated in her own house at the suit building. Full stop. Next para. That apart, comma, the appellate court specifically enumerated the number of family members and the details of them of the plaintiff, and also came to specific findings as to the exact requirement of the plaintiff stroke respondent. Push up. Next para. Thus, comma, since the plaintiff and her family are at present residing in a rented accommodation, comma, her own accommodation at her own building at the suit premises is always has an edge EDG over such rented accommodation. Push up. That apart, comma, a finding of fact has been arrived at by the learned trial judge on the basis of evidence regarding the number of family members of the plaintiff and their specific requirements. Full stop. Next para. The matter then boils down to the finding of the appellate court, first appellate court, to the effect that PW1 had stated that the other rooms of the suit building had been let out to other tenants. Full stop. However, comma, this court, comma, sitting in second appeal, comma, is not in a position to reappreciate such evidence. Full stop. Since the learned first appellate judge has chosen to believe and proceed on the basis of such evidence of the PW1 to the extent that the other rooms of the suit building are tenanted, comma, no substantial question of law arises as to reappreciation of the same for the second appeal to be entertained. Full stop. Next para. Thus, comma, we do not find that any substantial question of law is involved in the second appeal. Full stop. Accordingly, SAT 173 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 2 of 2024 also stands dismissed. No address to cost.
But may I submit my last
Sorry,
delivered judgment.
Yeah.
There is another judgment, Narayan Dwivedi, reported in 1996 volume to CLJ another court in the division bench,
Yes.
considering section 13 of the Premises Tenancy Act. Kindly see once the page. Once. In that case, the matter was remanded back to the appellate court.
No. Next.
Application.
What is the defect? Trial court certified copy and the appeal court certificate both are defective. That is not anything for you to do. You can move the matter.
Yes. But one thing before my land senior
Yes.
starts, there are some regarding maintainability. Once he accepted the preliminary degree by filing affidavit, the appeal is not maintained.
This is against preliminary degree.
Preliminary degree.
Second appeal. Affirmance.
Affirmance.
He accepted where?
Actually, in the trial court, my lord, when I filed an application for police help for holding the commission by final degree proceeding, my lord, they filed the opposition objection. My lord, the affidavit was affirmed where he has said that during pendency of the title appeal he objected, but now he has accepted he will cooperate the commissioner. My lord, these are the copies, man. Since they have accepted, then on that basis, my lord, my application for police help has been rejected.
Application for?
Police help has been rejected.
This is a peculiar circumstance. Please take instruction.
I will take instruction.
Please, Mr. Mahato, please give a copy of this to your learned friend. একটা order record কত? Although the respondents under normal circumstances have no right of hearing at the order 41 rule 11 stage, comma, learned counsel for the defendants, respondents. You are the plaintiff respondents hands over a copy of an objection allegedly filed on behalf of the defendants stroke appellants before the trial court, where they have admitted that the defendants are ready and willing, the defendants appellants are ready and willing to assist the learned commissioner for holding the commission work and abide by the preliminary decree, comma, which was challenged in the title appeal and before this court. Push up next para. A copy thereof be handed over to the learned advocate for the appellant in order for learned counsel for the appellant to take instruction, since in the event the appellants have admitted have conceded to the preliminary decree by way of an affidavit in the trial court, comma, a question would arise as to whether the present second appeal at their behest is maintainable in law. Push up. Accordingly, let the matter stand adjourned till March 4, 2025, when it will be listed under the same heading. 5th March.
If 6, 7, I shall not be there. 5, 6, and 7, I shall.
Then tell us 3rd
Fourth, I'll and then
March 4, 2025. Take instruction, please, and let us go. Mr. Mahato, you have given a copy to him.
Appeal challenging an order dismissing injunction application.
Dismissing injunction, yes.
I was enjoying an interim order for 10 years. That has been automatically vacated.
10 years?
10 years. 10 years from the High Court. Then it was sent back because I had come up against an ad interim refusal to pass ad interim order. The High Court had directed my lord to maintain status quo in the meantime. And then, my lord, upon final hearing, the ad interim order was continued for some time. And upon exchange of affidavits, the court below was directed to hear out the injunction application. Now,
but the court can definitely come to a
yes.
difference.
Now, the court has come to a finding, the only ground on which the injunction application has been dismissed, not on merits, but on the ground that the suit itself is not maintainable under Section 34 of the SARFACI Act. Now,
13(4) measures have been taken.
Now, there was a DRT proceeding filed, but the DRT proceeding in respect of from the order it appears, DRT proceeding was dismissed on the ground of it not maintainable. Because in the suit, I have specifically challenged a mortgage, a deed of mortgage. Now, once a mortgage has been challenged, that to ground of fraud being taken, even till recent judgment of Supreme Court is also there, which says, Pallad, that this is not a challenge in respect of any action pertaining to Section 70. So a suit itself is maintainable in respect of it. Plus, there can't be part rejection. If at all there is some prayer which may relate to a Section 17 measure, but as long as there is a challenge to the mortgage, then there can't be part rejection of plaint, and the suit itself cannot be said to be hid by Section 34 of the SARFACI Act. But no merits have been gone into. The learned court below has only restricted itself to the maintainability of the suit and dismissed the injunction application. That prima facie suit not maintainable, so prima facie no scope of granting any order of injunction.
What do you say? We can dispose of the appeal itself.
That can. Lordship, only my predicament before the Lordship is that I have to take certain, because they have made allegation, fraud, etc. But from the perusal of record, I need certain documentary instruction from the bank. But the dealing officer who was dealing with the case records in respect of the loan account, her mother has died.
No, we don't propose to.
We do not.
Obviously, we cannot affirm the findings on merits. Because those will be open for this in the suit. Otherwise, how can we at the injunction stage, even the court below could not do it. So we cannot do it.
Lordship.
We can record that you are, because we are not inviting affidavits, all of the allegations made in the can are denied.
Lordship.
One. Secondly, all questions will be kept open for the trial court to be decided.
Lordship.
But we'll admit the appeal and dispose of the appeal and grant injunction on the ground that this question of mortgage itself being fraudulent, I mean, on the face of the plaint, we have to go by the plaint for the maintainability of the suit. This is not cannot be adjudicated by the DRT. And so, because 17 entire scope is, as you know, 13(4) measures, validity of the measures and all. If the root of the measures is challenged, That has to be granted by civil.
That is your lordship. But
Maintainability of the
my
suit.
only lordship, subject to your lordship approval, obviously.
So we can dispose of you. You won't be stuck up here before this.
Yes,
court.
yes. I'm not. I only beseeching your lordship if subject to your lordship
No,
approval.
no, on fraud we are not entering into the merits also.
But the fact remains, your lordship, in addition, subject to obviously kind consideration of Monday, which I am beseeching for further documentary instruction. The petition, the appellant before your lordship is challenging the fraud. But the fact remains, what is his locus standi? Who is he to challenge the mortgage?
In the plaint, what has he disclosed?
In the plaint, they are saying the lordship, though certain further documentary instruction, prima facie, lordship, I am submitting.
No, you have to proceed on the plaint which has been annexed, Master.
Yes. So the prima facie, lordship, from the document, the property was mortgaged with the bank as way back in the year 2007. The appellant came into the picture in the year 2011 by the mortgager who leased out in favor of the appellant. Admittedly, the appellant was not in picture at the time of mortgage. Now, who can challenge the mortgage? I am putting this question to myself. He is neither the mortgager, he neither the beneficiary of the lessor of the mortgager. He is not the member of the lessor of the mortgager.
Who is he?
Let's say he is claiming that he has entered into the property in question in the year 2011 as a tenant.
As a tenant of the mortgager.
As a tenant of the mortgager who already mortgaged the property in favor of the bank. At the outset, your lordship, another fact from the plaint itself would be evident. Initially, the mortgager entered into a lease agreement for a period of 12 years that was unregistered. Subsequently, the loan account has been classified as NPA in the year 2011. When the bank has proceeded under 13.2, 13.4, during the continuation of that unregistered deed of lease for 12 years, the mortgager further executed a registered deed of mortgage in their favor. Absolutely prima facie collision. The court has taken cognizance of that. From the order impugned itself, it would be evident. They are challenging. I am putting this question to myself. First of all, to challenge the mortgage, what is the locus of the appellant? The appellant is neither the borrower, nor the guarantor, nor his case he was in possession of the property prior to mortgage. Position ought to have been different. Prior to mortgage, he was in possession. Admittedly, he came into the picture subsequent to mortgage. Whether mortgage is valid, whether mortgage is not valid, borrower is not challenging. He, being a stranger, challenging the mortgage is bad, kindly declared the mortgage steps taken by the bank is bad. They have challenged the surfacing action of the bank before the Debt Recovery Tribunal. Debt Recovery Tribunal dismiss their application where they have claiming they are the tenant. The DRT order has not been upheld up to the appellate forum, DRT. They have accepted the order of DRT. Thereafter, when the bank was on the process of proceeding to recover the public money, as way back in the year 2011, it was amounting to rupees 5 crore and odd. They have filed a title suit. Title suit was ex parte ad interim order of injunction was passed. That ad interim order was, trial court refused to grant any interim order. They have preferred an appeal. The appellate court of this honorable court has granted an ad interim order of injunction. The
mortgage on which you rely is not a registered document.
That's the mortgage. There was one covenant that in case their challenge is that the mortgager has taken the property on lease from the government. There were one clause in case of default, if the mortgager mortgages the property with any financial institutions, they have to take the permission, etc.
Urban Development Department.
Yes, they have to take permission from that.
That has not been taken.
That has not been taken. That is their allegation.
So they have a right to challenge because they claim to the.
But the fact remains. Let's see the question.
That's also an arguable case.
Yes, the moot question is: can he?
And it's not a registered document. Mortgage.
Document
Lordship.
No mortgage document.
The property.
No mortgage deed.
No mortgage deed, but the property was mortgaged by deposit of title deed.
It's
Why-
an arguable question.
That is.
Triable issue means injunction should be granted.
That is your lordship. That is why I'm beseeching your lordship as to whether any permission has been given or not. One. Second, your lordship, for the sake of argument, if no permission was taken, I am challenging the locus standi of the appellant before your lordship, who admittedly came into picture subsequent to mortgage. Second. Third, he is saying the case of the appellant before
Anybody having any interest in a deed being declared to be void or invalid can file a suit for.
yes, but that
challenging
interest must be
He has
prior.
an interest.
Lordship, that interest must be prior to
Not
mortgage.
necessarily. He can come and say that that mortgage in the face of it was void because it is vitiated by fraud and non-taking of permission from the authorities, urban development authorities. Plus there is no registered mortgage deed at all. That is their contention. If there is no mortgage, they are denying that.
Yes.
And they are a person, even if they came subsequently to the property,
Yes.
they are not saying that it was fraudulently executed or
But
something
at
like
the
that.
instance of whom?
On law, they are
At the instance of whom? That is also a
they
question.
have an interest in the property. They are a lessee to the
Not
property.
by the urban, but by the mortgager himself to defraud the bank. Kindly appreciate your lordship.
They don't have. You cannot shut their right out because even if there are subsequent lessee, they can say there was no mortgage at all. They are
Lordship.
saying there was no mortgage at all. They are
Lordship,
denying that.
Lordship, may I subject to lordship kind consideration.
And on the
But
basis of
they are
that,
saying
they can't
that
evict
the urban government authorities.
Urban development.
Yes, our urban development authorities has not been informed. Lordship, kindly take
It is
cognizance
not.
of
It is
this.
not. That's an answerable question.
Yes,
Whether without that it could be
could be or not.
mortgage.
Second, my question is, lordship, if such being the case, in the suit, urban government are not the party because they are the necessary party
No.
in the suit.
If I say that to acquire title in a property, you were necessary, your vendor or your mortgager had to take a permission from some authority. I challenge that deed. The deed is executed in your favor. Necessary parties are you, your transferor, and I. The permission not being taken from an authority, no relief is claimed against them. They're not claiming any relief against the urban development authority. Rather, they're thankful to the urban development authority for not giving the permission.
Lordship, that is why, lordship, I am seeking because kindly grant me
Triable issue has been made out.
only lordship subject to lordship. Obviously,
So then we'll admit the appeal and grant injunction and direct paper books to be filed. That is the entire reason we are not required to waste our time on this. I mean, if you want to come prepared, you come prepared. We'll admit the appeal. We'll grant injunction and direct you to file opposition and come back.
Lordship, that is
We don't have any qualms with
no,
that.
but only predicament.
Bank will suffer a further delay.
Obviously, the last
I'm not
10 years, the
threatening
bank-
you. We'll
bank
do
has
that
suffered.
actually because
The bank
we
has
were
suffered.
we were going to do that because you are appearing and you are for a bank which is carrying public money. We gave this option to you. So if you say you want to use affidavits, we'll direct affidavits.
Lordship,
Arguable questions have been made out. Appeal has to be admitted.
lordship, only subject
And
to
triable issue is definitely there.
lordship, only seeking a lordship, only today's accommodation, kindly fix it on
After
Monday
hearing so much,
thereafter,
no,
lordship, subject to your kind consideration,
No, no,
lordship, because I require certain documents, sir.
Very well, we'll admit the appeal,
Lordship,
grant
that-
injunction and then fix.
because what prima facie, your lordship, of at the first instance, that will subserve the purpose of the bank. That directing the trial court, but only documented because your lordship kindly appreciate.
Can we look into any document here?
Obviously,
We
not,
cannot even look at the mortgage if there was a mortgage deed.
Yes, yes.
Only the plain pleadings and the injunction pleadings.
Yes.
So this was ex parte hearing or this was a contested hearing.
Contested.
Or you filed your written objection.
Yes.
You know, his written objection has been annexed here.
Yes.
Did you annex any further document to your written objection? You
Lordship,
cannot
that is why
furnish further documents here.
no, whatever is there is there. I cannot furnish
So
something.
those are here already on record.
That-
Why is your manager required for
Lordship,
that?
because certain document which was in his control, her mother has died. I could not be able to get access.
We can look at only your written objection. We cannot look at documents which are in control of your deceased mother's sons. He may be in control of some documents, produce those in the suit, but at this stage, at the injunction stage, how can we look into that even? Further documents cannot be looked into, Mr. Singh. Whatever is there, your written objection is before us.
If you lordship-
Surface Act is it's writ large all over your written objection.
Yes.
That is the main ground.
But your lordship kindly take trouble to
And you have Quoted
If
section
so,
65.
Lordship, if so,
I have not filed an appeal, that's why the suit is not maintained.
Lordship, kindly appreciate if such
Appeal
is
against
so.
what? Section
Against the order
17.
of Dismissal, my lord, by the saying that it's not maintainable. I filed an application before the DRT. The DRT said that my application there is not maintainable. The learned judge said that I had to come and file this suit. The learned judge said, why didn't you file an appeal and dismiss my injunction application?
Lordship, then may I,
Question that my learned
Lordship,
friend
then
raised,
may I,
my lord, was
We are
that-
admitting the appeal and granting injunction. Mr. Sir.
Lordship, instead of that, Lordship, it will, because the admission of.
No, we have heard so much, we won't another day's time.
Lordship, instead of Lordship, kindly do one thing, then kindly direct the trial court to dispose of the entire suit in a time frame manner.
Intersuit will be, that will be a pressure on the, 2014 suit. But
Yes.
because of the parties, you must have done something
No,
to
no, because of the injunction, which they have got injunction. in the
Injunction
earlier
cannot
appeal.
deter the court from taking up the suit for hearing.
Once again, your Lordship, 10 years further. Lordship, kindly direct, it will
Very
serve the purpose of all the parties.
Good.
Direct the trial court to dispose of the entire suit in the time frame manner.
Dispose of the appeal.
Any other application is pending?
Before the
Order
trial court,
7 to
yes. We have filed an application under section 34 of the Surface Act.
Section 34 of the Surface Act.
Order 7, Rule 11, in view of section 34 of the
That,
Surface Act.
that we can direct to be hard out within 4 weeks. 7-11.
And
Why and? If your section order 7 rule 11 is allowed, then we'll direct the court to dispose of the suit within a year.
the 7-11 maybe.
7-11 within 4 weeks we'll direct.
Direction, the suit to be disposed of. I wanted
Let's
that
7-11.
direction.
Let's
I'll
7
check before the order 7 to 11.
Let order 7 Rule 11 be disposed of in accordance with
Definitely
law.
direct. In view of the short conspectus of the appeal, yes, the same is taken up for hearing at the admission stage. First up, since questions of both fact and law are involved, the appeal will be heard on the issues raised on the questions taken in the memorandum of appeal. First up, next para. We take up the appeal along with the application for hearing, accordingly, on consent of parties. First up, next para. The present challenge has been preferred against the refusal of a prayer of the plaintiff appellant for temporary injunction filed in connection with a suit, inter alia, seeking a declaration
Plain press.
168. Yes. Thank you. Declaration that a purported mortgage by the lessor of the plaintiff in favor of the defendant number 2 bank is void, that the same be delivered up and cancelled, as well as that the defendant number 2 bank has no right, title or interest in respect of the suit property on the strength of such purported mortgage and consequential reliefs. Push up next para. In connection with the said suit, the petitioners sought, the appellant petitioner sought temporary injunction to the effect that the respondent numbers 5 and 6. Respondent numbers 5 and 6. Who are they?
My lord, the bank, because the other respondents are my lessors.
Respondent numbers 5 and 6 be restrained from interfering with the plaintiff ' ownership, right, title, interest, and possession over and in respect of the suit flat. Push up next para. Learned senior counsel, Mr. Chatterjee is there for the appellant. Learned senior counsel appearing for the appellant contends that the learned trial judge dismissed the injunction application primarily on the premise that the suit itself is not maintainable in view of the bar incorporated under section 34 of the Surface Act. Push up next para. That apart, it is argued that on a composite reading of section 34 and section 37 and section 17 of the said act, the suit is maintainable before the civil court, since the relief sought therein cannot be granted by the tribunal. Push up that apart, it is contended that while the plaintiff stroke appellant approached the tribunal, comma, the tribunal dismissed such application on the ground that the same is not maintainable. Full stop. As such, comma, it is a suit which is the appropriate remedy and is very much maintainable. Full stop. Next para. Learned counsel appearing for the respondent bank raises a question as to the locus standi of the appellant, comma, since the appellant came into the picture much after the creation of the impugned mortgage in the year 2011 and claims on the strength of a purported lease deed created in his favor by the mortgagor. Full stop. Next para. It is further submitted that the allegations of fraud have not been substantiated. Full stop. However, comma, at this juncture, comma, we cannot go into the merits of the allegations and counter allegations which are required to be decided on a full-fledged trial. Full stop. Fact remains that the impugned order is primarily premised on a bar to the suit on the ground of Section 34 of the SURFACE Act. Full stop. However, comma, the appellant is justified in contending that such bar is not applicable, comma, since the reliefs sought in respect of the purported mortgage, comma, which was the very genesis of the proceedings undertaken by the respondent bank under Section 13 within bracket 4 of the SURFACE Act, comma, is vitiated by fraud. Push up. As such, comma, the said relief could not be granted by the tribunal, comma, since the jurisdiction of the tribunal under Section 17 is restricted to infirmities and illegalities committed with regard to the measures taken under Section 13 within bracket 4 of the SURFACE Act and is limited to the four corners of the said Act. Full stop. Next para. In such view of the matter, comma, we are of the prima facie opinion that the suit is maintainable and as such the very premise of the rejection of the injunction application is bad. Full stop. Also otherwise, comma, in view of the measures being taken under Section 13(4) by the respondent bank, comma, we are of the opinion that a sufficient case of urgency and balance of convenience has been made out in favor of grant of injunction. Full stop. Accordingly, FMAT 407 of 2024 is allowed on contest. Oh, the other
711 is pending. That will be by
no,
this
no. The
observation.
other respondents.
My lessors. They were not on caveat. The bank
Very, on contest, comma, thereby setting aside the impugned order dated September 23, 2024, passed by the Second Court of Civil Judge, Senior Division at Barasat, District North 24 Parganas, in title sheet number 202 of 2014, and granting injunction, comma, restraining the respondent numbers 4 and 5.
5 and 6,
sorry, 5 and 6 from disturbing the possession and or enjoyment of the plaintiff appellant in respect of the suit property in any manner whatsoever till disposal of the suit. Full stop. Next para. It is made clear that in view of no relief having been sought against the other respondents, comma, service of notice on the respondent numbers 1 to 4 is dispensed with. Push up. Next para. It is further clarified that this court has not gone into the merits of the respective contentions of the parties, and the learned trial judge would be at liberty to independently decide the same without being influenced unnecessarily in any manner by any of the observations made herein. Full stop. The learned trial judge shall dispose of the pending application of the respondent numbers 5 and 6 under Order 7, Rule 11 of the Code of Civil Procedure in connection with the suit as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the trial court. Full stop. Next para. Thereafter, comma, the learned trial judge shall proceed to dispose of the suit, comma, subject to the outcome of the said application under Order 7, Rule 11 of the Code of Civil Procedure. Full stop. Can 1 of 2024 is disposed of in the light of the above observations.
Let's see, the affidavit has not been used, allegations.
It is, since no affidavits have been directed, comma, it is deemed that none of the allegations made in this stay application filed in connection with the present appeal are admitted by any of the respondents.
Liberty be given to my file a written objection to the order 711 by Monday.
আচ্ছা আরেকটা লাইন যেখানে অর্ডার 7 রুল 11টা উইদিন 4 উইকস বললাম ওখানটা লিবার্টিজ না the appellant shall file it or he or what?
It is a company.
Its written objection to the application under order 7 rule 11 of the Code of Civil Procedure before the trial court by March 4, 2025 by Tuesday.
Grateful, mother. Deeply obliged.
We have another bench there.
Let's see.
You also directed me to file affidavit, my lord.
You are for the
My lord,
contempt.
I am for the respondent contender, my lord. I am the petitioner, my lord.
Oh, you have to file affidavit regarding what?
Regarding, my lord, communication of the order, my lord. That has been communicated in time, my lord. And also, my lord, respondent number, my lord, SP, my lord, has forwarding this to the, my lord, the Deputy Inspector General of Police, my lord. That is pending. State can say all the things, my lord, contender, my lord.
My lord, as per the order, we have communicated, we have processed with everything, my lord, and now the file is pending before the Deputy Secretary, Homes and Hills, my lord. The problem is that until and unless it is approved by the Deputy Secretary, we cannot go further. From our end, we have processed everything, my lord.
So
as
can
per
you
the
file
order.
a short? Can you file a short affidavit disclosing these things so that we, if necessary, we can pass necessary directions on the secretary?
My lord, I can.
The Deputy Secretary, Home and Hills.
My
What
lord,
is the exact
Deputy
designation?
Secretary, Home and Hills Affairs Department, Police Establishment Branch, Nabarno, Howrah.
Home and Hill. Please repeat Home and Hill after that.
Home and Hill Affairs
Yes.
Department.
Yes.
Police Establishment Branch, Nabarno, Howrah. Pin code is, my lord, 711102.
My lord, reference may be short for, my lord. Memo number, other things. My lord, otherwise, my lord,
Yes, my lord, I have the
No,
memo
they'll
number
give
also.
disclosing the affidavit. You can impede the Deputy Secretary also, but at this stage, probably it will be premature. Very well. Learned counsel appearing for the alleged contender submits that all steps have been taken at the end of the alleged contender and the file is now pending before the Deputy Secretary, Home and Hill Affairs Department, Police Establishment Branch, Nabarno, full stop, unless an approval is granted from that end, the pensionary benefits cannot be released in favor of the petitioner. Full stop. The alleged contender is directed to file an affidavit in opposition to the contempt application disclosing such facts as well as the particulars and the memo numbers of the respective communications and other particulars and details in their affidavit in opposition. Full stop. Next para. Such affidavit shall be filed within a fortnight. Mr. Shantanu?
Yes,
Within
yes,
a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matters shall next be listed under the same heading.
pension matter, my lord, kindly, my lord.
No, because of the bench, because my lord has another bench. March 26, on March 26, 2025 at 1 p.m. Let us come
My
back on
lord.
that date and we'll decide.
My
Thank you. Arun, lunch for control. Mhm. What is the defect, Mr. Chakraborty?
The defect, my lord, the nominal defect, my lord, in the trial court, name of performer respondent.
Surname. Yes.
Surname. Is mentioned wrongly, my lord, by as per substitution of the plaintiff as Dotto. And in the first appellate court, her surname is Da.
Mr. Chakraborty, in the memorandum, it is the correct surname.
Yes.
Dotto is the correct surname.
DAW.
No, yes. So very well, then we'll hear the appeal under order 41 and then decide.
I am for the caveated respondent.
Right.
My lord, the suit, I am for the defendant.
You don't have a right of hearing now, so let them.
My lord, I am for the defendant appellant, my lord.
Yes.
It is a degree of affirmance.
Suit for?
Suit, my lord, for eviction as per 1956 Act, Premises Tenancy Act, and suit has been degreed only on the ground of default. My lord, the original defendant immediately after service entered appearance, filed application under 17(1) and 17(2) and 2AB. My lord, thereafter several dates were fixed. Subsequently, the original defendant became ill and he did not respond, and the application under 7(2) and 2A was dismissed without any determination, rejected. This is the language. And thereafter, my lord, the present appellant subsequently filed an application for addition of party because the original defendant died. Thereafter, he filed an application under 7(2) and 2AB, and that was rejected on the ground that since earlier application filed by the original defendant has been dismissed, so his application was dismissed. Thereafter, 17(3) was allowed, and suit was degreed on the ground of default. My lord, in the first appellate court also it has been degreed on the ground of default. My lord, I have filed an application for my lord for payment of entire amount, my lord.
Mr. Chakraborty, the 17(2) is dismissed.
Dismissed, my lord, that cannot be dismissed. My lord, your lordship.
Have you set that up as a ground in the appeal?
Yes, that is the basic ground. My lord, I have kindly see, my lord, I first of all see that I have annexed the entire certified copy. My lord, you have kindly see, my lord.
Annexed to the application?
Annexed to the application for stay.
Right. Which is the order date?
My lord, order date is, my lord, order number 64. My lord, it will appear from page 33.
Yes.
Page 33. My lord, first of all, your lordship can see it immediately appeared. My lord, first date, my lord, can see. Order number 3, page 12. Order number 3, page 12. Your lordship will find that the original defendant immediately after the filing of the suit on the next order appeared and filed 17(1) and 17(2) AB. That will be appearing from the next page. And that application was, my lord, rejected.
17(2) was rejected without any adjudication.
My lord, that will be appearing from, my lord.
Yes, we have seen that. Where is the 17(2) application, Mr. Chakraborty?
17(2) application, I have not, my lord.
Yeah, have you got a copy?
No, my lord.
Whether you raised a proper dispute, we don't know.
Yes, my lord. My lord, default is the ground. So there is a dispute.
No, 17(2) sometimes is filed without raising any dispute. Then
my
we
lord,
hold
17(2) also there, my lord. For the installment and for my extension.
We don't know whether we prayed for that.
My lord, kindly see, my lord. Then yes, my lord, that will be from the degree it will appear the ground of default is there. My lord, kindly see, my lord, page 33, order number 64. How it has been rejected.
Yes, as the defendant is found absent on call, petition rejected.
Yes, rejected.
So without any adjudication on the
yes.
dispute.
And my lord, in this context, my lord, your lordship.
And 17(3) was subsequently allowed.
And 17, that will be appeared, my lord, page 69. Page 69, order number 134. 134. Page 69. Page 69, my lord, order number 137. That will appear 17(3) allowed.
(130)?
Order number 137, page 69.
No, page 70, 138.
Yes.
It also says that no document to show that you have been depositing current rent also.
Yes, my may not be seven. There is no scope of
7-1 violation is there.
If 17 is dismissed.
17-2 is dismissed. 17-1 you have to go on making current repayments.
17, I could go.
17-2 can be dismissed by turning down your dispute.
Yes, my lord.
But still you have a liability under 17-1.
My lord, kindly see that 17 whether, my lord, kindly see.
Court records that there is no document to suggest that you have deposited current rent.
I'm referring this judgment, my lord, your lordship, my lord, kindly see.
No, then you are defaulter under 17-1.
Even if I do not, my lord, because even first of all, determination is to be made.
If no determination is made, Mr.
Suppose, my lord, there is a dispute relationship that has also been made.
Even if that is dismissed, you have to deposit, go on making the current deposits. Otherwise, you are a defaulter under 17-1.
My lord, kindly see on that, my lord, on that context, my lord.
Yes.
I am referring the judgment.
Yes, yes.
Original defendant died, my lord, they should dismiss for default. Thereafter restored. I file application for addition.
Mr. Chakraborty, have you got a copy of the 56 Act? We are handicapped because we have 97 Act is Premises Tenancy Act 1956 আছে কিনা দেখুন তখন থাকার কথা নয়।
এটা তো ওইটাই হলো আর বাকি ওইটাই একই বেরিয়েছে is judgment order. The date of 1995 দিলাম
You did not prefer a challenge to the 17-2 and you don't even deposit the 17-1.
This is a point of law, my lord. This point, my lord,
no, that is the point of law. If
Yes.
you don't make any default, if you commit a default under 17-1, there is no 17-2 in the eye of law after it is rejected. Suit is pending. 17-1 violation also entails 17-3.
My lord,
Independently also.
Unlike the present act.
Unlike the present act,
Lord,
even
we
in
have
the
brought
another
the
previous act.
judgment of on Justice N.K. Mitro, pay and stay. Even, my lord,
That is a general proposition. Mr. Chakraborty, pay and stay cannot override the statute.
my lord, I have filed application to that. I meant that I am agreeable to pay the
See,
entire.
you have filed 17-2.
Yes.
17-2 is rejected.
Yes.
You don't prefer a challenge. Now you prefer a challenge, that's a different. At that point of time, there was no challenge to that. 17-2 stood rejected. Your liability was still cast under 17-1 to go on making the regular payments.
My lord, that I'm dealing with
17-3 otherwise
My lord,
is attracted. Yes, let us see this.
First of all, let us, my lord, kindly see paragraph 14, my lord.
Yes, yes. 14.
The learned trial court without determination of the said dispute rejected the petition of the defendant under 17(2) and 2A of the Act read with section 151 CPC in a summary manner. This is not permissible under the law.
True.
The court has duty to determine the
Mr.
period of
Chakraborty,
default.
there is no doubt on that.
And my next judgment I am showing, my lord, kindly see. This is that is on that point, my lord. Your lordship.
Yes,
Yes.
the other point.
Here, my lord, 7.1 was not complied with. Paragraph 3, I am referring, my lord.
Yes.
Mr. Manoranjan Das, appearing on behalf of the plaintiff, opposite party, has contested the propriety and correctness of the submission made on behalf of the defendant petitioner. He has relied upon the averment in the application under 17(2)(a) as referred to above to show that the defendant restricted the scope of the relief to be granted by the court to the area relating to the months November 83 to February 1985, and in that situation there was no reason for them for non-compliance with the requirement of 17(1) of the Act, which is mandatory in nature. Mr. Manoranjan Das has on the other apostate basis submitted that the court below was fully justified refusing to entertain the application by the defendant and rejecting the same by the impugned order. The submission made on behalf of the opposite party are apparently attractive, but upon a closer scrutiny of the language used by the legislator, including that of the proviso to section 17(2)(a)(b) of the West Bengal Premises Tenancy Act, the said argument is unacceptable. Section 17(2)(a)(b) in its first part indicates that such sum will include the area, but in the following proviso, the coverage of the said term has been extended to include not only the area, but also all rents or amounts equivalent thereto up to the month preceding to the month in which the order in terms of the said subsection is passed. In the other words, expressly, even the current rents securing after the making of the application for installment in terms of section 17 are also to be form a part of the amount of the installment to be granted by this court. In that view of the matter, accept the correctness of the contention made on behalf of the petitioner by Mr. Mrinal Kanti Das, and held that the court below acted with material irregularity in the exercise of jurisdiction and or failed to exercise the jurisdiction vested in it by law by refusing to entertain the application. So, my lord. So,
yes, Mr. Chakraborty will admit that. Yes. You don't have a right to think. The second appeal will be heard. The present second appeal will be heard on the following substantial question of law: whether the learned courts below substantially erred in law in view of no substantial adjudication being made on the application filed by the defendant appellant under section 17 within bracket 2 of the West Bengal Premises Tenancy Act 1956, but having struck out the defense of the defendant appellant under section 17 within bracket 3 in view of non-compliance of section 17 within bracket 1 of the said act, in view of the settled proposition of law being that once an application under section 17 within bracket 2 is made, it is the incumbent duty of the court to adjudicate the same on merits and decide as to what is the actual rent payable, and upon such adjudication, the said amount, which is decided to be the rent payable under section 17 within bracket 2, being the amount in which the liability under section 17 within bracket 1 merges. Full stop. Next para. Next substantial question of whether the learned courts below proceeded on the premise that the defense of the appellant was struck out under section 17 within bracket 3 of the West Bengal Premises Tenancy Act 1956, despite there being no adjudication, no substantive adjudication under section 17 within bracket 2 comma, despite such an application having been filed by the defendant appellant, comma, by the learned trial judge. Yes. Stay of execution, yes, what do you say now?
That's occupational. Because Malar's
File it affidavit to disclose whatever is the.
yes, Malar, the appellate court has already Malar's imposed Malar 50,000 because Malar's the area is Malar of almost of 17,000
per month. Per month.
Per month. And Malar's they have not paid that.
Appellate court, which portion of the impugned judgment?
Malar's, obviously, that would be on the stay application initially.
Let us see that. Yes. Which order?
Malar's, that is not annexed.
The entire. Oh, acha, the appellate.
That is at the time of
Disclose those documents.
Yes,
We'll grant a limited stay. How soon can you file your opposition?
2 weeks.
2 weeks. In view of a substance of a prima facie case having been made out, comma, there shall be stay of all further proceedings in title execution case. In ejectment execution case number 134 of 2018, pending before the learned judge, 4th bench, Presidency Small Causes Court at Calcutta, till disposal of the application. Pushed up, the respondent shall file, the plaintiff respondent shall file her affidavit in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on March 24, 2025. Pushed up, it is made clear that the question of imposition of occupation charges as a condition for grant of stay is kept open for being decided finally at the time of final hearing of the present application. When you impose occupation charges, that will operate from the date of it. You give him. Yes.
Item 19 is in respect of an ex parte ad interim order of injunction.
Is there any section 5?
There is a section 5 in 19, 20, and 21. 20 to 22 are appeals against the extension orders. By abundant caution, I had to file separate appeals, because the principal order is in respect of item 19. There's a section 5, the order is of 7th of October 2020.
Is appearing for the first time.
Appearing for the first
Serve copies of all the section 5 in all the appeals to the respondent.
Very well, my lord.
Same between same parties.
Same parties.
Has to be between
same suit. Yes.
Very well.
Keeps it on Monday, my lord. In the meantime, I'll serve.
Within Monday, you can serve. What are you saying?
My lord, 2 more days. After 1 week, my lord, then.
Don't be overzealous. You'll have to pray for time again. 1 week also won't suffice. We'll give you 2 weeks. 2 days.
Civil court, my lord. Possibly we can. It's from civil court, so the my lord.
But the parties reside.
Yes, my lord.
You have to serve by post. The postal department can do it within a fortnight, within a week.
My lord, allow us to. It's about Bortola, my lord. Allow us to serve by hand, my lord, if it's possible. And service.
Service by hand is always. I mean, subsequently they'll come and say that.
And also to serve their advocate on record in the civil court, my lord. Both modes, my lord. It'll, my lord, save time. That's the only reason. Because I'm suffering.
Yes, the suit is pending.
Suit is pending, my lord.
Very well.
I'm suffering an interim order from which I prefer an appeal.
So this is 19 to 22.
19 to 22. 22, there is no section 5. 21, but I'll serve 22 also, my lord, if that's a memo of appeal only.
Serve all the applications and all the memos.
All the memos.
So that it's a misappeal, we may. You are coming up against a grant of injunction.
Against a grant of an ex parte ad interim injunction.
So if against grant, we won't be granting stay.
Yes.
So it will be in your interest to serve also that we can.
Yes.
Since FMAT 49 of 2025 arises out of grant of an ex parte ad interim order of injunction, and the other appeals are against orders extending the same, comma, all the appeals are taken up together. Push up next para. The appellants shall serve copies of the memoranda of all the appeals as well as the pending applications in connection with all the appeals on the respondents directly and stroke or through their learned advocate within bracket S appearing in the court below, and file an affidavit of service to that effect on the next returnable date. Full stop. The matter shall next be listed on When should you keep it? Give us a date.
My lord, 6th, my lord, 6th or 7th of March.
On March 6, 2025.
Grateful, my lord.
Thank you.
Yeah, I appear for the petitioner, my lord.
Yes.
I'm appearing for the respondent.
If this is the copy.
I will repeat.
Copy we have already given, Lordship. We received an email from them saying that
Submitting that, I have received the copy.
yes.
We have received the copy.
They gave an email, Lordship. We did
They
not
have
want
received a
an-
copy. Move
Yes.
them up.
For reason of which we have given a copy. Lordship, this is the third round of suit that we have filed. Repeated disciplinary proceedings proceeded against me. Lordship, this is the thing. Lordship, the respondent number 1 institution is my employer.
Yes.
It's INSDAG, Institute for Steel Development and Growth. Lordship,
you are appearing for all the respondents. All the respondents.
No, my lord, I am appearing for the respondent number 1. The rest of the respondents, the Bhogalandama is not
with you.
received.
Can you get instruction for
except
all?
for respondent number 4?
Respondent number 1, I have got the instruction.
No, the others, can you get instruction? Because they are officials of the same.
No, my lord, 2 and 3 are officers.
Four.
4 is a complete third party, Lordship, who has been appointed as an inquiry officer with respect to my
Very good.
disciplinary proceeding.
What is your challenge against?
The challenge is with respect to the appointment of inquiry officer. And Lordship, we had come before you, Lordship, in the previous round as well. Lordship, let me give the background. Lordship, I was appointed by this respondent number 1 association. Lordship, the post of the defendant number 3 is the Director General. Lordship, I wanted, Lordship, there was an advertisement pursuant to which, Lordship, I had applied to be considered in the post of Director General. Lordship, without, Lordship, for some reason, Mr. Pradeep Kumar Mishra was appointed, who is the defendant number 3 herein. Lordship, he is a person from, this is, Lordship, Institute of Steel Development and Growth. Lordship, it's a completely technical institution. This is for growth of steel. And this Pradeep Kumar Mishra is from arts background, has got no technical know-how of the steel business. It's from a different institution altogether. Lordship, I started digging in that why Pradeep Kumar Mishra was appointed. Lordship, this has resulted in the series of disciplinary proceedings against me.
No, you did what? I mean, you wrote letters.
Lordship, I have written letters. I have written RTI applications. What is his qualification? How? Lordship, he was very close to some of the persons. Lordship, well, whatever, that is a different suit which is pending. Lordship, I have also instituted a suit challenging his appointment. My lord, in the first, Lordship, in 2024, in January 2024, Lordship, we filed a suit when a disciplinary proceeding was instituted against me. Interim order refused. We came before this honorable court. There was an order was passed that there should not be any coercive action against me. And there was a direction that the suit be expedited. Lordship, till date, they have taken adjournments in that suit.
Not filed written statement?
No, in none of the suits, they have filed written statement. That is their consistent stand. That suit, Lordship, that is pending. Since there was an order that no coercive action should be taken, Lordship, what they did, when we went to serve the order about this, they said that we have already taken a coercive action. So, but since there is an order of this honorable court, you may function, but without any designation. You will draw salary as per the punishment that we have imposed, and all these things. Lordship, they were relying on CCTV footage, etc. The acrimony is to the extreme. When we got this order, now they issued another show cause notice. That show cause notice, it is that I am talking to the employees and all these. It is like a school, Lordship, that I am talking to other employees for too long. That is one of the allegations. Anyway, my lord, against that, Lordship, again, when the memorandum of charges was framed, Lordship, we instituted another suit challenging those
failed to obtain an interim order, Lordship, and came before your Lordships. Your Lordships had refused to pass any interim order, but Lordship has said that the injunction application should be decided within 15th February. That is also pending. Oh, reject correction. Oh, 13th of February, the injunction application has been finally rejected. We shall be coming again, Lord.
What was the injunction in the nature of? The memo of charges should not be given effect to.
Not be given effect to till, Lordship, all these issues be decided.
Yes.
Thereafter, Lordship, this was 23rd December, Lordships have passed an order. 1st January 2025, I receive an letter about appointment of an inquiry officer, which is the defendant number 4. Lordship, the defendant number 4 is not.
What was that letter? Letter regarding?
Lordship, a letter regarding appointment of the defendant number 4 as inquiry officer in my disciplinary proceeding.
That was a New Year wish to you.
That was my New Year gift.
Yes.
On 1st January, I received that.
So defendant number 3.
Defendant 4.
4 has been.
So defendant number 3 is the
obviously
is the person
so
who is issuing
officer?
show cause notice.
Yes.
Defendant number 3 is appointing the inquiry officer. And when I write a letter to the defendant number 4, because defendant number 4 is not a person of our institution, is a third party. So I wanted to know his designation, because I cannot be tried by somebody who is lower in rank than me. So when I write letters to the defendant number 4, the defendant number 3 replies, saying that you don't have any locus standi, he has been appointed as per HR manual, so you have no business to challenge his appointment. So even today in arbitration also, I am entitled to a disclosure by the arbitrator. But he says that I am not entitled to anything. Defendant number 3 issues letters, email saying that please do not bother the inquiry officer because you do not have any locus standi. Lordship, in the meantime, Lordship, another thing happened. Lordship, we come to know that this HR manual which they are relying on, and they are all along showing this as their shield, that as per HR manual, everything is happening. The HR manual has to be adopted by the Executive Council of the respondent number 1. In that regard, I have also produced a document where in the past, the Executive Council had considered this issue, and I shall also show the bylaws which show that the Executive Council is the body who should have. But the HR manual which the respondents rely on is the HR manual circulated by an email. As an employee of the institution, I know that this has not been adopted by the Executive Council. So, my lord, first and foremost, my challenge to the appointment of inquiry officer is that the HR manual on the basis of which is a complete third party is appointed. That HR manual, I have challenged that in this present suit, that is non-est, not adopted by the Executive Council. Second is, there is clear elements of bias because the person who is issuing show cause, the person against whom I have instituted a suit about his appointment, he is appointing the inquiry officer. He is not only appointing the inquiry officer, he has also fixed a fees, a remuneration, which the inquiry officer will be receiving. Usually in disciplinary proceedings, Lordship, a senior officer is appointed, and that senior officer, Lordship, decides. But in this case, a third party has been appointed, and the ground that they have given before the trial court, my lord, that there is no bar in the HR manual to choose an inquiry officer who is not a person belonging to the institution. A third party can be appointed. That is the reasoning that they have given. So,
where have you annexed that whatever the rules or procedure
Lordship,
or articles or whatever?
First, Lordship will take.
What document says that it has to be adopted by the executive?
Lordship, it is the bylaws of the respondent number 1.
So, where is the relevant bylaw?
Lordship, kindly sees page 44. The bylaw starts, but I shall 42. I'm sorry, my lord, but I shall show. Lordship will kindly comes to page 54. Lordship, I have got a clear copy. I do not know if Lordship's copy, my copy is definitely not clear. But if Lordship's copy is clear, Lordship, I have got better copies.
Not clear, but we can manage. Now, আপনারটা খুবই smart. তাহলে দিয়ে দিই better. Better copy, give a better copy.
Lord.
Yes.
The difficulty will be page.
Internal page won't tell you.
Ajay.
Clause number should tell you.
Lordship kindly takes.
Refer to the clause number.
Lordship kindly takes first the 35. There is a pen mark. Internal page 18. I'm sorry, Mother, 13. এটা পরে দেখাচ্ছি।
Which clause are you relying on?
Lordship E. Page 13. And oh, it is executive council. এটাই তো আসল মেমোরেন্ডাম দিয়ে কি হবে? এটাই তো দেখাচ্ছি, ঠিকই দেখাচ্ছি আমরা। Lordship kindly close fix clause page 13. Is there a 35 in your Lordship's copy?
13 is the first
32.
page.
I'm sorry, Madam. 32.
Give us the
Start,
clause,
first
clause
page.
number. Clause number.
1.1e.
Yes.
The executive council. Council means executive councils of the association for the time being.
Yes.
Elected and appointed in the manner prescribed by
Where is the relevant provision?
Term shall include executive council members. Now, my lord, kindly comes to clause 9.6.4, which is in the petition. It is page 80, and it is page 38 of the bunch that I have handed over.
9.614, yes.
Without prejudice to the general powers conferred, which kindly takes clause C, to make conferred above, the executive council shall have powers, and C, to make such bylaws not being inconsistent with these rules for the time being for the management of the association as
Here
they
you
shall
say
take.
there was no role of the executive council in this.
Lordship. And my lord kindly takes page 214 of my lord stay petition. In the past also, the council has considered this. Page 214. May I please, my lord? The second paragraph, in the 15th council meeting on 26 July 2001 at Ishpat Bhavan, Kolkata, in point number 6, under head Personal and Administrative Rules of INSTAG, it has been mentioned as follows. INSTAG will align its personal manual in respect of the personal and administrative rules. Lordship, this is not important. The next, again in 35th meeting of the Executive Council of INSTAG held on 19 January at Hyatt Regency, Kolkata, under point number 6.3, it was mentioned that regarding service rule of INSTAG, it was decided that there is no need to prepare a new set of rules. Instead, sale rules should be followed. So, my lord, Executive Council, this is the
What does this
of
prove?
the Executive Council.
How does this matter?
Actually, this I have, in order to show that not
Yes.
only Executive Council has the power, but in the past, Executive Council has considered this in the past. So, Executive Council has to adopt in a meeting.
This was not a bylaw, this was a service rule.
Service rule, which is a form
Service
of
rule
bylaw, my lord.
may not be, may not be, may not be. Anyway, so this is there. Yeah, these rules and regulations are there.
Lordship.
Yes. So injunction has been refused on the basis of the HR manual, which has not been adopted by the Executive Council. One. Secondly, your other contentions have not been adverted to, that that R3 against whom the allegations are, you have made allegations against his appointment. He has appointed the inquiry committee member. Plus, inquiry committee member is an outsider. You are not sure whether he's senior to you also.
Lordship, and no reply given.
And reply given on behalf of R4 by R3.
And Lordship, the trial court was swayed by the, there was one observation in the trial court order that I have participated in the proceeding.
See the order, yes.
Lordship, kindly see.
Ad interim has been refused. Yes.
Lordship, ad interim. According, as you kindly sees at the seen the record after that. According to the plain case, defendant number 3 being disciplinary authority framed charge sheet against the plaintiff with allegations of several misconduct, and accordingly the defendant number 4 is appointed as inquiry officer for conducting a domestic inquiry against the plaintiff, and the plaintiff has moved this court challenging the appointment of the inquiry officer on the grounds that there is no provision in HR manual for hiring any outsider for any domestic inquiry, and the inquiry officer so appointed is also not competent to conduct
Then
inquiry.
you also rely on the HR manual. You say there is no provision in the HR manual. You don't challenge
I
validity
have
of
made a relief, Lordship. In the plain, there is a relief that the HR manual is not there.
Now, have you taken have you made a pleading that HR manual has not been adopted by the Executive Council?
Yes.
Very
Specific pleading.
Good.
At the time of hearing, learned advocate appearing for the plaintiff submitted that the inquiry officer is functioning in a biased and predetermined manner against him in consortium with the disciplinary authority and did not reply to the clarification sought for by the plaintiff. And since the appointment of inquiry officer is bad in law, it is prayed to pass an ad interim order of a temporary injunction in terms of the prayer. Learned advocate appearing for the defendant numbers 1, 2, 3 submitted that there is no express bar in HR manual for appointing any outsider as inquiry officer, and allegations leveled by the plaintiff have no basis, and it is prayed to refuse the ad interim order.
But Mr. Ali, you have not argued the validity.
I have argued, my lord. That has not been
validity
recorded.
of the HR manual, or that he was appointed by the very person against whom you have filed a suit.
All those pleadings are there, my lord. But this sketchy order has been made. That is to.
But we never know. I mean, you may waive certain points in argument.
No, my lord. We have not waived any point. On perusal of the HR manual annexed with the petition, again HR manual is relied, which is under challenge.
Yes, because if that is your argument, then this is the thing. You say in HR manual there is no provision for appointing outsiders.
No, I have said the HR manual is not.
That is not recorded here. It's recorded.
That is Lordship. Unfortunately, that is my misfortune that the trial court did not record it. But what the trial court understood,
yes,
it has recorded. On perusal of annexed to the petition, it appears there is no bar in appointing any outsider as inquiry officer for conducting any domestic inquiry against employee of the defendant number 1, and it further appears from record that domestic inquiry has already been commenced, and the plaintiff has also appeared before the inquiry officer. Therefore, I do not find any substance in the prayer made by the plaintiff and the prayer.
You did not appear before the inquiry officer.
I have appeared and said that I will, till you do not give any reply to my clarifications, I shall not participate.
What was the clarification you sought?
185.
What was the clarification you sought? That
what is your designation?
Qualification designation.
What is your qualification? And
Ms. Ali, show us from your plaint the relevant allegation.
Before that, my lord, kindly takes page 185.
Okay. Because the court has held that in the your plaint case has been quoted here. So if you can show us that the plaint case is otherwise,
I shall.
Because it has said, it has been recorded that according to the plaint case, no provision in HR manual. So we have to look at your plaint case whether you have taken the point that
Lordship, I have
185 first. Very well.
Page 185, Lordship will kindly come. CO arrived 10 minutes late and wanted to speak for a few minutes before starting the PH. The letter he sent by mail.
CO means?
CO means
Charged officer.
Charged officer.
Charged officer. And you are also mentioning.
I am CO.
What is PO? Presiding officer. Presiding.
Presenting officer.
Presenting as a presenting.
And the judge is the IU.
All right.
The CO stated that he does not accept IO. In this case, as his 2 letters demanding professional competency of IO so far has not been replied.
So this is the participation.
He refused to participate further and left the inquiry room at 11:46. And this lordship, the trial court says, I have participated.
Show us from the plaint your allegations regarding being appointed by D3.
A petition to me, petition to set out.
Plaint has not been annexed.
No, the petition has been.
The plaint is also there. 152. What is this?
No, that is the previous round.
Previous round, and you have not annexed the present plaint. Everything else.
Lordship, we have got the plaint. Lordship.
Give us the plaint. How could you draft?
Actually, I have the plain.
You have a copy of the plain?
At least
Hand
it's
over
marked.
to you. Has to be.
Where is the
বলেছে কোনো সেপারেট HR manual নেই, সেলেক্টটা ফলো করা হয়। Email was in any event the purpose HR does not trigger specific. ওই এর কথা কিছু গল্প করে।
paragraph 33. Prasha will see.
33. Yes.
Has recently come to know that the HR manual which has been relied upon and or issued pursuant to this said HR manual in all notices, including show cause notice dated 1st November, letter framing charges against the petitioner, and the letter of appointment issued by the defendant number 3
All the points have been.
has not been adopted by the
Para 34, the rest of the points.
that 34 lordship, ABCD lordship, I have given the reason why the inquiry officer is not unfit, is not fit, is not eligible to act as inquiry officer. They cannot appoint on the basis of HR manual dated 1st September.
Lower in rank or does not have the know-how. Yes. Thank you, Mr.
And that the bias shall be evident from the fact that when I ask for clarification from defendant number 4, without any copy to defendant number 3, the defendant number 3 issues.
Have you stated that also here?
No, not copy given. Oh,
that pleading is not there in the plain.
First notice, we have not given a copy. No, I have pleaded that this goes to show that defendant number 3's reply
you have pleaded that you have written to the D4, but D3 replied on his behalf.
Yes.
That you have alleged in para 34 itself.
No, not 34, but where I have pleaded about the letters, I have said so.
You have said so. Yes, you have probably quoted here. I mean, para 34 of the stay petition is your para 34 of the plaintiff.
34 are the grounds of against.
But para 34 tallies with the para
bias,
34 of
para
the
B, 34B is lordship shall be evident from the other.
Acting under the dictates and all.
Acting under the dictates.
Anyway. So that is all, Mr. Ali?
Lordship. Na, এটা দেখা না, যেটা emailটা. Lordship kindly takes page 183. This is one of such letter which the defendant number 3 has written to us.
Yes.
This is reference to the letter dated which you have written to Gopal Mohanty, inquiry officer. Your mail containing has been forwarded. Lordship, I have not given a copy to him. Mohanty forwards it to him, to us for our information. Please note, Mr. Mohanty has been appointed as IO as in terms of the provisions of HR manual. Please refer to the procedure for imposing major penalties, etc. Page 184, the second letter that we have issued, we have given a copy. This was replied that you have, which at page 186, this was replied by at page 186 that you have no locus standi. I'm sorry, 187, that you have no locus standi to challenge the authority of the inquiry officer. So it is
in the suit. What relief have you claimed in this suit? Have you quoted the reliefs?
Lordship, I have quoted the reliefs. In the injunction application itself, it is quoted, my lord.
So
Page
show us that.
35, page para 35, page 210. Lordship will see. Para 35. And pray see, Lordship will see. Giving any effect or further effect to the HR manual.
Yes, let us hear him. Mr. Banerjee, before you hear, you formally admit the appeal, and because we are hearing this. In view of several questions of fact and law being involved, the appeal is admitted and will be heard on the grounds taken in the memorandum of appeal. So, তারপর stay application এর নাম্বারটা দিয়ে বাকিটা হবে. Yes, you have heard you on the stay. Yeah, sorry, injunction. Yes, Mr. Banerjee.
Lordship, with this regard to this employee, let me tell how this proceeded.
Yes.
First, he was not diligent in his work. So we issued a show cause notice. He filed a case. Against that, interim was refused. He came to the High Court. High Court passed an order. The matter was fixed before High Court on 10th of January, and by that time, original order passed. We served it on him. Our CCTV says that he came to the office, he refused it. 11th, he moved the matter in High Court without saying that this order already been passed. He obtained an order that no coercive action should not be taken. Be that it may be, moment we got that order, we said, all right, though we have passed the order, we will not give effect to the order. We are not giving, we have demoted him, so we will not give you any designation, not the present, nor the fund, in the disposal of the appeal. And meantime, there was a direction in the code. Now, in the code below, he has gone and amended the plaint, incorporating that the punishment given to him should be set aside because of such and such. Therefore, the appeal pending before this High Court is on a premise of a plaint, which plaint do not subsist in the court below, because he has amended
the previous appeal.
First, then he continued with this bad work. We charged for the second time, and we said, I will impose a major penalty. He gone to the court below, tried to obtain an order to stay that one. Interim order refused, Lordship. After refusing interim order, he came to High Court against that interim order, which the matter was presented before your Lordship. Then Lordship said, why this camera on him? Then I have explained, Lordship, the job was given to him on such and such date, on the April. There was a given data he has to do. He never refused. Then he never visited anyone. He could not attend it. And so far as camera is there, of course, what I found that leaving the desk table, if you go and talk with someone, just like an school, which my learned friend said, I object to it because end of the day, you are not giving me the production also. So that was no order passed, remanded it back. In the court below, I said I have not been served with, but the court given a strict direction that I should file my written objection to that matter. So, and there was an order of show cause because of the injunction refused. I was not served with any injunction application of the suit. So I moved and put up application. I said that kindly direct them, just a hearing day before. Then the other side submitted before the court that he had the copy of the stay order and the memo. So he should by this time filed it. And any event, 10th of January was the date to file his written statement, written objection. He has not done, so right to be closed. Then again, I filed another application. I said, my lord, this injustice should not be done upon me because he has to file upon me. Then they said, no, we will not give. Court also said, no. High Court said, it's all right, it's over. You should have asked before the High Court. I said, I have no imagination that it will be done. and then maybe, then the matter was taken up for the final hearing. Second charge. There also he took the same point that the person appointment was correct, he is not authorized, similar of this point. The matter injunction application is heard on merit without my written objection. I said, all right, I will rely whatever he said because it's a matter of jurisdiction he is challenging. So I argued, he lost, which my learned friend said that soon they will come before. Now on the third suit he challenged that appointment of for the domestic inquiry, the present, which is the appeal, which is lordship is saying. The appointment for this present domestic inquiry is absolutely divorce of any merit. So now lordship, the first question he read that whether a outsider can be heard or not. First, it can be a IO or not. And the second point he said, the IO should be more qualified than him to hear him. The letters are there to that extent. I will take your lordship to that. Lordship, when he said that challenge the appointing authority, because the show cause was issued by one person, who is the Director General. Moment he said you have no authority to appoint someone, then we forward and we gave them a reply that HR manual we followed that has the power, or there is no bar that I cannot appoint anyone. And it has to be for a domestic inquiry. Outsider is always better because since I issued the show cause and all other members who are working here are subordinate to me, if they hear my show cause subordinate to me, they might not be fair. So it is always better. I have engaged a retired bureaucrat, UPSC qualified person to be here. Then he writes to the IO that, see, I am an engineer and I work in this cooperative society which is equivalent to the cell. My general manager rank is higher than rank of your UPSC cat. He wrote that letter to that judge. Be that as me. Then he order sheet is this, which
this disciplinary proceeding is in respect of the second show cause notice.
Yes. There are two. One,
the
terminated into punishment.
The first one.
First. Suit is pending.
That no coercive action, that one.
That.
Very well. So that you said, you told us, right? Yes. What happened? So demoted and all.
Right. But we have not given effect.
Yes.
The differential of money we are keeping in the bank.
You said
and
that. Yes.
Now, in this matter, Lordship, he wrote that you have no authority to do this. Lordship, they have shown two orders where they have participated. Just before moving this application, their advocate on record wrote a letter which they have not annexed in this matter, neither in the court below, Chitita Bergo. Wrote the letter that I want to represent him.
Who wants to represent whom?
Charged officer will be represented by one of the lawyers. So, Lordship, first, the gentleman, Lordship has seen that first order, where he has gone, he challenged the authority, and then he says that I will not participate. Then his lawyer writes to them that I will represent. So, they have participated. It's an ad interim stage.
His representation, it's only a letter that I will represent. He may represent and reiterate the same thing that you don't have jurisdiction. Yes. That's not a participation in that sense. Participation means you submit to the jurisdiction. Challenging the jurisdiction itself is not a participation in that sense, Mr. Manage. That is not a good ground. But what about the other two grounds? One is that D3 is appointing D4. D3 against him, a suit is pending at his behest. So there is an apprehension of bias at least, even if he is not actually biased. Secondly, this manual, HR manual. What about that? Because he has produced a bylaw, the rules.
Lordship, I'm handicapped. I won't be able to hand over those documents. But if he challenged the biasness of my Director General in the second matter.
Yes.
That has gone up to division bench of the High Court before your Lordship.
That's at an ad interim stage.
Right. That has gone back. And finally, it has been decided and rejected.
In injunction, not the suit.
Right.
The suit is still pending.
So, Lordship, if I just go...
Why do you, I mean, go on appointing inquiry officer? Because you are the judge, jury and executioner. You appoint an inquiry officer where you issued the show cause notice.
Then Lordship, who I put this question to?
Somebody else? Anybody subordinate to you or anybody else?
Can it be, Lordship? Can it be?
Because the allegation is against you.
Let it be. So everywhere, then if I see it from that angle, though it has not happened, but I will try to demonstrate. Then everyone will file a suit against someone. And then that someone.
Not only the suit, Mr. Banerjee, the show cause notice was issued by you.
Yes.
And the person issuing the show cause notice is appointing the inquiry officer.
The man who issued the show cause notice, he will get the reply. He has to satisfy himself the reply is satisfactory or not. If not, then
you are judging your own show cause notice. If you are appointing your inquiry officer, your appointment of an inquiry officer being appointed by you means in a sense that you have a hand in appointing the inquiry officer. So then ultimately it's constructively you who is deciding the fate of your own show cause notice. I issue a show cause notice to you, asking you to show cause why this will not happen. And if I suppose act as the judge of that, you give your answer and I will stand by my show cause. That is a presumption. That remains. So
the
at least
notice issued against me by a judge, the same judge will not hold the contempt against me.
Criminal contempt, no.
No.
Division bench.
Even in the civil contempt. Lordship, if I go by that analogy.
We generally don't. But a court is on a different footing. We are constitutional functionaries. You are not.
Lordship. Now, but I'm just only on the point of the balance. So, Lordship, what I'm only saying here is the man who appointed, if he is the only authority in the institution to appoint, rest are subordinate, next to him is the charged officer. The other man who could have done my duty is the deputy general manager or the general manager. He is the charged officer. It's a small organization, Lordship. It's not like that after Director General, there are 30 directors. So just immediate below of my two are litigating. My next two positions are litigating against me.
Another one is also litigating.
Two persons.
There must be something wrong with you. Sir.
Must be. Must be. But then other 28 are not. Now, Lordship, HR manual when to give effect and when not to give effect. Lordship will find that the HR manual was given effect to him in the year 2022.
No, whether the HR manual is a valid HR manual not being adopted by the Executive Council. That also remains to be seen.
Remains to be seen.
If you repeatedly apply the same HR, although that's not a valid HR manual, then it wouldn't have been effective.
HR manual which I have forwarded to him by a letter in 2022. Kindly come to page 97.
Yes.
It was in September 22 HR manual. Based on the HR manual, he got his appreciation. Based on this, it was noted to him. Promotional post he got. Pace revision he enjoyed. All benefits under that he has done, Lordship. Now kindly come to the.
His appointment was also under this.
No. Appointment it was much higher.
So he enjoyed a promotion and a pay revision as per.
Of course. Everything. He is guided by this from 2022.
We refuse this. Right? I am not aware of all these things.
So from 2022, if I could use a short affidavit against this, I could have given the document sequential.
No, we can direct you, but till then you don't give any effect. We'll have to pass an identity order of injunction.
Maybe not.
Prima facie case tribal issue has been made out.
I'm coming to.
Yes.
I will.
Yes.
So, Lordship, this was given to him. Now,
Yes.
kindly see the prayer of the plate, which I handed over to your Lordship.
And we return. But we have that in our here. They have quoted the prayer.
210. Page 210 of the stick.
Yes.
Sir, 196.
No, not one.
No, 210.
21?
210. They have quoted in the injunction. They have quoted the.
No suit. 210.
So, Lordship, kindly see in suit 2, there is one other suit of 196 as well. Lordship,
But we are not dealing with that.
no, we have to, because the same prayer was there.
Page.
No, he has not annexed it.
Achha.
Lordship, I will hand over.
There are how many suits? 2 suits. One is challenging your appointment. I mean, appointment of 3.
196. Kindly see this. That's why I said that all these suits has to be.
This is a different suit, not
This
the
is a
present.
different suit, but the prayer kindly see. And there, again, the interim order has been rejected.
Now, are you sure this is a
Yes,
different
yes,
suit?
196.
196 is this suit.
This suit.
196 of
Exactly same relief.
2025.
Can it be?
Kindly see the prayer of 196, which I have.
That is the present suit, not a
Yes,
previous suit.
Yes, I have handed over to you. Lord.
You are trying to give an impression that this is a previous suit.
Now, Lordship, kindly see this.
This is quoted in page 210.
Now, kindly compare this prayer with 2190.
This is an injunction application.
Plain Lordship is there.
Yes, it is preceded by a plaint, right?
Kindly see the
The
injunction.
challenge to the show cause notice. Show
There,
cause notice.
kindly see there what he has challenged. What I wanted to see.
No further effect to the show cause notice.
Lordship, kindly.
It's a completely different
Is the
treaty.
injunction Lordship is looking at, or the.
You check up. You check up. That's on the show cause notice, which he has challenged there. And this is on the HR manual.
Lordship, kindly read prayer C of the present plaint.
Yes.
And vis-a-vis, I will read out loudly the prayer of the earlier suit,
yes,
which is also rejected. (1024) plaintiff. 1024 plaintiff. Permanent injunction restraining the defendant from giving any effect or furtherance effect to the HR manual issued on such and such in connection with disciplinary proceeding pursuant to his letter of appointment such and such. So the entire manual is not under challenge, Lordship. Even in this suit, when he said that the manual is not applicable to me, he is not challenging the manual of the HR manual. He is only on the point of appointment and the issues of the show cause. Now, Lordship, so far as the show cause notice is concerned, he has lost his battle, at least to the trial court. Interim order tested by High Court. Now, when he could not find any space in that show cause notice, because
no, but he is not challenging the show cause in context of the show cause. He says in connection with disciplinary proceeding pursuant to the letter of appointment.
That means?
So that is the letter of appointment of defendant number 4. He says HR manual cannot be adopted for appointment of defendant number 4 in that limited context. And he wants a stay or injunction on defendant number 4 acting as an inquiry officer basically. On the pursuant to that HR manual. And we shall not go beyond that. Even if we grant injunction, we cannot go beyond that. Only the appointment of the inquiry officer, we cannot stay the show cause notice or injunctive from operating on the show cause notice. The initial show cause notice, no. That is beyond the scope of this suit. So that has been refused to them also.
Lordship, if I need to be fair before you, Lordship,
you can appoint a different
no, then I will come back with the instruction tomorrow with regard.
Yes.
In that case, Lordship.
Show cause we won't touch.
No, in that case, Lordship, he has only with the
inquiry officer.
Inquiry officer.
And you are appointing the inquiry officer.
Lordship, what I will do is, I will come back with the instruction.
Yes.
Lordship will appoint someone who is retired from Calcutta High Court, not even district level. So there will be nothing less than any fairness than that.
High Court judge may not agree to this.
We will try to pursue. Because otherwise, Lordship, again,
Okay,
I
it
might
can.
face a question tomorrow.
True, you are right.
So I want to keep
That's
my-
absolutely fair.
So, Lordship, so far as my proceedings is concerned, I will not spare.
Mr. Banerjee, you can no, the other point, that
So,
does not mean that
inquiry officer,
Inquiry
he is not
officer.
liking a bureaucrat, we will substitute not by me, not by him, not by my director.
say there is no other superior officer to him in this institution than you.
President, there is president. Defend number
President
2.
is-
No, Lordship, that we will not go into. Then again, I have to show that he is
No, no.
also, he is not in big allegation is there.
We can
Then
appoint the
I
president.
am much known to the president, so I have been
Mr. Ali, take instruction whether you have any difficulty with the president. If we appoint,
President? Inquiry officer.
you know the president well.
I do not know, my lord.
President is who?
President is a director of the Tata Steel or SAIL or someone.
Lordship, kindly not from my organization, Lordship, but I will say, I will take instruction, come back, retired judge of my court is.
I'm able to the
Find
I'm
out
sure
a.
my lord can pursue
You
someone.
will agree to the president.
That is my instruction.
Because he will never get a chance to do it because he is in London. So
Oh,
he
No.
said, Lordship,
Who is in London? Now this is from South. Who is in London?
who is in London? Let us see.
Tell me.
someone will be sitting.
President of this your institute.
Sir, my institute, but this is a president from the nominated members. Maybe he will be in an ivory tower. He won't be able to continue. Lordship, kindly, I will not get into that.
What is the name?
I will not get into that, Lordship. I will prefer anyone of your.
No, if he's in ivory tower, you're also in ivory tower. You're the director general, who has more powers on the practical field than the president.
No, but I
President may have much more time than you.
And had bettered me.
Much more time than you. We'll appoint the president. Let us appoint the president here.
Lordship,
Take instruction.
I
Take
will take
instruction.
instruction, Lordship. Then otherwise, I
No
still-
district judge or high court judge will do. They don't have any technical know-how about this.
Lordship need not do. Only because I have charged that you have not worked. My case
We
is.
won't appoint a high court judge to look into
Service
CCTV.
matter, Lordship, my
CCTV.
High Court judges are hearing every day.
Yes, they're hearing in
We
the
can
appeal.
pursue one.
No,
You're-
we won't
Lordship,
appoint a high court judge to look into your. No, not to look into your CCTV footages, whether he's going to the washroom or whether he's eating,
Talking to somebody.
eating some
May not be that come.
peanut
in the
butter.
evidence. May not that come in the evidence.
No. Disciplinary inquiry, your officer, why not the president? What is the difficulty with the president? Your president feels himself to be superior than a high court judge.
With the president will
Say
get
that
to
if he
know
does
about
that,
the
many
defendant
people
number
do.
3.
Many people feel like that.
Unless they
So
see
but
unless
if he
they-
feels like that, then we won't appoint him.
unless they see
We can
the
appoint
background,
you,
they do not
you, Mr. Banerjee, you.
Lordship.
We can appoint you as the. We have full faith in you.
আমি তো রক্ত মাংসের মানুষ কখন কি করে বসবো
Everybody is a রক্ত মাংসের মানুষ. Nobody is beyond রক্ত মাংস.
So, Lordship, I will come back then tomorrow with the instruction and then
President.
Lordship, I might not
Then we need not go into so many things. We'll set aside the impugned order. No, then won't be any necessity for. Yes, the suit will be infractious. The suit will become infractious. This suit.
In fact, all these suits, my lord, these can be decided summarily.
No, the rest cannot be. The show cause notice remains.
Not before your lordship, but
when the court
even
sometime
when the court takes it up, all on the basis of papers.
on a lucky day everything can be decided in a single way.
No, not that we won't force anything on anybody. He has to take instruction.
Let me come back. Let me come
If he
back
can
tomorrow.
take that instruction, otherwise we'll think about some other option. Maybe some retired district judge you can think of, or somebody else. Or you can agree, or council may also prepare a list of judges and approve it through your.
Tomorrow I will find another suit where my name is.
No, it will be an agreed order. Mr. Banerjee, you don't understand. There can be an agreed list. I mean, an agreed person from a list. You can also supply a list of retired district judges or whatever. It will be an agreed man or woman. Agreed person. During hearing, so are we hearing the appeal itself? I mean, because the injunction, on consent of parties, the hearing of the appeal itself along with the application is taken up. So at this juncture, learned counsel for the respondent seeks a day's adjournment to take appropriate instructions on issues which have arisen during the hearing of the matter. So accordingly, let them at tomorrow. We shall keep it tomorrow or next week.
Next week will be better, Lordship.
Very well. তাহলে a days adjournment না করে 6 an adjournment. Accordingly, let the matter stand over till March 4, 2025, when it will be listed under the same heading.
And
Try to agree on the precedent. That will be easier for all of us.
in the meantime, respondent number 4 should not call any meeting, my lord.
If they call, we'll think about that.
If he goes, then everything goes.
And it doesn't go.
No, he won't be calling a meeting. We hope he won't be calling a meeting after this. Mr. Banerjee himself will see to that. Yes.
Great.
I'm much.
Yes, Mr. Mathi, what is the matter?
This is the order 13 and rule 1 and 2 has been, my lord, the refused.
No caveat.
No caveat. My lord, the things for this is the preemption case, my lord, in terms of the Mohammedan Act, Mohammedan rules.
Right.
Now my lord, kindly see the order impugned. The order has been, my lord, the only things, my lord, has been, my lord, the refused at this stage. My lord, kindly appreciate to that. But the urgency in this case, my lord, so far I am pleading in the, my lord, the application and injunction application. Your lordship kindly look at, my lord, the injunction application answer P2. What I am prayed for ad interim injunction, my lord, what is it prayed for and what is the needed at the out the immediately.
You are in possession. You are the.
This is the co-shared properties, my lord. These are stranger purchaser has purchased.
You are the preemptor. I
I'm
mean,
the
you have filed a suit for preemption under the Mohammedan law. You have sought for injunction regarding your possession and change of nature character. Aren't these contradictory? If they are not in possession, how can they change the nature and character?
Kindly appreciate to that, my lord. I pleaded in my application. My lord, during, my lord, the pending of the case, my lord, some valuable trees has been cut down.
Then they are in possession.
No, they forcefully.
They included and cut the trees.
Yes, my lord, that is the case. And apart from that, they are, my lord, trying to change the nature and character of the position. By virtue of the started the construction without having the permission from the competent authority.
If you are saying he has started construction, Mr. Maiti, you cannot be the same bed.
Illegally.
Illegally or legally, then you cannot be in possession. If he has started construction on the property, cutting trees on the property.
Appreciate to that.
These are contradictory submissions.
What is the nature of the land? Nature of the land is the pond and the bank of the pond.
So where is the question of cutting trees? From the bank?
From the bank of the pond. Valuable trees has been cut down. In the allegation. And it's trying to change the nature and character. But some protection be given. Interim measure, let the come before this court.
Where is your pleading?
My lord, the kindly see application, my lord, annexure P2. Page, this is the injunction application, what I am prayed for. This is the praying portion, my lord, the page, inner page 7, page 31.
Urgency আছে মনে হচ্ছে টেনশন কেস করছি যে আমি ডিসকাস করে The appeal will be heard on the questions raised in the memorandum of appeal. Push up next para. We find from the impugned order that a prima facie case, that despite a prima facie case for injunction having been made out by the plaintiffs stroke appellants, who have filed a suit for preemption under the Mohammedan law and sought injunction to protect their possession in respect of the property as well as the nature and character of the property during pendency of the suit, the learned trial judge failed to advert to the extreme urgency involved. We find from the averments made in the application, injunction application in the code below, that a strong case of urgency has been made out inasmuch as it has been alleged that the respondents are trying to stack building material on the suit property as well as include into the suit property and fell FALL trees standing on the same. Next para. Since at the ex parte ad interim stage, the court has to proceed on the premise that the averments made in the injunction application are correct, we find that the learned trial judge ought to have granted an ad interim injunction to protect the possession of the plaintiffs as well as the status quo regarding the property. Push up accordingly, the respondents principal defendant, your player is only against principal
Principal respondent number 1.
আচ্ছা যেখানে রেসপন্ডেন্টস করে গেছে ওখানে রেসপন্ডেন্ট 1 করে দেবেন accordingly the principal defendant stroke respondent number 1 is restrained by an order of injunction from disturbing the peaceful possession and enjoyment of the plaintiff stroke appellants in respect of the suit property in any manner and or from changing the nature and character of the suit property and stroke or from alienating or transferring or creating any third party interest in respect thereof till disposal of the present application. Push up next para. The appellant shall serve a copy of the memorandum of appeal along with the injunction application on the respondent number 1, indicating that the application shall be listed next on March 24, 2025. Full stop. Next para. Affidavit in opposition, if any, shall be filed by March 10, 2025, and reply thereto shall be filed on the next returnable date. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date.
Much.
25 টা ডাকুন 25
It was admitted.
Yes.
And I agreed to serve notice upon all the respondents. I've served notice.
Appeal was admitted.
I do remember that on that day, 8/1, 2025. 8. I agreed to serve notice upon all the respondents.
Yes, it was admitted. এটা অর্ডার 41 দিয়েছেন কেন মেনশন হচ্ছে অর্ডার 41 বলে নাকি না অর্ডার 41 থাকবে না তো অ্যাডমিট হয়ে গেছে
No stay as but also directed me to serve copy upon the respondent bench. This is
the proper service has not been effected. 2 of the envelopes, no such person found. And addressee cannot be located. So you have to serve again.
from their own address, I have from the plain address I have served.
What is the challenge against?
Challenge against the order of interim order of expediting interim order of injunction. The case is
You served at their plain address.
yes, ma'am.
Let it appear under the appropriate heading tomorrow. Because since they're not appearing, we'll keep this on record.
I did.
We find that the appeal has already been admitted by an order dated January 8, 2025 and is accordingly appearing under the heading Order 41 Rule 11 erroneously. Full stop. Next para. Let the matter be listed under the heading application. Full stop. The affidavit of service filed today be kept on record. Full stop. Although 2 of the respondents have not been served, comma, it is pointed out by learned counsel for the appellant that the service has been effected at the addresses of the plaintiff's respondents as given in their own plaint in the code below. Service was directed only on 1 and 2 plaintiffs.
All. I've served all. All are served only to one.
Only the plaintiffs have returned.
Yes, ma'am.
The 2 returned ones are the plaintiffs. No.
No, we are the defendant there.
No. You are not correct, sir. With deepest respect, no. Because the plaintiffs have been served. Both of these which have returned, one is Maluti Mahato and the other is Sulekha Mahato.
Yes.
They are not the plaintiffs. They did not.
They are defendant.
If they're defendant, the premise is wrong. They did not give that address in the plaint.
No.
So you have to ascertain their address. What is the suit for?
But they are dependent there. Plaint is
Suit is for what?
suit for partition.
Then all have to be served.
And admittedly, my lord, since
এই একবার সংক্ষেপ লাস্ট কি বললাম বল we find from the affidavit in opposition that affidavit of service that two of the respondents, namely Malati Mahato and Sulekha Mahato, have not been properly served. Full stop. Next para. Injunction was obtained by the plaintiff only.
my only plate.
However, comma, since the present appeal has been preferred against an injunction order passed at the behest of the plaintiff respondent numbers 1 and 2, they have been served.
Yeah.
Who have been served, comma, further service on the other defendants took further service on the other respondents, comma, who are defendants in the courts below, is dispensed with for the present. It will appear, the application will appear tomorrow. We'll take up the application. We are directing this because somebody might be watching for the application heading.
So I pay for maybe I appear as application.
No, it's our mistake, not your mistake.
No, unfortunately.
It's our mistake. It should have appeared under the heading application.
My lord.
So, Jain, this you did not agree, but we cannot spend so much time on an order 41 rule hearing matter. We have decided we cannot go on. Either we cancel the part heard, or because already we have spent so many days on at the order 41 rule 11 stage.
Because
Either we are hearing out the appeal itself because we are also asking for written notice.
Lordships can hear out the
Or
appeal.
no, you said on the last occasion that we gave that proposal to you. You said that you are agreeable to the appeal, this being the appeal hearing.
Yes, my lord.
You are also agreeable to that. So then we are hearing the appeal. Then we please conclude today, sir. Jain.
I will try to, my lord.
এটা কি?
May I just point out?
Yes. Yes.
Lord, we had filed certain documents before the trial court.
Ah.
The defendant number.
You want to bring those on record?
I would, because my lord, from our end, my lord, the documents are not. At least I haven't been able to find them in the paper.
Have you got those? Have you got the copies of those documents?
Lordships will
Yes,
kindly
my lord.
ask my learned friend, my lord, as to how they filed the documents, if at all they filed it, my lord.
But I'll indicate one thing.
By way of a filicity. By way of, we did not file any affidavit, but we filed it by way of a filicity, and copies were furnished, my lord.
Filicity, but this is against an injunction order.
Yes, my lord.
Yes. So, my lord, final hearing of the injunction,
Ah.
during we were heard, and it's recorded in the impugned order that we have filed certain documents before the
But
court.
those documents have been referred to in this.
Yes, there is a reference. Maybe all documents have not been referred to, but there is a reference to the fact that I have filed certain documents, and those documents, my lord, have been relied upon.
But were they considered by the trial judge?
My lord, they had, my lord, that was one of my point of argument, my lord, that the documents, my lord, which have been tried to be filed by way of written submissions, my lord, have been taken note of.
No, we cannot look into those.
No, not a written submission. By
Written
way of a filicity.
I will show you.
Filicity doesn't mean anything. What is a filicity? A list of the filicity means a list of documents.
Meaning of the word.
Filicity means a list.
So, correct. So a list with
Filicity, if it's
bunch of documents,
bunch of filicity is a list.
but there is.
Filicity is a list of documents. That does not mean anything. That's not a part of your pleadings.
May I just clarify, my lord? Your lordship has, my lord, now your lordship knows about the matter at some level. My lord,
We knew. We are forgetting every day because it's continuing for so long.
the deed, my lord, the deed in question, the deed which
See,
is-
the injunction application has been decided finally.
Yes.
You must have filed your opposition or objection, written objection in the court below.
No, my lord, we were supporting the plaintiff.
Then we cannot look into your
We
documents.
advanced
We cannot do. But Filicity won't do.
because, my lord, reasonings have.
Whatever is there in the written objection and the annexures there too, we can look into. Whoever has filed the written objection and the injunction application, of course. Documents we cannot look into which are not before the court below. The court below, the trial court would not have looked into those documents.
Then, my lord, then kindly allow me that liberty that in the process of making my arguments, if I have to bring something to the court's notice, which is not alien to the impugned order, then your lordship
No,
will
we
allow-
cannot. If this was an ad interim order, definitely we would grant you that liberty.
This is not an identity.
This is the final order of injunction. You got your opportunity to file written objection. You did not. You cannot permit you to rely on certain other documents which are not there before the trial. No other document. Whatever is there is there.
Very good.
We don't have any other option because in law we cannot look into those documents, nor could the trial court. If that is one of his grounds, he succeeds already.
No, which is why I'm not pressing too hard.
Don't do that because we cannot. Yes, Mr. Jain, complete your arguments today.
I will try to, my lord.
What try? Yeah, we'll give you 15 minutes more. We have already given you so many days.
My lord, Lordship, possibly I should be able to conclude. Lordship will kindly
Possibly you should be.
Possibly.
We have given you already 3 days.
My lord, possibly
No,
Lordship
no.
cannot, my lord,
We can,
my
we
lord,
can.
that Lordship cannot complain, my lord, that I have been slow, my lord. Or my lord, or I have tried to
No,
waste
no,
the
no,
Lordship's
no.
time. My lord, possibly,
Pinpoint.
my lord.
In a pinpoint. In an injunction appeal, we won't grant you more time.
Because
We have to
because
pinpoint.
of Lordship will
If you are
kindly
before a formal arbitral tribunal or arbitral institution, you'd be done by 15 minutes.
before arbitral tribunal. No, sir, it's for Lordship.
Arbitral institution? No. Yes, yes.
Institution, my lord, I do not have any personal, my lord.
So let us pretend to be a foreign court. We'll give you
Lordship.
15 minutes, Mr. Jain, complete your arguments. And if file your written notes, we'll take written notes from.
Lordship will kindly take fourth volume, my lord.
Fourth volume, very good. Yes.
My lord, on last occasion, I was trying to rely on the order passed by another coordinate bench of this honorable court, my lord, at page 453, my lord. Page 450. I'll just, my lord, try to quickly, my lord.
Yes.
Take your lordships. Page 453, lordships.
450.
Order of first.
Yes.
Lordship will kindly recollect, my lord. This, my lord, order was passed pursuant to an affidavit which my lord will find starts at just 2 pages before that.
Yes.
Just for continuity, if my lord kindly permits me to page 452 once, my lord. So page 452, my lord. Lordship, paragraph 5, my lord.
Yes.
We have no objection and hereby accord our consent if the said premises number so and so be mutated in the records of the statutory authorities at Mumbai in the name of Sri Pradeep Kumar Gandriwala. Lordship will kindly.
You reminded us that Pradeep Kumar Gandriwala, not
Which
HUF,
not the
is HUF or Vishwanath HUF.
Vishwanath Gandriwala. Now, my lord will kindly permit me.
Yes.
Please. It is interior. Sorry, my lord. Page 453. It is interiorly submitted by the learned advocate for the petitioner that the concerned property described in the sale certificate issued by the Commissioner of Sancheta Investments, which is Annexure B to the present application, is sold in auction by the Sancheta bench under order dated so and so being Annexure A to the writ petition. It is further submitted that Sancheta Commissioner pursuant to the sale certificate issued in favor of Vishwanath Gandriwala HUF delivered possession of the concerned property to the said HUF. It is submitted that Vishwanath Gandriwala was the Karta of the said HUF and he died leaving behind his widow and 5 sons including Pradeep Kumar Gandriwala. It is further submitted that by the learned advocate for the petitioner that Pradeep Kumar Gandriwala. Now, Lordship will kindly mark this because, my lord, what the plaintiff has alleged, my lord, is that he alleges that this is an act of fraud by me before this honorable court. What he says, my lord, it is further submitted by the learned advocate for the petitioner that Pradeep Kumar Gandriwala is now the Karta of the said Hindu undivided family, which is now said to exist under the nomenclature of Pradeep Kumar Gandriwala HUF, my lord. The present petitioner. The petitioner wants the name of Pradeep Kumar Gandriwala HUF to be mutated in respect of purchase property in the concerned record of the respondents numbers 2 to 6. It is further submitted by him that the other heirs of Vishwanath Gandriwala has no objection to the same and affidavit. Lordship, the lordships were referring to the affidavit of the previous. Support of no objection has also been affirmed. On the same hand, the learned advocate for the Commissioner of Sancheta Investment submits that the Commissioner has no objection in the matter since the property in question was sold by the Commissioner in favor of Vishwanath Gandriwala HUF. Since the property in question was undoubtedly sold in public auction and a sale certificate was also issued by the Commissioner, we need not get into the question as to the status of the present claimant and only direction to the respondent numbers 2 to 6 to give effect to the said sale certificate to be issued by the Commissioner of Sancheta Investment, which is Annexure B to the writ petition by making necessary, Lordship will kindly mark this, by making necessary mutation in accordance with law after giving an opportunity of hearing to all interested parties, including the petitioner within a period of 3 months. So, my lord, their lordships, my lord, gave, my lord, opportunity to everyone, my lord. If anybody had any objection, they could have raised objection, my lord. My lord, pursuant to this, my lord, and lordship will kindly, my lord, bear one thing in mind, lordships, my lord. This order was passed in the year 1999, when the plaintiff, the respondent number 1, he was a minor. This decision to have the property mutated in my name was taken way back in the year 1999. Then comes, my lord, the deed of declaration. If lordship turns over page 456, I will not trouble you, lordships. My lord, this is, lordships will recollect, this is that deed of declaration, my lord, which has been executed outside the jurisdiction of the learned Alipur court, my lord.
This is regarding the Mumbai.
This is regarding Mumbai property, executed, my lord, within the territorial limits of this honorable court or at best city civil court. but my lord, not before the learned court at Alipur. This also has been stayed, my lord. This deed of declaration has been stayed. Stayed.
By which?
By the impugned order.
What?
By the impugned order, this declaration is also.
Yes, yes, you said that. Yes. That was the starting point of your beyond jurisdiction.
So, my lord, I am not troubling your lordship. The declaration starts at page 456. My lord, runs only one paragraph, my lord, if lordship kindly permits me, of this declaration. Page 461. Straight away, my lord, if lordships. Declaration signed by all my brothers, my mother.
Sorry, page 450?
461, my lord. 456, my lord, the declaration.
Yes, 460.
Lordship straight away, lordships comes to page 461, my lord.
Yes.
461. Last two paragraphs, my lord.
Yes.
We do hereby confirm, accept, agree, paragraph 6, my lord. Accept, agree, declare and ratify that we had not and we do not have any objection to the mutation of the name of only Pradeep, only, my lord will kindly mark this, only Pradeep Kumar Ganeriwala HUF being recorded in various offices under the Collector of Mumbai, Mumbai Municipal Records and also records of City Survey Office, and all concerned records as being, the lordship will kindly mark this, as the absolute owner of the said property, with khas possession of the said property, having heritable and transferable title of and all kinds of right, title and interest, to the exclusion, my lord, to the exclusion of Srimati Savitri Devi Ganeriwala, Deepak Kumar Ganeriwala, Dilip Kumar Ganeriwala, Manoj Kumar Ganeriwala, and Rajiv Kumar Ganeriwala, who have already disclaimed, renunciated and released their right, title and interest. Well, this was.
What is the ground of challenge to this by them?
Saying that there's no ground saying that I was major. He says, but my lord, he is not a signatory. Lordship will kindly bear. The plaintiff is not a signatory to this document.
My lord, I am extremely sorry, my lord, for interrupting my learned senior friend. I appear for the respondent number 5, my lord, in this matter. My lord, there are certain documents which were part of the trial court, my lord, that have not been brought on record. Those are my instructions.
Part of the trial court means?
My lord, these
part
were
of
before,
what?
My lord, the injunction application, my lord, which was heard out, my lord, pursuant to which, my lord, the
part of what document? What any part of the
written submission? A written submission that was
written
filed.
submission we won't look into. We cannot add documents by written submission.
Written
Mr. Sen, you have already answered Mr. Lakmani on this. Please don't disturb the court on this repeatedly. Different respondents come up and take the same point. This is not permitted before this court.
Well, my instructions are these were given.
Whatever be your instructions. The same question Mr. Lakmani raised, we said no. You come in later or you were there, we don't know. You raise the same point again. We are specifically saying whatever document was a part of the pleading, we'll look into. Written notes of arguments, you cannot add any documents.
It's not a written notes of
So why are you repeating the same thing?
It is not a. I'm sorry, my lord, just to clarify.
No, don't disturb the hearing, please. Take your seats. Both of you take your seats. Yes, Mr. Jain, continue. Repeatedly, the same thing is being continued.
Sorry, my lord.
Yes, please continue.
Khas position of
to the exclusion of these people, yes.
These,
Their point is that who was a major? Who was a minor? Plaintiff was a minor.
Plaintiff was a minor.
But he was not a signatory to this. So that does not.
No, he was not a minor, my lord. It's not a case he was a major. He's shown
sorry, he was shown as a minor.
He was shown as a minor in the deed of partition. He is nobody in this document.
All right.
So, and my lord, none of the signatories have challenged this. Now, the only thing is, my lord, they are supporting the cause of the plaintiff because, my lord, it inures to their benefit. Right, title and interest to the exclusion of Srimati Savitri Devi Ganeriwala, Deepak Kumar Ganeriwala, Dilip Kumar Ganeriwala, Manoj Kumar Ganeriwala, and Rajiv Kumar Ganeriwala, who have already, lordship will kindly mark this, who have already disclaimed, renunciated, and released their right, title, and interest. My lord, this, my lord, dates back to 1998-99.
Yes.
In the said property to be held and owned absolutely by Pradeep Kumar Ganeriwala HUF, free from all their claims, rights, and disputes, and also free from all encumbrances created and suffered by others. Then, my lord,
read the entire make your point.
Now, my lord, I'll again trouble your lordship with the impugned order, my lord. My lord, if 560, lordships 569, my lord, sorry.
We'll just take the memorandum. You can refer to the internal page.
Internal page 6, my lord.
Yes.
Paragraph 9, my lord, I had last occasion, my lord, I stopped at paragraph 8, para 9.
9.
The defendant number 2, defendant number 2 is my lord me, the appellant. The defendant number 2, defendant numbers 1 and 3 to 6, and defendant numbers 23 and 24 in the meantime amicably and mutually decided to dissolve Messrs. Vishwanath Ganeriwala HUF and partition, divide, demarcate, allocate, and distribute all the properties and or assets left behind by late so and so, which formed part of Vishwanath Ganeriwala HUF, so as to avoid any dispute and or acrimony between the family members in future, and also to enable the parties to own and possess the properties individually in terms of settlement and or partition to the exclusion of the others. The defendant number 2 and defendant numbers 1 and 3 to 6 and defendant numbers 23 and 24 accordingly from time to time held discussions and entered into agreements and or understandings with regard to the properties forming part of the then Messrs. Vishwanath Ganeriwala HUF. Pursuant to such agreements and or understanding, some of the properties of the then Messrs. Vishwanath Ganeriwala HUF stood conveyed, transferred, assigned and assured to the respective allottees. Then sometime in or about November, December 2008, the defendant numbers so and so and others arrived at a final family settlement arrangement in respect of all the remaining properties and the assets of late Vishwanath Ganeriwala and or Hindu undivided family being Messrs. Vishwanath Ganeriwala HUF. In furtherance of such family settlement arrangement, the defendant number 23 and 24 and others entered into a deed of partition, which is subject matter of challenge, dated 2nd of December 2008, pursuant to which the then Mrs. Vishwanath Ganeriwala stood partitioned, divided, demarcated, distributed, and allocated to the respective allottees. The aforesaid deed of partition and settlement dated so-and-so was presented for its registration in the office of defendant number 25, who, after accepting the same, was pleased to issue receipt number so-and-so, also having serial number so-and-so. However, due to non-payment of deficit stamp duty and registration fees, the completion of registration of such deed was kept pending for number of years. The defendant number 2, in the meantime, on September 11, 2023, paid a sum of rupees 49,68,858 only to registering the authority. My lord, lordship, if lordship wants, my lord, lordships can skip, my lord. These are my submissions.
These are the submissions.
These are submissions, my lord. My lord, paragraph 13 is little important, my lord, kindly. Paragraph 13, internal page 8, my lord.
Yes.
In the facts and circumstances as aforesaid, Commissioner Sancheta, lordship will kindly mark. Sancheta Investment Bank indenture dated 7th of July 2009, sold, transferred, conveyed, assigned all that piece and parcel of land measuring so-and-so, being premises number R154 Juhu Tara Road, Mumbai, so-and-so, and in favor of the HUF of the defendant number 2, being Messrs. Pradeep Kumar Ganeriwala HUF, which indenture was duly registered in the office of Sub-Registrar of Assurance at Bandra under serial number so-and-so. The defendant number 2's family, that is Messrs. Pradeep Kumar Ganeriwala HUF, thus became the absolute owner of the piece and parcel of land measuring so-and-so, having land bearing CTS number 870 of village Juhu, Taluka, Andheri, district Mumbai, suburban district, as mentioned above. The defendant number 2's HUF, while became the absolute owner of the aforesaid property at Mumbai, got its name mutated in the office of the Brihan Mumbai Mahanagar Palika. The said HUF also got the aforesaid property mutated in the records of City Survey Office at Mumbai. By several acts of defendant number 2's HUF has been owning, possessing, enjoying and using the aforesaid property and reaping benefits therefrom. The defendant numbers 2 HUF from time to time, letter, lordship will kindly mark this. From time to time, my lord, I have been letting out the property. I have been getting rent, my lord.
This is your case being narrated.
This is my case.
Yes.
The defendant numbers 2's HUF from time to time let out and or part and or portion of the said property on rent and or lease and or license basis. The portion of property which has not been let out and or leased out is thus always been in exclusive possession of defendant number 2's HUF. There was no existence, now my lord will also mark this, there was no existence of R154 Juhu Tara Road, Mumbai, or the property having CTS number.
Mr. Jain, what is the use of reading this? You have already argued these. These are your submissions. So why repeat?
Thereafter, my lord, if lordship kindly turns over, now comes, my lord, submissions. Next page, page 9. Page 9. Internal page 9 of the...
Where is the decision portion? Let us see the decision portion. Let us first see the decision portion, we'll come back. Where is the effective decision of the court?
Page 14. Page 14. Page 14, my lord. From the rival contentions?
Yes.
My lord, I'll just place this part first.
Please.
From the rival contention of the... Sorry, my lord.
Yes.
From the rival contention of the parties, specifically the submission made by the defendant number 2, one thing is clear, that there is a tribal issue which requires intervention of the court to taking resort to various provisions of law to administer justice regarding the... Now, lordship will kindly see, my lord, the learned trial court assumes, my lord, that the deed to be purported.
No comments, Mr. Jain, please read on.
Sorry.
Make your comments later.
Sorry. Regarding the purported deed of partition and settlement dated so-and-so. Prima facie, there is no confusion that regarding existence of Vishwanath Ganeriwala HUF, plaintiff and all the contesting defendants except defendant number 2 have unanimous understanding that the said HUF has not been dissolved as yet, nor any such partition deed as contemplated by defendant number 2 had ever been acted upon. the defendants have been able to refer to various documents from where the very existence of Vishwanath Ganeriwala HUF till the very recent time can well be presumed. Be it the admission of the defendant number 2 in various legal proceedings, be it the action taken by the said defendant in respect of Vishwanath Ganeriwala HUF as its karta, be it the legal proceeding initiated by defendant number 2 in the name of HUF before several institutions claiming his status as karta thereof. On the one hand, defendant number 2 is submitting that he is the karta of Messrs. Pradeep Kumar Ganeriwala HUF and such capacity is carrying on business activities. On the other hand, he is claiming that he is also karta of Messrs. Vishwanath Ganeriwala HUF, which according to him stood dissolved with the execution of partition deed of 2008. Defendant number 2 has stated that after death of Vishwanath Ganeriwala, defendant number 2 being the eldest male member of the as per the desire of Vishwanath Ganeriwala, became the karta of Messrs. Vishwanath Ganeriwala HUF. He and defendant number 3, being the two named executors to the will of late Vishwanath Ganeriwala, dated so-and-so, applied for probate of the aforesaid will, dated so-and-so, before the learned district delegate at Alipur, with case number so-and-so, and the learned district delegate granted probate of the aforesaid will by an order dated so-and-so. Vishwanath Ganeriwala, since deceased, for self and or as karta of Mrs. Vishwanath Ganeriwala HUF during. Lordship may skip this part, my lord. Lordship, if Lordship kindly takes last 5 lines of this page of page 50, last 6 lines back. In this connection, the defendant number 2, my lord. In this connection, the defendant number 2 mentions that the aforesaid sale certificate was never registered. In the meantime, Vishwanath Ganeriwala died on so-and-so, leaving behind the aforesaid will. The defendant number 2, who became the karta of then Vishwanath Ganeriwala HUF, alone was looking after and managing property at Mumbai. The said Vishwanath Ganeriwala having died prior to registration of the aforesaid property at Mumbai, the then co-parceners of the then Mrs. Vishwanath Ganeriwala HUF, sometime on or about, decided and agreed that the aforesaid property at Mumbai should be mutated only in the name of defendant number 2, my lord, and then, my lord, the learned judge, my lord, refers to the various affidavits, my lord, and the order. My lord, there is, my lord, no discussion as to what makes her, my lord, pass this order in derogation, my lord, of order of this honorable court, my lord.
No, Mr. Jain, Vishwanath died before the finalization of that deal.
Yes, yes.
Now, the said Vishwanath Ganeriwala having died prior to registration, the then co-parceners of the then Mrs. Vishwanath Ganeriwala.
Yes, sir.
What does the court get it? From what?
My lord, that was my submission, my lord. I had said, my lord, that this was the understanding between the parties, my lord. That
is that substantiated by any document?
No, my lord.
It's your submission in thin air that the co-parceners agreed.
No, and
otherwise there is a continuity of Vishwanath Ganeriwala HUF.
No,
There is no pause to that. I mean, where does it end? Vishwanath Ganeriwala HUF. Still, that family nucleus, that HUF nucleus is being used. That's their case.
That's their case. No, that is not their case. Well, this case is not about the property. My lord will kindly, lordship will kindly
Yes.
recollect. The prayer, what are the? I will trouble your
All
lordship
right,
with
all
the
right,
relief
very
also.
well. Let us
Because, my
continue.
lord, existence or non-existence of Vishwanath Ganeriwala
HUF, yes.
is not at all subject matter of the suit.
What have they challenged?
They have challenged the partition deed and the declaration. That is all.
On the ground?
Saying that I was a major, I am shown minor.
Only that, or
That
they have
is-
also pleaded that Vishwanath Ganeriwala HUF nucleus was used in this.
Lord will kindly see the.
We'll come to that. Let us finish this. Yes.
Well, that is what I am saying. Well, existence or non-existence of Vishwanath Ganeriwala is not at all a part of subject matter of the suit, my lord.
Very well. Let us continue. Yes. How does the court deal with it? Let
Yes.
us-
My lord, page 16, if lordship runs over.
Yes.
Should be mutated only in the name of defendant number 2 in presence of the same. Lordship may skip this, my lord. This is
Yes,
again
yes,
the
yes.
iteration
Submissions
of
are
this.
again narrated.
My lord. Then lordship will kindly turn to page 17, my lord.
Yes.
17, 18, 19, 3 pages, my lord, possibly.
Right,
those are
right, right, right.
The above submissions made
Yes,
by
yes.
defendant. The above submissions made by defendant number 2 categorically in his written objection clearly demonstrates that not only Bombay property but also various other properties of Vishwanath Ganeriwala HUF remain the joint property of Vishwanath Ganeriwala HUF till the alleged deed of partition was executed in the year 2008. But even after execution of the said deed of partition, which defendant number 2 still believes to have been properly executed and acted upon, why the defendant number 2 as karta of Vishwanath Ganeriwala HUF went on to take various decisions and actions in the name of Vishwanath Ganeriwala HUF in respect of property covered under the said partition deed could not be explained convincingly by the defendant number 2. The existence of Vishwanath Ganeriwala HUF at the insistence of defendant number 2 can be ascertained from various documents, including, my lord, these documents she is referring to, my lord, what my learned friend possibly is trying to file now, my lord. Can be.
You are not also disputing existence of that HUF.
No,
Are
my
you
lord,
disputing?
no, my lord, I am.
You are not.
No, no, my lord, my case is, my lord, there are existence of two HUFs and
Yes.
both HUFs are mine.
So the
Vishwanath,
court only finds from these income tax returns and other things that Vishwanath Ganeriwala HUF still exists.
yes, even I am saying it exists. But my lord, I am saying, my lord, that it exists only with regard to my branch of family, not to the, my lord, my father's branch of family.
So therefore, these documents, reliance of the court on these documents, nothing hinges on that.
It doesn't. But these
The court only
documents form
says
part of our, my lord, judicious process, the adjudicating process.
yes,
my lord.
but you are admitting the court only came to a finding on the basis of these income tax return and other documents that Vishwanath Ganeriwala HUF still
My
continue.
lord, for argument's sake, my lord, it is my case also, my lord. Not even for a moment, my lord, I am saying that Vishwanath Ganeriwala is not there. But
So what is the harm if the court looked into these documents? I mean,
my lord,
it came to the purpose of looking into those documents is only to hold that Vishwanath Ganeriwala HUF is still continuing.
my lord, only my lord, my where it the shoe is pinching, my lord, is that
Yes.
by looking into these documents and by coming at this findings, my lord, what she has done, my lord, she has expanded the scope of the suit. My lord, can she have done that? Lordship, an interlocutory application and relief claim therein, my lord, has got to be in aid of the suit, my lord, the plaint, reliefs of the plaint. My lord, can it travel? Lordship, I put a question to myself. Can my relief in an interlocutory application travel beyond, my lord, the ultimate?
You say their sole case was that a major was represented by somebody.
I will just place the.
That is the sole case, sole ground.
That is the sole ground.
Well, let us continue, finish this, and then we'll go to
The existence of Vishwanath Ganeriwala, sorry, filed income tax return. Lastly, in 2016-17, issued rent receipts of to the lessee in the name of HUF, filed assets of the HUF, which covers allegedly partitioned and allotted property of Mumbai, etc. My lord, I do not know from where she gets. My lord, there is not a single document. This is her finding. Lordship can take it from me. My lord, there is not a single document. Cannot be and could not have been. Some emails referred to by the defendant show that the defendant number 2 not only assured the co-parceners that he had not taken any steps to the detriment of the interest of the other co-parceners, but also assured that he would not create any third-party interest in the said HUF property without their consent. Even the defendant tried to convince other co-parceners of the HUF to come to a mutual settlement and understanding regarding the joint property of the HUF, namely Vishwanath Ganeriwala HUF. Now, my lord, admittedly, my lord, there is nothing admitted. Admittedly, some movable properties, that is various bank accounts, still stands in the name of Vishwanath Ganeriwala HUF, which defendant number 2 claims to be his own account. To save those joint properties being misused or misappropriated, plaintiff has prayed for injunction against those. Lordship will kindly mark this once. And Lordship will kindly compare this with the relief of the plaintiff. In the circumstances, a question reasonably comes in the mind of the court. If defendant number 2 was of the belief that the deed of partition has been successfully executed and acted upon, then why he himself, representing himself as a Karta of the said dissolved Vishwanath Ganeriwala HUF, is taking several actions, leaving an impression that Vishwanath Ganeriwala HUF still exists and that he was the Karta of the said HUF. It means, like other defendants, defendant number 2 also has a doubt regarding the partition deed.
this is the impugned partition deed. Very well, yes.
And its binding effect upon all the co-parceners. Here comes the necessary to try all the issues raised by the parties by taking evidence. There's only one party who has raised issue, because nobody else has filed any written statement or written objection subject to correction. Record and restrain all the defendants. Now, my lord, lordships, my lord, posed a question, my lord, section 80, lordships possibly will not consider. My lord, all the defendants, my lord, this is where, my lord, I join issue, my lord, that section 80 comes into play here, my lord, because even the
section 80
of CPC, my lord.
Why?
Because, my lord, government is a party. Even
I see.
So, even government has been restrained. Record and restrain all the defendants and their men and agents from relying upon the said purported deed of partition and settlement dated 2nd of December 2008 and the deed of declaration dated so-and-so till the suit is decreed finally. To save the suit, now Lordship will kindly mark this, to save the suit property from being dealt with in adverse to the interest of the parties by an order of injunction necessary. It is the submission of the defendant number 2 that the plaintiff deliberately has suppressed. Now, Lordship will kindly take see, my lord, as to how the learned court deals with my objection with regard to, my lord, order passed by this honorable court. It is the submission of the defendant number 2 that the plaintiff deliberately has suppressed the fact that the defendant number 2 had instituted a writ petition being number so and so before the Honorable High Court at Calcutta, wherein the plaintiff was respondent number 12, and the Honorable High Court, while disposing of the aforesaid writ petition, granted liberty to this defendant to file a suit before a competent court of law to seek remedy, as was prayed for by the defendant number 2 in the said writ petition. The ex parte interim order of injunction granted by this court is in direct contradiction to the order passed by the Honorable High Court in the writ petition so and so. Video order dated so and so, the Honorable High Court was pleased to direct the writ petitioner, I defendant number 2, herein to approach any competent civil court, including the court where the suits are pending, to seek appropriate remedy, both with regard to getting the original partition deed from the appropriate registering authority, as well as for raising other disputes regarding non-return of the same from the said authority. Learned advocate for the defendant, though has stated that the ad interim injunction passed by this court is in contradiction of the order passed by the Honorable Court, but has failed to explain why things fail. You know, the orders are there, my lord. I am saying, my lord, that order would.
The order granted you liberty to file a suit.
My lord, now in view of this, lordship, this after this injunction, my lord, I cannot file a suit because, lordship, all parties have been injuncted even from relying on. My lord, what will I, my lord, even if I file a suit, my lord, what will I achieve, my lord? Lordship will kindly appreciate that.
That's in aid of the suit. Why is it in contradiction of the High Court's?
My lord, because today, my lord,
High Court grants you a leave to file a civil suit.
Civil suit, my lord.
That does not mean that the High Court says that the civil suit, if you file it, would be maintainable in law otherwise also. You may file it in a wrong jurisdiction. Suit may be held by the trial court. It's entirely the discretion of the trial court.
Definitely, I may lose my suit. My suit may
You
be
may lose your
dismissed
suit, definitely.
at a threshold. Maybe they may come up with an order 7 to
Yes,
dismissed.
absolutely.
But my lord, today, in view of this order which has been passed, my lord, even the government authority, the additional district sub-registrar.
It's not a question of the High Court's order being violated. It may be a question of Section 41A of the Specific Relief Act being violated. At most. At the most.
My lord, it was my submission. My lord, it may have been a wrong.
That's a very well.
My submission was, my lord, that it would be in teeth of the order passed by this honorable court. That was my submission, my lord. But she said that I have not been able to explain. My explanation may be wrong, my lord.
We grant you a leave to file a suit. Today, in a different suit, a court injuncts you from doing something which is not in violation of Section 41A, supposing. Court can always do that.
My lord, but
all liberty that does not mean
court
anything.
Cannot, my lord, I have given my explanation. Court cannot say I have failed to explain. Court may say it is not convincing. Court, my lord, my submission was, my lord, that it is in teeth of the order. Court could have said, could have brushed aside my lord submission.
Section 16 is quoted then.
Then Section 16, lordship can skip that. If lordship kindly turns over to the next page. If a suit is filed for relief or compensation, for lordship may skip that.
Part of the property is located. Was that the premise of the court? A part of the property is located inside. Because Mumbai is a part of the conglomerate of properties which is the subject matter of the suit. And if this court, the court where it was filed, at least a part of the suit property is within that jurisdiction.
Lordship will kindly see the schedule. I will take it. Now I will trouble your lordship will.
You place that schedule also.
I will see.
Everything is outside.
Everything
but the bank accounts?
Everything is outside.
Bank accounts after this core banking concept, you cannot say it's beyond the jurisdiction.
My lord, the address is mentioned, branch is mentioned. Branch is MG Road, RN Mukherjee Road.
Now today I can withdraw an amount lying in my bank in Mumbai. Definitely. And vice versa.
My lord, then there has to
so
be
how
some
can you?
My lord, at least that some pleading has to
then
be
part of the jurisdiction is within this court.
Within the subject to my lord, then everything and anything under the sky, my lord, will be jurisdiction.
Not under the sky, but under a bank.
My lord, because invariably everyone will be having a bank account, my lord. Nowadays, even my lord, the rickshaw.
If the jurisdiction, if the dispute, rickshaws don't.
They do have, my lord.
Yes, if you have a bank account, if the corpus of the subject matter of the suit is the bank account,
my lord, then whether that is the subject matter of the suit, lordship, subject matter of the suit has to be determined from the press, the relief.
Absolutely.
Now, my lord, I will lordship has seen now.
So let us complete this and go to the release quickly.
Yes.
So that your arguments are over. Yes.
Just before ordered portion, my lord, upon cumulative consideration of the documents so filed on record by the parties. Now, my lord will kindly, what she's, my lord, considering the documents, my lord, filed by.
No, you read the first paragraph also, Mr. Jain.
If a suit is filed. Sorry.
Yes, yes.
If a suit is filed for relief or compensation for a wrongful act to immovable property, and it can be effectively obtained through the defendant's presence, it may be filed in a court within the local jurisdiction when the property is located or where the defendants reside. So, my lord, this is the justification, my lord, of the learned court of, my lord, assuming jurisdiction. She assumes that since the defendants are within, carries on business or earns livelihood. This is based on the principle of equity acts in personam. which means that equity applies to a person rather than to property. In such view of the provisions of law, prima facie, this court is found to have sufficient territorial jurisdiction to try the suit, my lord, because defendants are within it. Though determination of limitation to file the instant proceeding in the present suit appears to be mixed question of fact, my lord, lordship, limitation, my lord, even my lord, I given, my lord, limitation is always, my lord, mixed question of law and fact. Upon cumulative consideration of the documents so filed on record by the parties and from the submission made by them, I have not found any reason to interfere with the ad interim order of injunction passed on 12th of September 2024. In view of above, it is ordered that the defendants and their men and agents, servants and or assigns are hereby restrained from relying upon deed of partition and settlement dated 2nd of December 2008 and deed of declaration dated 1st of June 2009 and or parting with possession or in any way encumbering, removing and or disposing of Schedule A, B and C property in favor of any third party or parties in any manner whatsoever till disposal. Now, Lordship, just pausing here for a moment before I trouble. Lordship, she does not, the learned trial court does not say, my lord, as to what makes her think, my lord, that when this honorable court, another coordinate bench of this honorable court, my lord, gave me permission, my lord, to get the Mumbai property mutated in my name, my lord, as way back in the year 2009. My lord, how, my lord, under what premise, my lord, she, my lord, comes to a conclusion, my lord, that the partition or, my lord, the understanding arrived at between the parties, my lord.
But Mr. Jain, the writ court could not have decided the title of the parties.
No, not writ court.
Or
No,
the validity of the document.
No, that was not, my lord, what had happened. My lord, lordship knows, my lord,
Suppose you, in a writ petition, you get an order of this court, yes, you are permitted to mute it. That does not mean that your right to mute it, your title to the property, or anything has been decided conclusively.
Lordships will recollect, my lord, what was the order in the accordance with law after giving opportunity to all concerned.
True.
So, my lord, everybody had an opportunity. If anybody had a, my lord, then there will be never ever finality to anything, my lord. My lord, today I will approach your lordship, my lord. I will say something after me. My son will come. He will say, my lord, my lord, agitate it. And thereafter, if I have a grandchild. So, my lord, this will come. My lord, there has to be a finality to some decision, my lord. So, she does not, my lord, try to distinguish as to why or what made her, my lord, pass this order, my lord, which, in my respectful submission, is in violation of order of this honorable court, my lord, of 1999, my lord. 1st of March 1999. One, my lord, I produced a document, my lord, a registered indenture in my favor, Mumbai property, in the favor of my lord Pradeep Kumar Ganeriwala HUF. She does not deal with that. There is a document, a registered document, which, my lord, I have shown. My lord, if somebody has any, my lord, like today, my lord, the plaintiff, who's the respondent number 1, today he is having a grievance, my lord, he is trying to challenge a deed. Nothing prevents him or anyone, if somebody wants to challenge the deed wherever they can. Till the time, my lord, that registered instrument is there, the property is registered in my name, in the name of my HUF. I have shown it to her. The documents are.
What is your answer to that major person being represented by somebody?
That only his father, because I did not represent him, my lord.
Whoever, but then that deed could not have been a valid partition deed between all the co-personers.
Subject to correction, my lord, it can only be if anybody can challenge, it is only him. But then, my lord, what about first of all the persons who have signed, who were majors? My lord, it is still binding on them.
Acha, the person who was represented, he is not a plaintiff.
No.
He's a defendant here.
He is a defendant.
Now, subsequently, he's supporting.
Now he's supporting. So, my lord, if at all, if any fraud is, and my lord, it is not a case of a minor being shown and his property being sold, my lord. Then I could have understood, my lord, Guardians and Wards Act, and my lord.
That's a different proportion.
My lord, he was, and my lord, it is not.
But this is more serious. I am a major. I am shown as a minor, somebody else, even if my father signs for me.
My lord.
I mean, that is also illegal. I mean,
my lord, possibly. My lord, I cannot.
At least I was not properly represented there.
When, my lord? When? Lordship will kindly see.
Whenever I was the major.
And lordship, and my lord, what he has said, lordship will kindly see.
Let us see this really.
No, one more paragraph, my lord, I will show to show that he was aware about the existence of 2009 deed in his affidavit in reply.
Ever when? Became ever when?
He says that it was given a go by. So means from 2009, that's his pleading. If my lord kindly, his affidavit in reply starts at page 520 of this volume only, my lord. If my lord kindly turns, I will just trouble your lordship.
Yes.
520 is his affidavit in reply.
This was the person who was allegedly represented by his guardian.
He's the plaintiff. He's the plaintiff.
No, this is the plaintiff.
Yes, yes.
It's
Rohan Ganeriwala, my lord.
no, the person who was represented by as a minor.
This Rohan Ganeriwala, who's the respondent number 1 here. His father, Dilip Kumar Ganeriwala.
So then the plaintiff himself challenges.
Yes,
What are you saying that he has not challenged somebody else?
What he says about the.
You just now said, Mr. Jain, that he himself does not come up and say. He is a defendant and he is supporting the case of the plaintiff.
His father, my lord. I said, my lord, if fraud at all has been committed.
He is the affected party.
Correct. So, my lord, his father.
The plaintiff himself, he was impersonated. I mean, he was shown as a minor.
Major. Sorry.
Minor.
Correct.
Then he is the worst affected party.
Yes,
The
yes,
plaintiff
yes,
has full locus standi.
No, my lord, what I'm trying to show from his affidavit in reply is, my lord, that he was aware of existence of this document from the year 2009. That is I'm trying to say. Now in 2024,
What is the cause of action he's showing now?
Now he's saying that partition suit filed by my other brother. He says that after that, my lord, he has come to know this. That's what he says. But here in his affidavit in reply,
Where does he admit that he knew?
My lord will kindly turn to page 546. 546.
Yes.
Last 3 lines, my lord. In this regard, my lord, this is, my lord, with regard to deed of partition.
That partition.
Yes. In this regard, I say that the purported deed of partition and settlement dated December 2, 2008 was kept pending and incomplete. So, my lord, he knew, my lord, that it was kept pending.
He might have known later also.
He does not say so. Here, let's see.
He doesn't say so means this is not an admission.
My lord will kindly.
Admission has to be clear, unambiguous. He has to say that I knew all along, or from this and this date.
No, that he doesn't.
He might have come to know later, was kept pending and incomplete because
of executing co-parceners of the said document, decided not to give any effect to the same, and I chose to repeat and reiterate this.
He comes now, and after knowing, he now says that it was kept pending only because they chose not to.
One more document, my.
This does not indicate that there is an admission on his part that he knew all along. This is not sufficient.
No. His own admission, my lord. If my lord kindly takes his own admission, page 396, my lord. His own admission. Third volume, which he suppressed. Lordship will recollect. In his plaint, he suppressed.
Page 300?
396, my lord. Third volume, my lord.
Yes.
My lord, this is plaintiff, respondent number 1, writing to the Office of Additional District Sub-Registrar. Lordship will kindly see 6th of July 2023. This is to, I'll just place this slide. This is to bring to your immediate and urgent attention that Lordship will kindly mark this, that I am one of the signatories to the above mentioned deed.
You have already marked and circled.
So Lordship said.
You placed it twice.
Once, my lord. Once, my lord. So my lord, he and lordship, this my lord, he suppressed, my lord, in his plaint, he suppresses this letter. When in my written objection, I file this, my lord, by way of my written.
He's speaking about the partition where he was mentioned to be a minor and his father's sign.
Correct. But then
he was not a signatory there.
But he says I am a signatory, so he is aware. So he was all throughout aware. My lord, lordship will kindly. My lord will kindly. My lord, it's very easy, my lord, for a person, my lord, today. He's definitely not a signatory. I agree, my lord, because it's a fact that he did not sign, his father signed. But my lord, this only goes to show that he was aware all throughout. My lord has just now posed a question that
he was aware of what?
That the existence of that deed.
When did he become aware? What is the admission on that?
My lord, his admission itself that I am one of the signatories of the deed. My lord, in my respectful submission, lord, this is his admission.
That he was a signatory. Although your case is that he did not sign.
Not his own case.
Your case is also that you are relying on that partition deed. That partition deed does not contain his signature.
My lord,
this admission, even if it,
my lord,
we understand what he meant to say. He obviously meant to say that he was shown to be represented. But he said, I am one of the signatories to the government.
My lord, he said that has been
compromised. The deed shows that he is not one of the signatories. So that the admission, it should go to the trash can as an admission.
Lordship will discard that. But my lord, what he says, he says it has been compromised, manipulated, interpolated, and he asked the registering authority not to complete the registration process. My lord, so that was, my lord, and he suppressed that in his plaint.
But he does not, you have a point here, he does not categorically say that I being a minor at that point of time was.
My lord, that is what I was
That
trying
is
to.
not, that is not.
That is not there. That is what.
It's not an admission.
My lord,
Now-
my lord, everybody does not write good English like Mr. Choi. That's
My lord, my English is so pathetic, my lord, at times.
that we know.
Yes.
No, my lord, I will trouble your lordship with the reliefs of the plaint. My lordship, kindly take the first volume.
Yes.
Plaint starts at page 67.
We are interested in where it ends.
Prayer starts at page 82, my lord.
Maybe.
Before-
82, right?
82, my lord. Now, my lord, a decree of declaration that the said purported deed of partition and settlement dated 2nd December, a copy whereof is annexed hereto and marked F, is void or voidable and be directed to be delivered of and cancelled. My lord.
This is the relief sought. He gets an injunction in aid of this because the partition deed has been, the injunction is that you cannot give effect to the partition deed. So why do you say the injunction is not in aid of the main relief?
Because none of the properties is part of the partition deed. None of the properties is part of the partition deed. I will show that. And in fact, lordships will recollect when last occasion when my lord I had placed the partition deed, even lordships possibly my lord agreed. my lord.
So the injunction order was granted. We'll just see that again. Granted in respect to the suit property or
Yes, suit
just the
property.
party? Let us once again revisit that
Sorry.
ordering portion. Yes. Disposing of ABC property.
ABC. Schedule
So not only not giving effect to the partition deed, but also regarding the suit property.
Now, lordship, prayer A. my
So
lord.
therefore, you say none of the properties are part of the partition deed.
None. I will just show you.
And partition deed enumerated certain properties. There was a schedule to the partition deed.
Yes. There are 7, 8 scheduled, but Mumbai property is not there. Bank accounts are not there.
None of the present.
Demat account is none.
All right.
Now, prayer B. A decree for declaration that the purported deed of declaration dated 1st of June, copy whereof, my lord. What is the basis? Firstly, my lord, I put a question to myself. How the court assumes jurisdiction? This deed of declaration is in respect of property at Mumbai, executed in Kolkata, and affirmed before the learned Metropolitan Magistrate at Kolkata. And none of the signatories are challenged. He is not a signatory to this deed of declaration. C, my lord, prayer C. Perpetual injunction restraining the defendants and particularly the defendant number 2, their respective servants, agents, and or assigns from in any way relying and or taking any step on the basis of purported deed of partition, settlement, and purpose. So again, my lord, it is, my lord, back to my lord, deed of partition and settlement on declaration, my lord. D, my lord, permanent injunction against the defendants and each of them restraining them from circulating, relying upon or disclosing the deed of purported deed of partition, settlement before any court of law. So, my lord, what lordship says, my lord.
41A.
Deed of partition, settlement before any court of law, municipal corporation, or before.
But there are judgments, they must be showing those judgments, Mr. Jain, where it says that if the relief claimed, if the consequential relief is in aid of the primary relief, and if a particular document is challenged, the operation of that can be stayed by the court, or you may be injuncted from giving effect to that. That does not per se tantamount to 41A, because you are not restrained from filing a suit.
It's a,
what you are restrained on, because
I could have
they have made
understood
out a prima facie case that this document is vitiated by some law.
I could have understood, sorry.
You can be restrained from relying on it.
On a temporary basis, my lord, subject to condition.
It has been done on a temporary basis. It's a temporary injunction by definition.
No, this is plaint.
No, the temporary injunction has been granted, which is
Ultimately,
challenged.
my lord, I am saying, my lord, all decree will be passed against me. My lord, I am giving, my lord, let the learned trial court pass a decree against me. Then, my lord, what will be the consequence? Lordship will kindly envisage such a situation. Then what happens? Now,
If the partition deed is set aside by the court, then event D will not be necessary.
It will not.
That
be.
is set aside. You
That is
cannot
that-
rely
then
on
it
it.
will not be. But
So it's a valid consequential relief. They have challenged a partition deed, Mr. Jain. If ultimately the court sets it aside or cancels it or whatever, says it's void, then you cannot rely on it before anywhere.
Anyway, I cannot use it. I
So
can
D is not a non-maintainable relief.
No, I'm not on non-maintainable. My lord, I'm just trying to demonstrate what are the
And on
relief and-
temporary basis, why shouldn't it be granted? I mean, if a partition deed is challenged, a prima facie case is made out, subject to that. Then always the court can grant an injunction. You are submitting repeatedly that you are being restrained from relying on this deed, contrary to the High Court's leave.
No,
in any
no, my
court
lord,
of
no,
law.
I'm no longer submitting that. my
This
lord.
is not Section 41A bar.
That my lord, what I'm trying to demonstrate right now is, my lord, what are the relief, my lord? If lordships are if lordships are to pass decree in this suit, my lord, then what can be the effect and consequence of that lordship? That is what
The suit property, none of the suit properties are
Now,
part of
E,
this.
My lord,
Yes.
the E is the last prayer. Permanent injunction against the defendants, each of them restraining them from recovering and or trying to recover the said purported deed of part. Lordship will kindly mark, my lord, curiously, there is not a single prayer with regard to any of the schedule. Lordship has seen A, B, C, D, E, and then F, G, H, I, J. Not a single prayer in suit, my lord. Lordship sees Schedule A, outside. Schedule B, all outside. If my lord kindly takes
Yes.
page 85, lordship, my lordship just now, lordship, it fell
85.
from my lordship, my lord, that bank account today, my lord, in
And not only that, if the bank account, I mean,
MG Road, R.N. Mukherjee, he has given the branch, my lord. So we'll see. And Schedule C, all demat account with Baljit Securities, my lord. Of course, my lord, the address is not there, but my lord, lordship can take it from me, my lord. The office of Baljit Securities is outside the jurisdiction of London Trial Court. आपने तुल्य से सब जगह देते हो भाई.
Yes.
Now, Lord, this is the prayer of the suit. And now, Lordship will kindly see the extent of interim order which has been passed or the interlocutory. Lord, what she has done, my lord, the learned trial court, my lord, she has expanded. My lord, lordship, possibly, my lord, I have been able to demonstrate, possibly, my lord, that existence or non-existence of Vishwanath Ganeriwala HUF is not at all a subject matter of the suit. How does she assume, my lord, the things belonging to my lord, today, I take it for, my lord, for argument's sake, my lord, if lordships, if the deed of settlement goes, partition goes, what turns on that? Mumbai property has not come to me through that deed. How can she injunct me from that? And admittedly, my lord, when I have shown, my lord, demonstrated by a registered instrument, first of all, that property belongs to an entity who is not a party to the suit.
Mr. Jain, have they stated anywhere that this is from the joint nucleus of the joint corpus of Vishwanath HUF?
My lord,
that can be the only link. Otherwise, we don't find.
My lord, to be very candid, my lord, I have not come across, and my lord, I will not be able to say that, my lord. But my lord will kindly appreciate one thing, my lord. Lordships have seen the prayer of the suit. My lord, Vishwanath Ganeriwala HUF, my lord, in my respectful submission, is not at all a subject matter. My lord, I gave in, my lord. The partnership deed goes. Now I'll just take your lordship through the deed of partition. Partition settlement, my lord. And lordship will see for your lordships, my lord, own satisfaction, my lord, whether
So that you placed before us.
I placed just, my lord, just for completeness of my lord of my today's argument.
Did not complete. Leave it incomplete. You already shown it. They must be also showing it again, and we will be seeing it at the time of passing judgment. So need not.
So my lord, possibly, my lord, lordship has seen, and my lord will kindly see what kind.
Otherwise, there will be no finality to litigation.
No, my lord. So, my lord, what kind of drastic order has been passed? The learned court, my lord, has proceeded as if she is dealing with a suit, partition suit. Partition suit is not a subject matter of this. My lord, today, my lord, for argument's sake, my lord, if even, my lord, the deed of partition goes, my lord, what will turn around on that? And if, my lord, but since, my lord, I wanted to rely, but since my lords have not permitted.
What?
My lord, the deed of indenture, my lord, where, my lord, my learned friends' clients, my lord, have taken property, my lord. which my lord records about the deed of settlement.
It was not a
Those-
part of the trial court records.
My lord, that's why, my lord.
So we'll be consistent on that.
So, my lord, those properties, my lord, how selective he has been, my lord, I could have understood. My lord, the properties which have gone to them, they are happy with that. None of the properties have been touched.
It has ascertained their happiness. Now you conclude, we will get their happiness.
So, my lord, in my respectful submission, my lord, the impugned order, my lord, is perverse, my lord, and my lord, it travels well beyond, my lord, the reliefs claimed in the plaint, my lord. Cannot be sustained even for a moment, my lord. I humbly beseech your lordships, my lord, to set aside the impugned order, my lord. These are my
Who is for the respondent number 1? Mr. Mithu, you are for the respondent.
Grateful, lordship.
Thank you. Yes.
I was only wondering, my lord, whether I was hearing argument in an appeal from decree or from an appeal in an appeal from order.
Yes.
Adu? I just wanted to rely on one judgment. I'm sorry, my lord.
Cite it, cite it.
Sorry,
Mr.
sorry.
Mithu, take your seat.
Sorry.
Where are you standing? Take your seat. Yes.
Well celebrated judgment, lordships are aware, my lord, 1976 Supreme
Celebrated
Court.
by the parties who get advantage of it. There is no celebrated judgment.
A well followed judgment, sorry. my lord.
There are
Well-
landmark judgments
Landmark judgment and followed judgment, sorry.
celebrated by only people who win.
1976 Supreme Court 807.
Right.
It's the longest judgment, my lord, if lordship takes. Pura.
This is on what proposition?
Lord, about family settlement. If family settlement.
Oh, that. Acha, acha. Kale? Oh,
Kale,
yes.
Kale. Lordships are aware, my lord. So, my lord.
The other day, Kale is being cited because we are taking up these first appeals also.
So, if lordship, it's a longest judgment. Lordship, only 2-3 paragraphs I will cite, my lord. I will not.
Para 10 is the most important. That has been followed in other judgments also.
So, lordships are aware, my lord. I would like to rely on this Kale judgment.
Very well, definitely.
Page 812, 813, and para 19 also, my lord. Paragraph 19 is also.
So give the paragraphs, we'll just record the paragraph. Para 10, obviously.
Yes, ma'am.
And para 19.
My lord, paragraph 6 as well. Para 6, 8, 9. 9, in fact, my lord. 10. 12, 13.
10, in the language of Justice Krishna, probably.
No, this was Justice Sikri's.
This is Justice Sikri.
Justice Sikri,
Yes, following proposition.
Justice Ali. Justice Ali.
Propositions have been crystallized in para 10.
Paragraph 10.
Yes, 10 and what other paragraphs? 6, 8, 9, 10 and?
10. Hello, 12, 12, 13.
Which are the paragraphs we shouldn't look into?
Well, it's the longest judgment, my lord, that's why. My lord, up till 17, my lord. Or in fact, 18. Up till 18. Sorry, my lord. Up till 18. Lordships will kindly look up to paragraph 18.
Thanks.
Grateful, lord. Deep love.
Yes, 8 minutes. Mr. Mithu will take 8 minutes to ascertain whether Mr. Jain has finished. Yes, Mr. Mithu.
My lord, not on merit. One submission was made, my lord, while I was here on earlier occasion.
Yes.
So Jain has possibly, my lord, submitted for maybe 3 days. That, my lord, while the application was taken up for hearing, he had relied on the order sheet. The defendant was, or my lord, the contesting defendant was called upon to answer first or to address first.
Hmm.
My lord, lordships must be aware, Justice Kumar definitely is, my lord, that in most of the, my lord, district courts, when there is an interim order, I never knew this until I personally faced it. If there is an interim order, then the person or the lawyer who is opposing the interim order, he is, my lord, directed to address first.
That also is reflected from the ordering portion, that there is no reason why I should change that.
Now, that's neither here nor there, because ultimately the
parties were heard.
Yes. Now, my lord, kindly take up the petition, my lord. The trial court petition, my lord. Page 45, kindly come. The injunction app.
Yes.
Kindly come to page 47. As far as the plaintiff petitioner is aware, defendant respondent number 4 got married to Sharita Devi Ganariwala since deceased on 17th May 1986. Out of the said wedlock, the defendant respondent number 15 was born on 22nd October 1989 and became co-personer of the said HUF and was adopted by the defendant respondent number 3 and 15 sometimes around 1992. Out of the said wedlock, the plaintiff petitioner was born on 13th March 1988 and became a co-personer of the said HUF. Out of the said wedlock, the defendant respondent number 16 was born on 29th December 1993, also became a co-personer of the said HUF. The birth certificate is annexed. There is no dispute, there cannot be any dispute about this fact. Then, my lord, kindly come to paragraph 12.
Yes.
In the year 1986, the said Vishwanath Ganariwala, since deceased, purchased a property being a bungalow at premises number R154 Juhutara Road, bearing such and such CTS number, hereinafter referred to as the said Mumbai property in the name of the said HUF, and as such the said Mumbai property formed part of the common hodgepodge of the said HUF. Full particulars of the said property would appear from a schedule, my lord. This has been, I shall show you, Lord, my lord, if your lordship is pleased to come to the affidavit in opposition once, my lord. Kindly come to the third volume, page 321.
Yes.
321.
Yes.
Save and accept whatever matters of record, etc. It is denied that in the year 1986, late Vishwanath Ganariwala purchased a property being bungalow at premises number R154 Juhutara Road in the name of the said HUF, or the said Mumbai property formed part of common hodgepodge of the said HUF as falsely alleged or at all. And the defendant number 2 puts the deponent to strict proof thereof. The defendant number 2 states and submits that late Vishwanath Ganariwala during his lifetime had created an interest in a bungalow at premises number R154 Juhu Beach at Mumbai. Vishwanath Ganariwala, since deceased, for self and or as Karta of Messrs. Vishwanath Ganariwala HUF, during his lifetime had participated in an auction proceeding conducted by Honorable High Court at Calcutta in connection with matter number such and such for purchase of the property being a bungalow at premises number R154 Juhu Beach at Mumbai. The Honorable High Court at Calcutta, by an order dated 8th August 1986, passed in matter number such and such, was pleased to accept the offer of late Vishwanath Ganariwala and confirm the sale in his favor. The Commissioner Sanchoita Investment, who was appointed as Commissioner in respect of the properties of Sanchoita Investment by an order of the Honorable Supreme Court in furtherance of the order dated 8th August 1986, passed by Honorable Division Bench, issued a sale certificate in favor of Vishwanath Ganeriwala HUF. The said Vishwanath Ganeriwala was then Karta of Vishwanath Ganeriwala HUF. In this connection, it will not be out of place to mention that the aforesaid sale certificate was never registered. In the meantime, Vishwanath Ganeriwala died on 3rd August 1994, leaving behind the aforesaid will and testament. The defendant number 2, who became a Karta of the then Vishwanath Ganeriwala HUF, alone was looking after and managing the aforesaid property at Mumbai. The said Vishwanath Ganeriwala, having died prior to registration of the aforesaid property at Mumbai, the then co-personers of the then Vishwanath Ganeriwala HUF, sometimes on or about 1998, decided and agreed that the aforesaid property at Mumbai should be mutated only in the name of the defendant number 2. In pursuance of the same, the defendant number 1 and 326 affirmed an affidavit before the Notary Public at Calcutta on 18th August 1998, which affidavit was filed before the Honorable High Court at Calcutta in GA number such and such, by which the deponent of the said affidavit inter alia declared that they had no objection and gave consent for mutation of the aforesaid property at Mumbai in the name of the defendant number 2. Only mutation. The Honorable Division Bench of the Honorable High Court at Calcutta inter alia, taking into consideration the aforesaid affidavit by an order dated 1st March 1999, was pleased to direct inter alia the Municipal Authority of Mumbai to give effect to the sale certificate issued by Sanchoita Commissioner and to make necessary mutation of the aforesaid property at Mumbai in the name of the defendant number 2. In accordance with law, after giving an opportunity of hearing to all interested parties, the defendant number 2 thereafter tried to get the aforesaid property at Mumbai mutated in his name and or in the name of his Hindu undivided family in the records of the concerned municipal authority. However, the municipal authority refused to mutate the property in the name of the Hindu undivided family of the defendant number 2 and or delayed, stating that there was no registered instrument existing or subsisting in favor of the defendant number 2 or his Hindu undivided family, which conferred the title of the aforesaid property on the defendant number 2 or his HUF. The defendant number 2, the defendants number 1 and 326 and defendants number 23 and 24 in the meantime amicably and mutually decided to dissolve Vishwanath Ganeriwala HUF and partition, divide, demarcate, allocate and distribute all the properties and or assets left behind by late Vishwanath Ganeriwala, which formed part of Vishwanath Ganeriwala HUF, so as to avoid any dispute and or acrimony between the family members in future, and also to enable the parties own and possess the properties individually in terms of the settlement and or partition, and or to execute and to the exclusion of the others. The defendant number 2 and the defendants number 1 and 326 and the defendants number 23 and 24 accordingly from time to time held discussions and entered into agreements under understanding with regard to the properties forming part of the then Vishwanath Ganeriwala HUF. Pursuant to such agreements and or understandings, some of the properties of the then Vishwanath Ganeriwala HUF stood conveyed, transferred, assigned, and assured to the respective allotments. Then sometimes in or about November, December 2008, the defendants number 1 to 6, defendants number 23 and 24 and others arrived at a final family settlement arrangement in respect of the remaining properties and assets of late Vishwanath Ganeriwala under his Hindu undivided family being Vishwanath Ganeriwala HUF. In furtherance of such family settlement arrangement, the defendants number 1 to 6, defendants number 23 and 24 and others entered into a deed of partition and settlement dated 2nd December 2008, pursuant to which the then Vishwanath Ganeriwala HUF stood dissolved and ceased to exist, and all the properties and assets of the then Vishwanath Ganeriwala HUF stood partitioned, divided, demarcated, distributed, and allocated to the respective allottees. The aforesaid deed of partition and settlement was presented for his registration in the office of defendant number 25, who after accepting the same was pleased to issue a receipt.
Mr. Mittal, continue from here on next.
It's not tomorrow morning, my lord. I presume, because tomorrow, my lord, is the parted matter.
Oh, yes, yes. Tomorrow the part it is. So,
I think it's the day after no, কালকে সকালে একটু আছে।
hard in part. For further hearing tomorrow, it will appear in tomorrow's list, but we'll take up the other part of it.